that the defense worked hard to bring out during lots of different witnesses' testimony in this case really helped the self-defense arguments, because the defense is saying, look, this was a dangerous, rapidly evolving, chaotic circumstance, and that Kyle Rittenhouse made the decision to fire on each occasion that he fired his weapon based on the need to protect himself. And the prosecution has really done what they can to try to minimize the chaos and paint this as a picture where people just came to the town to walk through it and peacefully protest, which is a very different presentation of what's happening. And the very fact that these jurors lived in the town where this took place and may recall independently the damage and the chaos for themselves may lean in favor of the defense, in my opinion.
One of the fixtures in the courtroom throughout has been the mother. Wendy Rittenhouse, the mother of the defendant, has been there every day. She has broke down and wept on several occasions, but most notably when her son was on the stand, when he broke down, she was right there with him. Obviously noticeable. The jury has to know she is there. She talked to NBC News over the weekend and said basically she's worried. Take a listen.
A lot of people shouldn't have been there, you know, and he brought that gun for protection. And to this day, if he didn't have that gun, my son would have been dead.
Are you anticipating, looking forward to, dreading the verdict? How would you describe what your feelings are going into this week?
I'm scared.
That's Wendy Rittenhouse with Gabe Gutierrez of NBC News over the weekend. Yeah, she's scared. I'm sure 18-year-old is scared as well. CK, what do you tell clients when they're in this situation at the 11th hour here, when literally their life is on the line?
First, I tell them they need to pray. Because when their life is on the line, as is the case with Kyle Rittenhouse, we may have a difference of opinion or view as to whether or not he should be convicted or acquitted, but his life is on the line. A lot is at stake.
Proposal, or draft number 3 of the instructions to the attorneys this morning, and we'll make a record now on. Oh, would you get this on my printer, please?
Hey, Judge, this was.
All right. Has everybody received a copy of draft number 3 of the proposed instructions?
Yes. Yes, Your Honor.
And state objections, requests?
Judge, we have no objection. I know the defense has asked that the self-defense instruction be read with every count which is applicable. If they're asking for that out of an abundance of caution, we would agree with that request.
All right, what about that?
Well, Judge, we've had, we've all talked about things off the record in terms of our jury conference. I was under the impression that that was a requirement. I understand we're trying to streamline it. We're trying to instructions. I think that is, and if I'm wrong, I'm wrong, but I think that is what the law requires.
I inquired on the message last night. Is anybody familiar with authority on this subject that requires that? That makes. I guess I'll argue with you, and then I'll hear the rest of what you have to say. You know, attention span, as you know, you speak to juries all the time, and when you start repeating yourself, you lose your audience mighty fast. They've got a lot to hear today from me and from you lawyers. And if I am reading the self-defense instructions 5 times, I would expect to lose the audience rather rapidly. And this is so typical of lawyers. We're hidebound. We've always done it this way. And I will tell you that for years I have taken out common elements of things and put them in separate areas of the instructions. And once they learn what the term intent to kill means, I don't have to define it every single time it comes up. And I've never gotten, even to my knowledge, there hasn't even been an appeal on it. My job here is to communicate with the jury so that they understand what the law provides, and I think that can be done better, briefly and concisely, than by repeating the same old stuff over and over again. But given the position of the parties, if that's your position, we'll do it. But to me, it's a monumental waste of time, and it may end up having a negative effect. But I'm not going to mess around with a case of this magnitude over 2 days or 2 weeks to try. So if you think that risks everything to proceed as I've suggested, then we'll go with the long forms every time. I'm gonna have to count on you to make timely objection if you feel that I'm leaving something out on a particular count, because I've prepared it in the 36 pages of instructions. I've prepared them using a brief form without, there's already plenty of repeating going on. But if I have to do longer, you're going to have to object if you think I'm missing something, or it's going to be a waiver, just so you're forewarned. You have to make a contemporaneous objection. Is that clear?
It is, sir. And
All
the
right.
only one that you don't have it in that we had talked about a little bit was count 5. You had, there's a lesser included offense of recklessly endangering safety.
Oh, yeah, I'm sorry. On that one, I do think that, no, I didn't put it in there, although it does in the final sentence. It says they have to be satisfied beyond a reasonable doubt of that the defendant was not acting lawfully in self-defense. But I'll try to squeeze the content in there as well. And I guess I'm not sure that I agree with your statement that, well, let's take a look at it. And of course, the state wants me, if I read the self-defense portions in, then they want me to repeat every time retreat and provocation, which you have opposed.
They don't.
So they're going to hear that again. What?
They don't want that anymore.
They don't want it anymore?
I'm going to withdraw that request simply because of time.
Okay. I think I'll go back to bed. Okay. But in counts 2 and 3, I gave special instruction only with respect to Mr. McGinnis, because the law is different with respect to him. And we'll get to that.
Okay, very good.
But I didn't reread it with respect to the account involving Mr. Jumpsuit Man.
Grosskreutz is the one that I think is where, so you've done attempted first degree with self-defense, attempted second degree with self-defense. But the way that I read it, and if I'm reading it wrong, I know the court will correct me, on page 27 of the final instructions, it simply says, here are the elements. I didn't see self-defense mentioned
You're right.
in there.
You're right. Because as I did, now, let me say, on counts, the attempt murder and the murder, on those, that's the pattern instruction. If I had my way, I think that's overly verbose, and we didn't used to do it that way, and then they came up with this, and I follow it, but I think it could be better stated, but I follow the guidance of the instruction committee because there's more of them than there is me, and they're very bright people. But and then on count 3, I gave a special instruction because of the situation with Mr. McGinnis, but I didn't on count 2 or count 5 because I relied upon the general principles of self-defense on which I instructed them. So if you want me to do it on 5, I need to do it on 2 too. When they've just, that's 2 also. And that's right after they've just heard it. So, all right.
Well, my only concern is that the instruction makes it clear that self-defense is an issue for first-degree attempt and second-degree attempt. I don't know if a right.
And
so
that's because that's from the pattern instruction. I understand you're thinking, well, because I didn't discuss it in the portion on reckless endangerment, that they're going to think it's not part of it. But the last sentence tells them, and if you are satisfied beyond a reasonable doubt that the defendant's conduct was not privileged under the law of self-defense, you should find the defendant guilty.
Did you see that under the recklessly endangering safety one, Your Honor? Is that what I'm just making? Is that what you're telling me?
That's on the that's on. Excuse me, I'm reading the 4th count here. Let's see. Let's have a look at what I said on 5. See, if I had set this up, I would have put a. Well, I'm not going to say what I would have done. You know, you're right. Well, maybe I misunderstood what you wanted. Did you want the whole self-defense instruction discussed again, or just the clause? And if you are not satisfied beyond a reasonable doubt that the defendant, or I should say it, is all 3 elements of the crime of endangering safety of the first degree have been proved, and that the defendant is not privileged under the law of self-defense, you must find the defendant not guilty.
I think that's fine as long as the self.
You don't need the whole.
As long as they're aware that self-defense is an
well,
option.
Yeah, well, you're right. All right, I'm misunderstanding what your email said. So, if you are not satisfied beyond a reasonable doubt well, there's more missing there than that. You know that? There's not the clause about if you are satisfied. All right, so it'll read at page 27, the 4th line will be, if you are satisfied that all 3 elements of the crime of reckless endangerment have been proved, and that the conduct of the defendant was not privileged under the law of self-defense, then you should find the defendant guilty of reckless endangerment of the first degree as charged as submitted. If you are not so satisfied, then you must find the defendant not guilty.
Okay.
Is that satisfactory? Okay. What's next?
I have nothing else on the instructions.
Defense?
So, Judge, this is more for the record. You've already made, I think, preliminarily, you had talked a little bit about the Ritchie McGinnis instruction.
Right.
Which is on page 8 and 9.
Right.
And the position that I had taken was, one of the lines says, but the defendant does not have a privilege of self-defense as to Richard McGinnis. After that, there's discussion about self-defense and what that means. On page 9, there's a sentence that says, if the defendant was acting lawfully in self-defense, his conduct did not create an unreasonable risk to another. I had told you in an email that all the parties were involved in that I thought that there was some incongruence in that in terms of how that reads. I know the court disagrees, but just for the record, I wanted to make sure that that was on there. Because I do think it's confusing. However, I know it's the pattern instruction. I know you took it from the pattern.
Yeah, I'm not even going to argue with you. It is the pattern, and I'm not going to argue with you that it is confusing. But it's an accurate statement of the law. Mr. McGinnis does not have a self-defense status because he's the defendant has no right of self-defense as to any harm he would cause to Mr. McGinnis. And that's what the instruction is telling the jury. But if he was acting lawfully in self-defense with respect to Mr. Rosenbaum, then it kills one of the elements. I think I'm reading that right. It gives him an absolution with respect to the element of what is the precise element? It's
Element number 2.
part of element, yeah. Unreasonable and substantial risk of death. It says then that the jury can't find that. Well, if they can't find that, they can't find one of the elements, so they have to find the defendant not guilty.
Judge, do you think it's appropriate then on page 9 to say if the defendant was acting lawfully in self-defense as it relates to Joseph Rosenbaum?
At what point do you want that put in?
I just think that makes it clearer. I mean,
Where do you want to put in?
Where did you say?
Yeah.
On page 9, it would be right, so there's a subheading determining whether the beliefs were reasonable. I think it's the third or fourth to last sentence says, if the defendant was acting lawfully in self-defense, comma.
Okay, with respect to
to Joseph Rosenbaum.
With respect to Joseph Rosenbaum.
His conduct did not create an unreasonable risk to Richard McGinnis.
Yeah, I'll do that. Any objection?
No.
Okay. Okay, what's next?
Just, Your Honor, that on page, these are small, but on page 34, 2 of the witnesses, you said one of the witnesses had been convicted of a crime. Mr. Grosskreutz had been convicted of a crime, and Mr. Smith had been convicted of a crime for a juvenile adjudication. So I think if you just say multiple witnesses had been, something like that.
Okay. What page is that on?
I'm sorry, 34. And we are asking for the cautionary.
Do you want the word some instead of one?
Or multiple? Yeah, some
Several?
is fine.
How many was it? 2.
That I recall.
There actually were. Well, I don't think you asked Ms. Swart about hers. There was another witness with convictions, but I don't believe the question was asked. So 2.
What was the answer? 2. All right, I'll put down 2 then.
And then there was some conversations regarding a cautionary instruction regarding Mr. Armstrong.
Yeah, and I really struggled with it.
And we had proposed the instruction to the court, which I think we took off of 245 or something like that.
Yeah.
So we are asking, based on his testimony, that the court instruct with that modified 245 instruction as relates to Mr. Armstrong.
Did you want to be heard?
Well, I would stand by what I indicated over the weekend in my email, but I believe that I'm looking up the specific instruction. Say 245?
I think it's
No, it's testimony of accomplices.
Yeah, and that's a good model for it. That was what I had planned on using if I had drafted it myself.
Judge, I just don't think it's necessary. The evidence was received. The points that the defense wanted to get into were made on cross-examination. Giving any kind of instruction on this would essentially be telling the fact finders how to weigh the evidence. I proposed some different wording. You should not base a verdict of guilty upon it alone unless after consideration of all the evidence you are satisfied beyond a reasonable doubt that the defendant is guilty is completely inappropriate. I can understand where it's appropriate if you're talking about accomplices, but certainly not when we're talking about a one picture out of 100 and some odd exhibits. So I don't believe it's appropriate. I don't believe it's necessary. I believe that these arguments about pixels and zooming are specious, that their expert used a very similar software program with zooming, was cropping.
There was no objection then, you see.
I understand. There's no basis for an objection, and they know that.
I don't know that. Maybe they do. I don't know. I can't read their minds.
This is a forensically sound program used by a forensic analyst who's trained. This image was peer-reviewed. If they want to discuss the proprietary algorithms and how an analyst would not know a proprietary algorithm contained in the software that they are using that is an industry standard, they can go ahead and argue that. But to give an instruction that tells the jury essentially to ignore this evidence unless everything else proves it is way too far.
Well, this whole business about, well, I don't want to say the whole business, but the Daubert rule is the product of the abuse of so-called scientific evidence by attorneys. There were companies, pension funds, individuals were bankrupted because of legal decisions that were made on the basis of so-called science, which was later shown to be garbage. So when you come in here and you tell me, well, this is what they rely on, I think that's fine, except when my common sense tells me, well, wait a minute, what's happening here when you get an image that is consistent of I'll say it again, let's say 2,500 pixels, and you blow it up to 25,000 or 250,000, and you don't really know what fills the vacant space, that's a little struggle for me. And this is not being used to decide which camera I'm going to buy or which phone I'm going to buy when I'm at the store. This is being used to decide about whether someone's innocent or guilty of a crime. So that's why I was when the witness answered, he didn't know. And the only reason I left here and I troubled about it. And, in the end, I decided, well, wait a minute, we allow this kind of thing to happen in DWI cases where the officer is asked, well, how does the machine work? I don't know. I just am trained how to operate it. But there is a difference there. That has already passed judicial scrutiny, and this method has been judicially determined to be accurate. Has that been done in this? I don't know. So that was when I was thinking, well, maybe I should give a cautionary instruction. I ultimately, you convinced me in our exchanges that I don't want to be meddling and commenting on the evidence. I will tell you this, assuming that there's conviction, one or more, assuming that other motions don't contaminate the whatever outcome there is, if it comes out at some time that the method used produces unreliable results, this is going to fall like a house of cards. Because you're basing this extremely important segment of the evidence on something that I'm really queasy about. But as I said when I left here Friday, this is the jury's case, it's not mine. And I'm going to let them decide. They have your photographs and your video, and they've got the testimony of the person who's worked with it, who knows a lot more about this stuff than I do. So I've decided to leave it alone. So I'm not going to give an instruction on it, but I've made my record on the high risk that I think it presents for the case. Okay, what's next?
The two last things, Judge, the court had modified a little bit count 6, which was the...
I did.
Okay, so the third element that you have listed there is the dangerous weapon was a rifle that had a barrel length of less than 16 inches or an overall length of less than 26 inches. We have pulled the transcript, talked, and looked at it. Detective Antaramian was asked if this was a short-barreled rifle. He had answered no, he did not believe that it was. That's the only information regarding that.
Was the gun offered as an exhibit?
Yes.
That is evidence.
Correct.
Enough in itself. The jury can measure it.
Okay. Fair enough. I just didn't, the way that I looked at it, there was no other information that a reasonable juror could believe that count 3's been met. So
what are you telling me?
That I'm asking that you take it from them.
They're asking me to dismiss the case for failure to prove.
This is count 6. Judge,
Count 6.
there have been many discussions about this count. I'm not going to rehash everything. The state disagrees with the interpretation the court has established. We do not believe this jury instruction is appropriate. We do not believe that the exception or affirmative defense, or whatever you want to call it, was properly raised. We argued about all that on Friday. I'm not going to rehash it. I believe it should go to the jury, and if the jury believes that it was not proven beyond a reasonable doubt, they can return a verdict on that. But the state has objected all along, or has given its version all along. We stand by that version. I believe that this jury instruction essentially swallows the entire statute. We've gone over that before. So I believe that if they raise an exception, then it should go to the jury. We would like the standard instruction. Clearly, the court's not going to do that.
Well, up to now, the motions were motions to dismiss the complaint. And you filed a very nice brief, which well explained what the law is. And of course, we were dealing with what the complaint stated and whether the complaint stated sufficient facts to bring the case to court. And the court is confined on that kind of a motion to what's in the complaint and whether it meets the law. And as you pointed out, these offensive matters are affirmative defenses, and the DA doesn't have to plead them. So that's why I ultimately denied the motion to dismiss, although I think it ought to have been mighty clear that I had big problems with this statute. I've made no bones about that from the beginning. And there always was access to the Court of Appeals all along here. Well, I guess that's not fair for me to say because I was sitting on it. But so shame on me. But I ultimately read the statute and have, even when I ruled on the motion to dismiss, I was of the opinion that the statute was as interpreted by the defense, but there was not sufficient grounds to grant the motion to dismiss. Is the firearm here now?
Yes.
We can either measure it, or you can stipulate that it does not meet what I've stated are the requirements, and if it is out of compliance, if it is if the barrel length is less than 60 inches, or an overall length less than 26 inches, then I'll deny the motion. If it does not meet those specifications, then this defense motion will be granted.
We are not disputing that the barrel is appropriate.
Isn't legal?
It is not a short-barreled shotgun or a short-barreled rifle, yes.
Either by...
Correct.
All right, and then count 6 is dismissed. What's next?
One other thing, Judge. I had filed on November 8th, we had addressed a motion for mistrial with prejudice. The court had taken that under advisement. What I had informed the court was, so I have filed something in writing on that. I know the court likely hasn't had an opportunity to review it. I don't know. I'm assuming,
I haven't even seen it.
Okay. I'm assuming that we're going to go obviously through closing arguments today, but I did want to make sure the court was aware that it had been filed, and at some point have the court make a final ruling on it, just for the record.
I will.
Okay.
If it's necessary. Okay. Came in this morning? Okay. Okay, anything else?
Were you ever able to get the defendant's interview link that we sent to play? The Washington Post story?
I did receive that. I did receive that.
It relates to the motion. That's the only reason I asked. The defense motion, it relates to that.
Well, I'm not going to take up the motion now.
I understand now. I just knew there were typical problems. I just wanted to make sure they were ironed out.
I did receive it.
Okay.
Okay. Anything else right now?
Judge, are you done? Attorney Charles. Yeah. The only thing, Judge, in our arguments, we would like to indicate that pointing a loaded AR-15 at someone without reasonable justification would be a criminal act without citing, the specific statute, but that pointing under 941.20 is a crime. We would like to point that out, and we just wanted to preview that. So if there's objection, we can handle it now.
Okay. Do you want to respond?
We would object. This is once again relying on the exhibit that is so far out of focus, and there's been nothing in the record. When I specifically asked the Detective Howard regarding the strong arm robbery, I asked about it. Strong arm robbery while masked. I asked about it. It's in the record.
The struggle I'm having with that is, and I will, well, I'll leave that. How do we know it was pointed at or toward Mr. Zeminski or Mrs. Zeminski or whomever? You have a theory that it's pointed in that direction. I agree with that. But the statute's prohibition is pretty explicit. And I'm not sure that the evidence that you have, especially because it's just well, not just especially, but in part because it's just a regular photograph. It's not multidimensional. It doesn't show the exact area at which the firearm was aimed.
Judge,
even if you see the firearm.
Again, the photograph is perhaps the 5th or 6th most relevant piece of evidence on this topic.
Most what?
5th or 6th most relevant piece of evidence on this topic. We have testimony, we have videos. I'm not going to go over that again. The defense submitted their own exhibit of the FBI video with the Zeminskis denoted as being the only two that were on that side of the Duramax. Mr. Zeminski starts out by one of the windows of the Duramax. I guess it would be the rear passenger side window. And so there's no real dispute that they are in that area, and that is where that he is pointing the weapon. It's for the jury to decide if he's pointing at Zeminski's or not.
So it's for the jury to decide. It is not for the jury to speculate. I mean, let's look at the statute. That's a good place to start. Was it 941.20? Yeah. And that brings up, a separate issue, I suppose, that what is the role of Mr. Rosenbaum, assuming the defendant violated that statute? That's the very theory that the state has proceeded on in the first place, is that the defendant was a vigilante who was getting himself involved in something that was not his concern. And now you're telling me that would justify Mr. Rosenbaum's actions? I'm kind of struggling with that, too. How would that justify? I mean, what does the jury do with that?
I don't fully understand the court's question. I would also note that
pardon me?
He also pointed the weapon at Mr. Rosenbaum before the shooting. While he's being pursued, he turns and points it at Mr. Rosenbaum.
Well, there's no question about that.
Correct.
He's being chased by him.
Pardon me?
I said he's being chased by him.
Well, they've made it much more complicated. It used to be points or aims of firearm at another. I'm not seeing that exact language anymore, but I'm not seeing it here in the statute that there would be a broad enough sweep to capture some wrongfulness in just pointing the firearm towards the west without evidence that it was pointed specifically at or toward another? What am I missing?
1A is endangers another safety by the negligent operation or handling of a dangerous weapon.
Could you start that over? I'm so
Sure. 1A is endangers another safety by the negligent operation or handling of a dangerous weapon. We would argue that it is. If the court feels otherwise, we just simply will talk about it and not call it a crime.
Where was the firearm aimed? You say at the Zabinskis. I didn't hear the Zabinskis come in here and say that. Who said it?
Except for looking at the video, and that's who's over there. That would be the only evidence.
I beg pardon?
Looking at videos and indicating that those are the ones who are over there, that would be the only evidence.
I can't say. I'm not saying it didn't happen. I'm saying I don't think I can give an instruction to the jury, telling them something when I don't see the statutory.
We're asking for instruction. In our closing, in our arguments, we just wanted to say that it's.
I think it would be okay for you to state what the law says, but you have to be careful because the jury cannot be invited to speculate. So I don't want to. There's such a universe of possible statements that could be made that I don't want to try to rule in advance. I've refrained from doing that. I always try to because I can't read your mind, but. So I'm not going to say that he can't mention that at all, that it's unlawful to point a gun at somebody. The jurors probably have a sense of that anyway. But as to what might be said, I can't tell you what's in and out of bounds. Okay, what's next?
That's all we have.
Okay, ready for the jury? I'll probably take a break after the lengthy instructions. And
It's He was only a good vice president because he understood how to kiss Barack Obama's ass.
That's what she said.
Who built the cages, Joe?
Don't get brazen with me.
What happened? Your balls drop off? Fuck Antifa! Fuck Antifa! Fuck Antifa! Fuck Antifa! Fuck Antifa! Fuck Antifa! Fuck Antifa!
Okay. Nice weekend, and we'll begin our final phase of our case, which is my instructions, and I'm going to instruct you on the principles of law which you are to follow in considering the evidence and in reaching your verdicts. It is your duty to follow all of these instructions, regardless of any opinion that you may have about what the law is or what the law ought to be. You must base your verdict on the law as I give it to you in these instructions. Apply that law to the facts in the case which have been properly proved by the evidence. Consider only the evidence received during the trial, and the law is given to you in these instructions. And from these things alone, guided by your soundest reason and best judgment, reach your verdict. If any of you has any impression of my opinion as to the innocence or guilt of the defendant, you must disregard that impression entirely and decide this case solely as you view the evidence. You are the sole judges of the facts, and I am the judge of the law only. Keep in mind that the information is nothing more than a written formal accusation against the defendant, accusing him of the commission of crimes. You are not to consider it as evidence against the defendant in any way, and it does not raise any inference of guilt. The information contains 6 counts of charged unlawful behavior against the defendant, and to each of these he has entered a plea of not guilty, which is a demand that the state prove every element of each crime beyond a reasonable doubt. Self-defense is an issue in this case. As to 5, and I might interject here, count 6 is no longer part of your consideration. That was the firearm charge. So that will not be something that you will need to address. You'll need to address only the first 5 counts. Self-defense is an issue in this case. As to each of counts 1 through 5, the state must prove by evidence which satisfies you beyond a reasonable doubt that the defendant did not act lawfully in self-defense. The law of self-defense allows the defendant to threaten or intentionally use force against another only if he believed that there was an actual or imminent unlawful interference with his own person, and he believed that the amount of force which he used or threatened to use was necessary to prevent or terminate the interference, and his beliefs were reasonable. The defendant may intentionally use force which is intended or likely to cause death or great bodily harm only if he reasonably believed that the force used was necessary to prevent imminent death or great bodily harm to his own person. A belief may be reasonable even though it is mistaken. In determining whether the defendant's beliefs were reasonable, the standard is what a person of ordinary intelligence and prudence would have believed in the defendant's position under the circumstances that existed at the time of the alleged offenses. The reasonableness of the defendant's beliefs must be determined from the standpoint of the defendant at the time of the defendant's acts and not from the standpoint of the jury now. There is no duty to retreat. However, in determining whether the defendant reasonably believed the amount of force used was necessary to prevent or terminate the interference, you may consider whether the defendant had the opportunity to retreat with safety, whether such retreat was feasible, and whether the defendant knew of the opportunity to retreat. You should also consider whether the defendant provoked the attack. A person who engages in unlawful conduct of a type likely to provoke others to attack, and who does provoke an attack, is not allowed to use or threaten force in self-defense against that attack. However, if the attack which follows causes the person reasonably to believe that he is in imminent danger of death or great bodily harm, he may lawfully act in self-defense, but the person may not use or threaten force intended or likely to cause death unless he reasonably believes that he has exhausted every other reasonable means to escape from or otherwise avoid great bodily harm. Counts 4 and 5 require intent to kill as part of the elements. Intent to kill means that the defendant had the mental purpose to take the life of another human being or was aware that his conduct was practically certain to cause the death of another human being. While the law requires that the defendant have acted with the intent to kill, it does not require that the intent to kill have existed for any particular length of time before the act was committed. The act need not have been brooded over, considered, or reflected upon for a week, a day, an hour, or even for a minute. There need not have been any appreciable time between the formation of the intent and the act. The intent to kill may be formed at any time before the act, including the instant before the act, and must continue to have existed at the time of the act. You cannot look into a person's mind to determine intent. Intent to kill must be found, if found at all, from the defendant's acts, words, and statements, if any, and from all the facts and circumstances in this case which bear upon intent. Intent should not be confused with motive. Proof of motive is necessary. While proof of motive is necessary to a conviction, proof of motive is not. Motive refers to a person's reason for doing something. While motive may be shown as a circumstance to aid in establishing the guilt of the defendant, The state is not required to prove motive on the part of the defendant in order to convict. Evidence of motive does not by itself establish guilt. You should give it the weight you believe it deserves under all of the circumstances. The first count of the information charges that on or about Tuesday, the 25th of August of last year at the city of Kenosha in this county, the defendant recklessly caused the death of another human being, Joseph D. Rosenbaum, under circumstances which show utter disregard for human life. First-degree reckless homicide, as defined in the criminal code, is committed by one who recklessly causes the death of another human being under circumstances which show utter disregard for human life. Before you may find the defendant guilty of reckless homicide of the first degree, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following three elements were present. First, that the defendant caused the death of another. Cause means that the defendant's act was a substantial factor in producing the death. Second, that the defendant caused the death by criminally reckless conduct. Criminally reckless conduct means the conduct created a risk of death or great bodily harm to another person, and that the risk of death or great bodily harm was unreasonable and substantial, and that the defendant was aware that his conduct created the unreasonable and substantial risk of death or great bodily harm. The circumstances and the circumstances of the defendant's conduct showed utter disregard for human life. In determining whether the circumstances of the conduct showed utter disregard for human life, you should consider these factors: what the defendant was doing, why he was engaged in that conduct, how dangerous the conduct was, how obvious was the danger, whether the conduct showed any regard for human life, and all other facts and circumstances relating to the conduct. If, as to the first count, you are satisfied beyond a reasonable doubt that both elements of this crime have been proved, and that the defendant was not acting lawfully in self-defense, as I have instructed you on the law of self-defense, then you should find the defendant guilty of reckless homicide of the first degree as charged in the information. If you are not so satisfied, then you must find the defendant not guilty on this count. Counts 2 and 3 of the information accuse the defendant of the crimes of recklessly endangering safety. Although the elements of each of these charges are identical, the rules of self-defense which apply to them are not. The second count of the information charges that at the same time and place, the defendant recklessly endangered the safety of Richard McGinnis under circumstances which show utter disregard for human life. The third count of the information charges that at the same time and place, the defendant recklessly endangered the safety of an unknown male under circumstances which show utter disregard for human life. First-degree reckless endangerment, as defined in the criminal code, is committed by one who recklessly endangers the safety of another human being under circumstances which show utter disregard for human life. Before you may find the defendant guilty of reckless endangerment of the first degree, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following three elements were present. First, that the defendant endangered the safety of another human being, and the risk of death or great bodily harm was unreasonable and substantial, and the defendant was aware that his conduct created the unreasonable and substantial risk of death or great bodily harm. Great bodily harm means injury which creates a substantial risk of death or which causes serious permanent disfigurement or which causes a permanent or protracted loss or impairment of the function of any bodily member or organ or other serious bodily injury. The third element is that the circumstances of the defendant's conduct showed utter disregard for human life. Again, in determining whether the circumstances of the conduct showed utter disregard for human life, you should consider these factors: what the defendant was doing, why the defendant was engaged in that conduct, how dangerous was the conduct, how obvious was the danger, whether the conduct showed any regard for human life, and all other facts and circumstances related to the conduct. When I was instructing you a moment ago on reckless homicide, I indicated there were 2 elements. There are actually 3. I did read all of the ingredients, but I'm just going to reread a portion of that instruction so it's clear that there are 3 elements to that crime. And I also used the word both of the elements, and it's actually 3. So I apologize for that mistake, and we'll stop with the reckless endangerment for a moment and return to the reckless homicide. And the elements of reckless homicide are that the defendant caused the death of another, that he did so by criminally reckless conduct, and the third element, which I read as part of the second, is that the circumstances of the defendant's conduct showed utter disregard for human life. And what tipped me off is, other than causing death, the reckless endangerment, which I've been reading now, has those same 3 elements. So utter disregard for human life is one of the elements of both crimes. And in order to convict on the first count, you must find the presence of all 3 of the elements of first-degree reckless homicide, and also find beyond a reasonable doubt that the defendant was not privileged under the law of self-defense. Is that clear? Thanks. Thank you very much. getting back to the reckless endangerment charge with respect to Mr. McGinnis, there is evidence in this case that the defendant was acting in self-defense as to Joseph Rosenbaum. The fact that the law may have allowed the defendant to use force in self-defense as to Joseph Rosenbaum does not necessarily mean that recklessly endangering the safety of Richard McGinnis was lawful. You must consider the law of self-defense in deciding whether the defendant's conduct as to Richard McGinnis was criminally reckless conduct, which showed utter disregard for human life, but the defendant does not have a privilege of self-defense with respect to Mr. McGinnis. So the defendant would enjoy a privilege of self-defense with respect to Mr. Rosenbaum if you find the factual ingredients of that. But that doesn't mean that the fact that if he endangered the safety of Mr. McGinnis was privileged under the law of self-defense, because Mr. McGinnis was not attacking him. However, you must consider the law of self-defense in deciding whether the defendant's conduct as to Richard McGinnis was criminally reckless conduct which showed utter disregard for human life, but he does not have a privilege of self-defense as to Richard McGinnis. The law of self-defense allows the defendant to threaten or intentionally use force against another only if the defendant believed that there was an actual or imminent interference with the defendant's person, that he believed that the amount of force he used or threatened to use was necessary to prevent or terminate the interference, and that his beliefs were reasonable. The defendant may intentionally use force which is intended to or likely to cause death or great bodily harm only if the defendant reasonably believed that the force used was necessary to prevent imminent death or great bodily injury to himself. A belief may be reasonable even though mistaken. In determining whether the defendant's beliefs were reasonable, the standard is what a person of ordinary intelligence and prudence would have believed in the defendant's position under the circumstances existing at the time of the alleged offense. The reasonableness of the defendant's beliefs must be determined from the standpoint of the defendant at the time of his acts and not from the viewpoint of the jury now. You should consider the evidence relating to self-defense along with all the other evidence in the case in deciding whether the defendant's conduct created an unreasonable risk of death or great bodily harm to Richard McGinnis. If the defendant was acting lawfully in self-defense with respect to Joseph Rosenbaum, his conduct did not create an unreasonable risk to another. The burden is on the state to prove the burden is on the state to prove beyond a reasonable doubt that the defendant did not act lawfully in self-defense, and you must be satisfied beyond a reasonable doubt from all of the evidence in this case that the risk was unreasonable. You should consider the evidence relating to self-defense in deciding whether the circumstances of the defendant's conduct showed utter disregard for human life. The burden is on the state to prove beyond a reasonable doubt that the defendant did not act lawfully in self-defense, and you must be satisfied beyond a reasonable doubt from all of the evidence in this case that the circumstances of the defendant's conduct showed utter disregard for human life. If, as to each of these counts, you are satisfied beyond a reasonable doubt that the elements have been proved and that the defendant was not acting lawfully in self-defense, you should find the defendant guilty of reckless homicide of the first degree. If so satisfied, then you must find the defendant not guilty. The fourth count of the information charges that at the same time and place the defendant caused the death of another human being, Anthony M. Huber, with intent to kill that person. This is a charge of intentional homicide of the first degree, and you must consider first whether the defendant is guilty of that offense. If you are not satisfied the defendant is guilty of first-degree intentional homicide, you may consider whether or not the defendant is guilty of second-degree intentional homicide or first-degree reckless homicide, which are less serious degrees of criminal homicide. The crimes referred to as first and second degree intentional homicide and first degree reckless homicide are different degrees of homicide. Homicide is the taking of the life of another human being. The degree of homicide defined by law depends on the facts and circumstances of each particular case. While the law separates homicides into different types and degrees, there are certain elements which are common to each crime. Both intentional and reckless homicide require that the defendant have caused the death of another. First and second degree intentional homicide require the state to prove the additional fact that the defendant have acted with the intent to kill. First degree reckless homicide requires that the defendant acted recklessly and that the circumstances of his conduct showed utter disregard for human life. It will also be important for you to consider the privilege of self-defense in deciding which crime, if any, the defendant has committed. Self-defense, the Criminal Code of Wisconsin provides that a person is privileged to intentionally use force against another for the purpose of preventing or terminating what he reasonably believes to be an unlawful interference with his own person by the other person. However, he may intentionally use only such force as he reasonably believes is necessary to prevent or terminate the interference. He may not intentionally use force which is intended or likely to cause death unless he reasonably believes that such force is necessary to prevent imminent death or great bodily harm to himself. As applied to this case, the effect of the law of self-defense is the defendant is not guilty of any homicide offense if the defendant reasonably believed that he was preventing or terminating an unlawful interference with his own person, or reasonably believed the force used by him, and reasonably believed that the force used by him was necessary to prevent imminent death or great bodily harm to himself. The defendant is guilty of second-degree intentional homicide if he caused the death of another human being with intent to kill and actually believed the force used was necessary to prevent imminent death or great bodily harm to himself, but the belief or the amount of force used was unreasonable. The defendant is guilty of first-degree intentional homicide if he intended to cause the death of another with the intent to kill and did not actually believe that the force used was necessary to prevent imminent death or great bodily harm to himself. The defendant is guilty of first-degree reckless homicide if the defendant caused the death of another by criminally reckless conduct and the circumstances of the conduct showed utter disregard for human life. You will be asked to consider the privilege of self-defense in deciding whether the elements of first-degree reckless homicide are present. Because the law provides that it is the state's burden to prove all facts necessary to constitute a crime beyond a reasonable doubt, you will not be asked to make a separate finding on whether the defendant acted in self-defense. Instead, you will be asked to determine whether the state has established the necessary facts to justify a finding of guilty for first or second degree intentional homicide or for first degree reckless homicide. If the state does not satisfy you that those facts are established by the evidence, you will be instructed to find the defendant not guilty. The facts necessary to constitute each crime will now be defined for you in greater detail. First degree intentional homicide is defined in the Criminal Code as committed by one who causes the death of another human being with the intent to kill that person or another. In this case, first degree intentional homicide also requires that the defendant did not actually believe the force used was necessary to prevent imminent death or great bodily harm to himself. Before you may find the defendant guilty of first degree intentional homicide, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following three elements were present. First, that the defendant caused the death of another. Cause means that his act was a substantial factor in producing the death. Second, that the defendant acted with the intent to kill the other. Third, that the defendant did not actually believe that the force used was necessary to prevent imminent death or great bodily harm to himself. The third element of the first degree intentional homicide requires that the defendant did not actually believe the force used was necessary to prevent imminent death or great bodily harm to himself. This requires the state to prove either that the defendant did not actually believe he was in imminent danger of death or great bodily harm, or that the defendant did not actually believe that the force used was necessary to prevent imminent danger of death or great bodily harm to himself. When first-degree intentional homicide is considered, the reasonableness of the defendant's conduct, when first-degree intentional homicide is considered, the reasonableness of the defendant's belief is not an issue. You are to be concerned only with what the defendant actually believed. Whether those beliefs are reasonable is important only if you later consider whether the defendant is guilty of second-degree intentional homicide. If, as to the fourth count, you are satisfied beyond a reasonable doubt that the defendant caused the death of another with the intent to kill, this is Mr. Huber, with the intent to kill, and that the defendant did not actually believe that the force used was necessary to prevent imminent death or great bodily harm to himself, intentional homicide. If you are not so satisfied, then you must not find the defendant guilty of first-degree intentional homicide and must consider whether the defendant is guilty of second-degree intentional homicide as defined in the criminal code, which is a lesser included offense of the first-degree intentional homicide. There are hierarchies of cases in the law. Typically, first-degree is the highest offense. Then lesser included are crimes that are of the same nature with many common elements, but some differences. So there's a sequence of verdicts that are going to be submitted to you with respect to this count, and that's what we're going through at this time. So we'll take on now the, but let me advise you, you should make every reasonable effort to agree unanimously on the charge of intentional homicide of the first degree before considering the offense of second-degree intentional homicide. However, if after a full and complete consideration of the evidence, you conclude that further deliberation would not result in unanimous agreement on the charge of first-degree intentional homicide, you should consider whether the defendant is guilty of second-degree intentional homicide. Before you may find the defendant guilty of intentional homicide of the second degree, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following three elements of this crime were present. First, that the defendant caused the death of another. Second, that he acted with intent to kill another human being. And third, that he did not reasonably believe that he was terminating an unlawful interference with his own person, or did not reasonably believe that the force used was necessary to prevent imminent death or great bodily harm to himself. You have already been instructed on the definitions of causing death and with intent to kill. These same definitions apply to your consideration of second-degree intentional homicide. The third element of second-degree intentional homicide requires that the defendant did not reasonably believe that he was preventing or terminating an unlawful interference with his own person, or did not reasonably believe that the force which was used was necessary to prevent imminent death or great bodily harm to himself. This requires that the state have proved one of the following. First, that a reasonable person in the circumstances of the defendant would not have believed that he was preventing or terminating an unlawful interference with his own person, or that a reasonable person in the circumstances of the defendant would not have believed he was in danger of imminent death or great bodily harm, or that the reasonable person in the circumstances of the defendant would not have believed that the amount of force used was necessary to prevent imminent death or great bodily harm to himself. The reasonableness of the defendant's beliefs must be determined from the standpoint of the defendant at the time of his acts and not from the standpoint of the viewpoint of the jury now. The standard is what a person of ordinary intelligence and prudence would have believed in the position of the defendant under the circumstances existing at the time of the alleged offense. If, as to the fourth count, you are satisfied beyond a reasonable doubt that the defendant caused the death of another human being with intent to kill, and did not reasonably believe that he was preventing or terminating an unlawful interference with his own person, or did not reasonably believe that the force used was necessary to prevent imminent death or great bodily harm to himself, you should find the defendant guilty of second-degree intentional homicide. If you are not so satisfied, then you must not find the defendant guilty of second-degree intentional homicide, and you should consider whether the defendant is guilty of first-degree reckless homicide as defined in the criminal code, which is also a lesser included offense of first-degree intentional homicide. Again, you should make every reasonable effort to agree unanimously on the charge of second-degree intentional homicide before considering the offense of first-degree reckless homicide. However, if after a full and complete consideration of the evidence, you conclude that further deliberation would not result in unanimous agreement on the charge of second-degree intentional homicide, you should consider whether the defendant is guilty of first-degree reckless homicide, which is a crime committed by one who recklessly causes the death of another human being under circumstances which show utter disregard for human life. Before the defendant may be found guilty of reckless homicide of the first degree, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following three elements were present. First, that the defendant caused the death of another human being. Cause means that the defendant's act was a substantial factor in producing the death. Second, that the defendant caused the death by criminally reckless conduct, which means the conduct created a risk of death or great bodily harm to another person, and the risk of death or great bodily harm was unreasonable and substantial, and the defendant was aware that his conduct created the unreasonable and substantial risk of death or great bodily harm. You should consider the evidence relating to self-defense in deciding whether the defendant's conduct created the unreasonable risk to another. If the defendant was acting lawfully in self-defense, his conduct did not create an unreasonable risk to another. The burden is on the state to establish beyond a reasonable doubt that the defendant did not act lawfully in self-defense. And you must be satisfied beyond a reasonable doubt from all of the evidence in this case that the risk was unreasonable.
Sorry, my mic was off. Hey, look, I stopped it because, you know, Toko's been here for the whole entire trial, guys. Toko is cool. Let's not argue. We're here to root for Kyle Rittenhouse. That's all I'm saying. All right? Everybody, it's Monday. I know we're all tired. We don't want this trial to be happening, but come on, guys. Can't we all just get along?
The third element is that the circumstances of the defendant's conduct showed utter disregard for human life. Again, in determining whether the circumstances of the conduct showed utter disregard for human life, you should consider these factors: what the defendant was doing, why he was doing it, how dangerous the conduct was, the obviousness of the danger, whether the conduct showed any regard for life, and all other facts and circumstances relating to the conduct. You should consider the evidence relating to self-defense in deciding whether the circumstances of the defendant's conduct showed utter disregard for human life. The burden is on the state to prove by evidence which satisfies you beyond a reasonable doubt that the defendant did not act lawfully in self-defense. And you must be satisfied beyond a reasonable doubt from all of the evidence in the case that the circumstances of the defendant's conduct showed utter disregard for human life. Consider also the defendant's conduct after the death so as to, consider also the defendant's conduct after the death to the extent that it helps you decide whether or not the circumstances showed utter disregard for human life at the time that the death occurred. If as to the fourth count you are satisfied beyond a reasonable doubt that the defendant caused the death of another human being by criminally reckless conduct, and that the circumstances of the conduct showed utter disregard for human life, and that the defendant's conduct was not privileged under the law of self-defense, then you should find the defendant guilty of reckless homicide of the first degree, as submitted. If you are not so satisfied, then you must find the defendant not guilty on the fourth count. The fifth count of the information charges that at the same time and place, the defendant attempted to cause the death of Gage Grosskreutz with intent to kill that person, a crime of attempted first-degree intentional homicide. With respect to this charge, you must first consider whether the defendant is guilty of that offense. If you are not satisfied that the defendant is guilty of attempted first-degree intentional homicide, you must consider whether or not he is guilty of attempted second-degree intentional homicide or first-degree reckless endangerment, which are less serious degrees of criminal homicide. The crimes referred to as attempted first and second-degree intentional homicide are different degrees of homicide. Again, that is the taking of the life of a human being. The degree of attempted homicide is defined by law depending on the facts and circumstances of each particular case. While the law separates intentional homicides into two degrees, there are certain elements that are common to each. Both attempted first and second-degree intentional homicide require that the defendant have intended to kill another, that he did acts towards the commission of that crime which indicate unequivocally, under all the circumstances, that he had formed that intent and would have caused the death of the other, except for the intervention of another person or some extraneous factor. It will also be important for you to consider the privilege of self-defense in deciding which crime, if any, the defendant has committed. The Criminal Code of Wisconsin provides that a person is privileged to intentionally use force against another under the following circumstances. Force is used for the purpose of preventing or terminating what the person reasonably believes to be an unlawful interference with his own person or by the other, and he uses only that amount of force which he reasonably believes is necessary to prevent or terminate the interference, and the person may not intentionally use force which is intended or likely to cause death unless he reasonably believes that such force is necessary to prevent imminent death or great bodily harm to himself. If you find that the elements of attempted first or second-degree intentional homicide have been proved in this case, the effect of the law of self-defense is as follows. The defendant is not guilty of either attempted first or second-degree intentional homicide if he reasonably believed that he was preventing or terminating an unlawful interference with his own person, and he reasonably believed the force used was necessary to prevent death or great bodily harm to himself. He is guilty of attempted second-degree intentional homicide if he actually believed the force used was necessary to prevent imminent death or great bodily harm to himself, but the belief or the amount of force used was unreasonable. The defendant is guilty of attempted first-degree intentional homicide if the defendant did not actually believe the force used was necessary to prevent imminent death or great bodily harm to him. Because the law provides that it is the state's burden to prove all the facts necessary to constitute a guilt beyond a reasonable doubt, you will not be asked to make a separate finding as to whether the defendant acted in self-defense. Instead, you will be asked to determine whether the state has proved the necessary facts to justify a finding of guilty for attempted first or second-degree intentional homicide. If the state does not satisfy you that those facts are established by the evidence, you will be instructed to find the defendant not guilty. The elements of each crime will now be defined for you in greater detail. Before you may find the defendant guilty of attempted first-degree intentional homicide, the state must prove, by evidence which satisfies you beyond a reasonable doubt, that the following three elements were present. First, that the defendant intended to kill another. Second, that he did acts which demonstrate unequivocally, under all of the circumstances, that he had formed the intent and would have caused the death of another, except for the intervention of another person or some other extraneous factor. Unequivocally means that no other inference or conclusion can reasonably and fairly be drawn from the defendant's acts under the circumstances. Another person means anyone other than the defendant, include the intended victim. An extraneous factor is something outside the knowledge of the defendant or outside of his control. The third element is that the defendant did not actually believe that the force used was necessary to prevent imminent death or great bodily harm to himself. The third element of attempted first-degree intentional homicide requires that the defendant did not actually believe the amount of force was necessary to prevent imminent death or great bodily harm to himself. This requires the state to prove either that the defendant did not actually believe that he was in imminent danger of death or great bodily harm, or that the defendant did not actually believe that the amount of force used was necessary to prevent imminent danger of death or great bodily harm to himself. When attempted first-degree intentional homicide is considered, the reasonableness of the defendant's belief is not an issue. You are to be concerned only with what the defendant actually believed. Whether these beliefs are reasonable is important only if you later consider whether the defendant is guilty of attempted second-degree intentional homicide. If, as to the fifth count, you are satisfied beyond a reasonable doubt that the defendant intended to kill another human being, and that his acts demonstrate unequivocally that the defendant intended to kill and would have killed the other except for the intervention of another person or some other extraneous factor, and that he did not actually believe that the force used was necessary to prevent imminent death or great bodily harm to himself, you should find the defendant guilty of attempted first-degree intentional homicide. If you are not so satisfied, then you must find the defendant not guilty of attempted first-degree intentional homicide, and must consider whether the defendant is guilty of attempted second-degree homicide, intentional, which is a lesser included offense of intentional homicide of the first degree. Again, you should make every reasonable effort to agree unanimously on the charge of attempted first-degree intentional homicide before considering the offense of attempted second-degree intentional homicide. However, if after a full and complete consideration of the evidence, you conclude that further deliberation would not result in a unanimous agreement on the charge of attempted first-degree intentional homicide, you should consider whether the defendant is guilty of attempted second-degree intentional homicide. Before you may find the defendant guilty of second-degree intentional homicide, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following three elements were present. First, that the defendant intended to kill another. Second, that he did acts which demonstrate unequivocally, under all of the circumstances, that he had formed that intent and would have caused the death of another human being, except for the intervention of another person or some other extraneous factor. The third element is that the defendant did not reasonably believe that he was preventing or terminating an unlawful interference with his own person, or did not reasonably believe that the force used was necessary to prevent imminent death or great bodily harm to himself. You have already been instructed on the definitions of intent to kill unequivocally another person and extraneous factor. The same definitions apply to your consideration of attempted second-degree intentional homicide. The third element of attempted second-degree intentional homicide requires that the defendant did not reasonably believe that he was preventing or terminating an unlawful interference with his own person, or did not reasonably believe that the force used was necessary to prevent imminent death or great bodily harm to himself. This requires that the state have proved any one of the following. First, that the reasonable person in the circumstances of the defendant would not have believed that he was preventing or terminating an unlawful interference with his own person, or that a reasonable person in the circumstances of the defendant would not have believed that he was in danger of imminent death or great bodily harm, or that a reasonable person in the circumstances of the defendant would not have believed that the amount of force used was necessary to prevent imminent death or great bodily harm to himself. The reasonableness of the defendant's belief must be determined from the standpoint of the defendant at the time of his acts and not from the viewpoint of the jury now. The standard is what a person of ordinary intelligence and prudence would have believed in the position of the defendant under the circumstances existing at the time of the alleged conduct. If as to the fifth count you are satisfied beyond a reasonable doubt that the defendant intended to kill, and that the defendant's acts demonstrated unequivocally that the defendant intended to kill and would have killed another, except for the intervention of another person or some other extraneous factor, and that the defendant did not reasonably believe that he was preventing or terminating an unlawful interference with his own person, or did not reasonably believe that the force used was necessary to prevent imminent death or great bodily harm to himself, you should find the defendant guilty of attempted second-degree intentional homicide. If you are not so satisfied beyond a reasonable doubt that the defendant is guilty of attempted first or second-degree intentional homicide, you must determine whether the defendant is guilty of the lesser included offense of first-degree recklessly endangering safety, as defined in the criminal code, which is a lesser included offense of attempted first and second-degree intentional homicide. First-degree recklessly endangering safety, as defined in the criminal code, is committed by one who recklessly endangers the safety of another human being under circumstances which show utter disregard for human life. Before you may find the defendant guilty of first-degree reckless endangerment, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following three elements were present. First, that the defendant endangered the safety of another human being. Second, that he did so by criminally reckless conduct, which means that his conduct created a risk of death or great bodily harm to another, and that the risk of death or great bodily harm was unreasonable and substantial, and that he was aware that his conduct created the unreasonable and substantial risk of death or great bodily harm. Great bodily harm means injury which creates a substantial risk of death or which causes serious permanent disfigurement, or which causes a permanent or protracted loss or impairment of the function of any bodily member or organ or other serious bodily injury. Third, that the circumstances of the defendant's conduct showed utter disregard for human life. In determining whether the circumstances of the conduct showed utter disregard for human life, you should consider these factors: what the defendant was doing, why he was doing it, how dangerous was the conduct, how obvious was the danger, whether the conduct showed any regard for life, and all other facts and circumstances relating to the conduct. If you are satisfied that all three elements of this offense have been proved beyond a reasonable doubt, and that the state has proved beyond a reasonable doubt that the defendant was not acting lawfully in self-defense, then you should find the defendant guilty of reckless endangerment of the first degree as submitted. If you are not so satisfied, then you must find the defendant not guilty. You are not in any event to find the defendant guilty of more than one of any sequence of offenses. So you can return only one verdict per count. You should consider the charged offense first. If you find unanimously that the defendant is guilty of the highest degree of crime, you need not consider lesser included offenses. If you decide unanimously the defendant did not commit the greater crime and was acting lawfully in self-defense, got myself into a mid-sentence and I don't like it.
Wonder what they're tripping on now. Thought that's why they do that, all this stuff beforehand, so we don't got to deal with stuff like this. You know, this is why, like on the Rittenhouse trial, on the last trial, on the Chauvin trial, I would stay way behind. I would start late so I could fast forward through shit like this. Should have done that on this one. Come on, Judge. We're gonna have a big bacon sandwich for lunch. Sounds good. Remember that, what was that movie? Oh, it was in Minnesota. Grumpy Old Man. I had bacon for breakfast, then I had some bacon for lunch, and I drink myself for dinner. Or something like that. Oh yeah, I was right in the very middle of the cops trial. I mean, I was like right in the middle. I was fucking right there. Like I had Black Lives Matter surrounding me. In fact, I think I was me and Taiho were the only patriots that were actually there in the center. Oh no, excuse me, Terra American Brotherhood was there, but I mean Taiho and I were right the F there. I'll show you guys on a break.
The concern that I have, and I worked with the instructions all weekend, and we discussed them by email, and then I'm reading them, and little things are striking me as I read them. But the jurors are never told to actually discuss self-defense except in the context of charged offenses. And what I was about to say to the jury, and decided I better talk to you people beforehand, is if the jury gets into a discussion of a charged offense, any charged offense, but let's use this one as an example, and they decide that the elements are there and he wasn't acting lawfully in self-defense, they're done. They never discuss the lessers. What?
Was or was not acting lawfully in self-defense?
Well, let's say if they decide the elements are there, but he was not acting lawfully in self-defense, they're done. Then they find him guilty of the charged crime. What if they discuss count 1, or count 5, I should say, and decide that the elements are there, but they all decide it was privileged under the law of self-defense? They're not. Is there anywhere that they're being told? Are they being told you're done? See, under the old law, we did do that. Is that in here? Where is it saying that? Yeah, that's what I used to construct these from scratch. And I would tell the jury, which I was just doing now, that once you have exhausted this, you're done. As opposed to having them needlessly go through these lessers if they've already concluded that. And this is a case where this could happen. I'm not saying it should or would. I'm saying it could, that they would decide, well, yeah, the elements are there, and then they make a decision. And if all of them say, well, they all vote not guilty on the basis of valid self-defense, then they really should not be considering lesser included. Am I wrong about that?
So if they find perfect self-defense on the charged count,
yeah,
they should be told.
You see what this? Yeah, I'm sorry.
I mean, I understand where the court's coming from. I guess they could consider the other ones in 30 seconds and just go down to be not guilty. But
they're so complicated as it is.
No, I understand.
I feel terrible about giving this kind of stuff. It's just so. Well, anyway, see what the instruction is telling them, that kind of cryptically. It says it tells them if after a full discussion. says, however, if after a full and complete consideration of the evidence you conclude that further deliberation would not result in unanimous agreement on the charge of second-degree intentional homicide, I'm going back to a different count, you should consider whether the defendant is guilty. So it is telling them,
Yeah, I just think it's kind of unclear.
I think it's very unclear. What you're saying is the law. They all agree that the elements are met and there's a privilege. You don't go any further.
Pardon me?
I believe the pattern instruction makes that clear enough. If they can unanimously agree, which includes the privilege, they're done. They don't have to go forward.
Where does it use?
It says you should make every reasonable effort to agree unanimously on the charge of second-degree intentional homicide before considering the offense of first-degree reckless homicide. However, if after a full and complete consideration of the evidence, you conclude that further deliberation would not result in unanimous agreement on the charge of second-degree homicide, you should consider whether the defendant is guilty of first-degree reckless homicide. So, there, I don't think it's not the way a person would speak if he wanted to make things clear. And I'm not saying anyone deliberately is trying to make things unclear, but
I think one can say that about all 30-some pages of the.
Don't do that. People will find out our lawyer secret.
I think it's clear in the instructions. If the court did wish to make it clear, I would just say, just explain if you're unanimous either way on the first count. There's no need to go to the lessers.
Yeah, I think that's a good way to do it. I think I'll tell them that in any sequence, if there are lessers submitted to them, once they've discussed the highest count, if they are unanimous either way, then they're done. Does that make sense? No, Mr. Binger is having a problem with that, and let's see what he is, or what he's... I don't like the way I said that either. How about this? In any count where there are multiple verdicts submitted to you, if at any point in your deliberations you are unanimous either as to both the elements, the presence or absence of the elements of the crime, and the presence or absence of the right of self-defense, you need go no further.
The reason I was shaking my head, Your Honor, is because let's take Anthony Huber's counts, for example.
Yeah.
If the jury is unanimous that he is guilty of first-degree intentional homicide, they go no further.
Right.
If they are unanimous that he's not guilty of first-degree intentional homicide, then they are instructed to consider second-degree intentional homicide.
Only if they're not satisfied that it was done in self-defense. If they, for example, if in your example, if they discussed it and said, well, sure, the elements of attempt murder are there, and then they go around the table and they say, well, we all think it's not self-defense, then guilty. If they all say we don't think it's, well, actually, if they all say we don't think it's self-defense, then it's not guilty. And what the jury is being told is if you can't agree unanimously, then consider these lessers. But I don't think it's so clear as it should be.
It says if you are not so satisfied.
I know it. Well, that's at the very end.
And I think what the court was originally proposing is telling the jury unanimous on the charged count one way or the other,
Stop.
then you go no further.
I like that.
That's not the law.
If you're unanimous on,
So, for example, with
if you're unanimous on the legal question, intentional, well, you're right, because it could be an elements issue.
the jury,
Maybe the constructions committee is right.
the jury only goes to lesser included if they are either unable to agree on the charge count or if they're unanimous not guilty on the charge count. Then they go to the lesser included. So there is no requirement that they be unanimous on the charge count to move to the lesser.
No, they shouldn't be unanimous. If they're unanimous, then they're done. That's what I'm trying to tell them, but I don't know how to say it.
But that's not true, because if they're unanimous on first-degree intentional homicide, what they're concluding at that point is that the defendant, either the elements aren't met, or the defendant actually believed that deadly force was necessary. They would still then have to consider the second-degree intentional, because it changes the self-defense into the objective, reasonable one. So they can be unanimous on count one. Let's take Huber, for example. They can be unanimous on the first-degree intentional homicide. They can be unanimous on that, and in the defendant's favor. But they still have to then move to the second element, or to the lesser included.
You might be right.
Perfect self-defense.
Pardon me?
If it's perfect self-defense, it's perfect self-defense for everything.
But they're not told to consider perfect self-defense on first-degree intentional homicide. They're specifically told.
It's fine.
Well, yeah, you're right. He's right.
They're not told to consider that until second-degree intentional homicide. The instructions, Your Honor, are the pattern instructions. I understand your point that if we had to redraft them today from scratch, maybe we could do better. But I'm sure we could. But we need to follow them, and I don't think deviation is appropriate.
I think you're right. And they are certainly correct in what they say. I just think that they're not clear. But maybe they are. I don't know. Now let's see how much damage I've done already by my last paragraph. So can you go back to what the last thing I said to the jury?
Guilty of the highest degree of crime, you need not consider lesser included offenses. If you decide unanimously the defendant did not commit the greater crime and was acting lawfully in self-defense, and then that's when you stopped in mid-sentence.
So the first part was right. Did not commit the greater crime and was acting lawfully in self-defense. You know, if he was acting lawfully in self-defense, the ball game's over. Yeah. I think that's correct. Even your suggestion is seductive, Mr. Binger, but see, they're not asked to consider that. That's where I'm having the problem. And they even make reference to it. I think maybe I read in one of the comments. They talk about we don't have, like some states do. They have a question right off the bat: was the defendant acting lawfully in self-defense? If they answer that yes, we're all done. We've got it interlaced in all these cumbersome instructions. And now, does anyone have any objection to what I've already told the jury? And tell them what?
Just what we said. If you find perfect self-defense, you don't go on to the next count. It's over.
I understand what the term perfect self-defense means, but we haven't told the jury what that means. We're deviating from the standard instructions here, and the words perfect self-defense don't have a meaning to ordinary people, would require further definition from the court, and now we're going much further afield. I also have a problem with the wording of, you know, if you find the defendant is justified in his self-defense, because we've instructed them on his own subjective self-defense belief, which is a defense to the first-degree intentional homicide, and then we've given him the instruction on what the law considers to be objective self-defense, is what a reasonable person would think. When the wording that was just read by the Madam Court Reporter doesn't delineate between those two things, and I think, as I said, and I've repeated here several times, I think the more we deviate from these standard instructions, the more confusion it causes. Counsel has asked you to read the self-defense individually on each count. So they're already being told on each count that you are to consider the final thing is the objective self-defense, and that is if you find that, then he's not guilty. And to say across the board that you find self-defense is a defense to everything is not technically true, because there are different self-defense claims as to the different counts. So, for example, he may be justified to self-defense as to Rosenbaum, but not as to Huber.
I don't want to step into something that I haven't already done. I am inclined, though, because I've made a statement about if everything's present, they're done because they found the defendant guilty, and I do think I probably should give the alternative, which is, and I'm not going to use terms like perfect self-defense like he did. I'm going to use the term acted lawfully in self-defense, and they're instructed on that. So I think the correct statement is, if as to any of the cases with multiple submissions, if on any individual count they find in their consideration of the charged offense that the defendant acted lawfully in self-defense, they're done. Any objection? No. Okay.
While we're talking about the jury instructions, it was noticed as you read them on page 10, which is count 3, it should be first-degree reckless endangerment, and it's written and you read homicide, which is not a homicide count. So
on page 10?
Top of page 10 on count, still at the end of count 3, it says you should find the defendant guilty of first-degree.
Yeah, you're right. You're right. It is in there as homicide. We didn't catch that last night when we talked about him. I said.
Okay, now they took it off of this Law and Order site. They took their stream down. PBS is taking everybody down for sharing their stream right now, apparently. Let's go here.
Presentation.
Here we go.
Well, let's just kind of plan on around noon, because the lunch has already been ordered, so, and I'm not going to comment on the lunch.
He's not commenting on lunches anymore.
So let's ask the jurors to come back in, please. So I'll take a break at, why don't you around whenever you're comfortable.
You know what, I should go one of those other channels and tell them that one channel that I was just on.
Yeah, well, when
I'll
he's
tell him
the
that I'm
commander
live.
I don't want to interrupt him at a time he doesn't want to be.
That way they'll watch it on my channel.
Did you get my IM?
I did.
Where'd they go? Was it Law and Crime? While they're bringing the jury in, I'm going to go switch over. I'm going to go let them know That I have it on my chat. Oh, their chat's down. Never mind. Shit. Damn it, I'm in a poker, I play poker while I do this. I'm in a poker tournament, and I just could have made a whole bunch of chips, but I was paying more attention to the trial for you guys. But it's all good. It's worth it. Let's see, right now, nope, I would have lost. So, thank you guys.
Folks, what I was talking about with the cases that you have multiple possible verdicts submitted to you for consideration, when you address the charged crime, if in your discussions you conclude that the elements are present and the defendant was not acting lawfully in self-defense, then you needn't go any further. You can return your verdict.
Did they kick me off again?
Based upon that conclusion. If in your discussions as to any individual count of those with multiple possible verdicts,
shit.
In your initial discussion, if you decide that
Stream suspended for policy violations. What the fuck?
You're done, and you can return a not guilty verdict without considering the lesser offenses. The defendant acted lawfully in self-defense.
These guys have it on, at least.
You're done, and you can return a not guilty verdict without considering the lesser offense.
Hold on one second.
Any question about that?
Let's see if it comes back on now.
How that wound up sounding. I'm going to give you written
Makes it very easy for them to quit this.
Yeah. Because I know this is arduous going through this, but it.
Hold on one second, guys.
But you'll get written instructions for your.
Not to mention that long break.
I went to this Rakisha law. Maybe they won't kick me off.
Trying his best to stay awake, and I mean, everybody's gonna be posting pictures of him yawning, going, "Oh look, he's such a bad guy" or whatever. But how do you stay awake during something like that?
Counts 1 through 5. During these instructions. Each contain the guilty verdicts of any submitted offense contain a question based upon the allegation of the information that the defendant committed the crime while using a dangerous weapon.
Oh.
If you find the defendant guilty on any of the counts, you must answer the following question: did the defendant commit the crime while using a dangerous weapon? Dangerous weapon means any firearm, whether loaded or unloaded. A firearm is a weapon which acts by the force of gunpowder.
Let me know if it returns, guys. I'm going to check myself real quick. This is bullshit what they're doing. It says stream still unavailable. It says once you go to a different stream, they'll let you back on. Alright, hold on a second. Let's go here for a minute. Let's see if it comes back on. At least I'm still live. Mr. Nice Guy, you don't understand. I understand YouTube has it. Many other channels have it, bro. What's going on is YouTube is banning it on me. They're giving me a copyright issue. I cannot control about what YouTube is doing. I have the channel right here. I'm just waiting for it to come back up, bro. YouTube is being fucking assholes. No matter what channel, I keep trying to go to different channels and YouTube keeps sending me a copyright issue. It's just fucking YouTube being fucking assholes. That's what they're doing. They don't want anybody else to watch this shit. And so it says your stream is interrupted until you can prove that there's nothing else on. So right now I'm showing this to hope that it will pop back on. So that's what I'm working on. I'm waiting for it to come back. And once it comes back, I'll go back to a different channel. But the issue is, YouTube is copywriting everybody. So far, I understand they kicked off, okay, see, look, now I'm back. Okay, look, we're back. Let's go back to the trial now. Let's go to this Rikishi law. They haven't been kicked off yet, so let's stay with them.
Second, any exhibits which have been received, whether or not they accompany you to the jury room.
Maybe they
Third, any
paid
facts
it. Maybe they
which
paid
the lawyers
to.
have agreed or stipulated, or which
It's
I have
just YouTube's
directed
a
you
bunch
to
of
find.
fucking assholes. Is
Anything
all it
that you may have
is.
seen or heard outside the courtroom is not evidence. You are to decide the case solely on the evidence.
Well, Court TV. Whoever's doing it is.
You should disregard entirely any question to which I did not permit.
Yep. See, look, I got kicked off right away again. They won't let you show the fucking trial, guys. They won't let anybody fucking show the trial. So here's the deal: if you want to watch it with me, you're gonna have to go to my You guys are gonna have to go to my channel. What do you call it? Channel.
Objection is made. By allowing testimony,
if you guys
or
want to
other
see this, you're gonna have to go to my
received
Twitch
over
channel.
objection,
That's the only thing I could
I
say.
did not
YouTube's doing this on purpose.
any
There's nothing else I
opinion
can
as
do.
to that evidence.
I really
You
can't
jurors
help
are
it.
the sole judges of the believability of the witnesses.
What's up, Eva?
And of the weight of the evidence. At the beginning of the trial, I described the charges against the defendant. Counts
Maybe
6 and 7,
they're picking certain
which
people to kick
respectively
off.
charged possession of a firearm by a minor
I don't know
and
who,
curfew
but
violation,
so look here.
have been disposed of.
Let me
and are
give
no
you guys
longer
my
part of
Twitch
this case.
page. I don't
The
think
other
you need
counts
to log
remain.
into Twitch to
Do
watch
not
it.
guess about or concern yourself.
Hold on. It's
The charges that remain.
YouTube is
Do not
being a bunch
consider
of dicks.
evidence that
Let's
related
put it
only
that
to
way.
the counts which have been disposed of.
Where's my channel?
During the trial, I have ordered certain testimony stricken, and you must disregard all such stricken testimony. Exhibits become evidence only when received
All right,
by the
guys.
court.
So here is
An
going to be
exhibit
my
which was
channel.
marked for identification but not received is not evidence.
If you want to go to Twitch, you can click on that link and you
Whether
can
or
watch
not-
it for free.
Excuse me.
You don't need to log
is
in,
not
I don't
evidence.
think.
An exhibit received is evidence whether or not it accompanies you.
So
to the
join
jury.
us over on Twitch. Yes,
Remarks of
mass
the lawyers
censorship.
are not evidence, and if the remarks suggest certain facts not in evidence,
I'm sorry, guys.
disregard
There's
the
nothing I can do.
suggestion. You should consider carefully the closing arguments of the attorneys, but their arguments, opinions, and conclusions are not evidence. Draw your own conclusions from the evidence and decide upon your verdict upon the evidence under the instructions given you by the court. I have taken judicial notice.
Oh,
of
yeah, they're
certain
always
facts,
banning
and you are
conservatives.
directed to accept them as true.
So sorry, guys.
The state has
You gotta go
introduced
to
evidence
Twitch.
of statements which it claims were
Once again, here's
made
my
by the
Twitch channel, and you
defendant.
can watch me over
It
there.
is for you to determine how much weight, if any, to give to any statement.
That's why I'm getting sick and tired of
Evaluating each
YouTube.
statement, you
Twitch
must
is
consider
so
three
much
things.
better,
Whether the
guys.
statement was
And I'm sorry if I
actually
got
made
upset,
by the
Mr. Nice Guy. I'm just.
Only so much of a statement
It
as was
pisses me
actually
off when
made
I get
by a person
censored.
may be considered an
This is
evidence.
bullshit. I should be
Whether the
allowed to
statement
show
was
this
accurately
just as much as
restated here at the
everybody
trial,
else.
Whether the statement or any part of it ought to be believed. You
YouTube
should
can
consider
go
the
fuck
facts and
themselves.
circumstances surrounding the making of each statement, along with all other evidence, in determining how much weight, if any, the statement.
Well, the reason is no, it's called a copyright. Other people are
The
playing
weight
it,
of
right?
the evidence does not depend on the number of witnesses on each side.
So because other
You may
people are playing
find
it,
that the testimony of one witness is
they
entitled
won't
to
play
greater
it.
weight than that of another witness, and you may give it such weight in considering your verdict.
you email me, Snucks? Okay.
In weighing the evidence, you may take into account matters of your common knowledge and your observations and experiences in the affairs of life.
I didn't get it, Snookies.
Ordinarily, witnesses may testify only about facts. However, witnesses with specialized knowledge in particular fields may give opinions in those fields. In determining the weight that you give to these opinions, you should consider the qualifications and credibility of the expert, the facts upon which the opinions are based, and the reasons given for the opinion. Opinion evidence was received to help you reach a conclusion. However, you are not bound by any witness's opinion. It is your duty as jurists to scrutinize and weigh the testimony of the witnesses and to determine the effect of the evidence as a whole. You are the sole judges of the credibility, that is, the believability of the witnesses, and of the weight to be given to their testimony. In determining the credibility of each witness and the weight you give to the testimony of each, you should consider these factors: whether the witness is interested or disinterested in the outcome of this trial, conduct, appearance, and demeanor on the witness stand, the clarity or lack of clarity of the witness's recollections, the opportunity which the witness had to know and observe the matters and things about which testimony was given, the reasonableness of the witness's testimony, the witness's apparent intelligence, bias or prejudice, if any has been shown, possible motives to falsify, and all other facts and circumstances during the trial which tend either to support or to discredit the testimony, and then give the testimony of each witness the weight you believe it is entitled to receive. The defendant has testified in this case, and you should not discredit his testimony just because he is charged with a crime. Use the same factors to determine the credibility and weight of the defendant's testimony that you use to evaluate the testimony of other witnesses. There is no magical way for you to evaluate the testimony. Instead, you should use your common sense and your experience. In your everyday lives, you determine for yourselves the reliability of statements made to you by others, and you should do the same thing here. Evidence has been received that 2 of the witnesses in this trial have previously been convicted of crimes. This evidence was received solely because it bears upon their character for truthfulness. It must not be used for any other purpose. We're going to hear the closing. You know what? Does anybody want a break, even just a short one, or not? You want to go right into your discussion? Anybody need a break? Okay. We're going to hear the closing arguments of the attorneys now, and we follow the classical debate format in the court. That is that the proponent of a proposition is entitled to give the first and the last argument. So Mr. Binger will address you first on behalf of the state, then Mr. Richards for the defense.
Let's get ready to rumble!
Limited to rebuttal.
It's time!
Break, obviously. I'm not going to make you sit there for 5 hours, unless you want to. So we'll break. I asked Mr. Binger while you were out of the room if he was comfortable with breaking his argument in parts, and he indicated he was. So at a time he thinks is appropriate, around noon, we'll take our lunch break, and then pick up this afternoon. And then after all of the arguments have been presented, I'll give you about 3 or 4 more minutes of instruction, and then we'll do our striking with the tumbler over there, and it'll be yours. So let me ask you.
Do you have the pointer? Sister's pointer.
Which one do you want?
The sister's pointer.
The sister's pointer? Okay. We'll take a vote right now. Supposing the case arguments are finished at 4:30, 5 o'clock, and we'll be working well to get there. How many would like to begin their deliberations tonight and stay until a later hour? Or how many would like to come back and start fresh in the morning? And the cutoff point would be, say we got finished by 4 and I give you the case. The latest I would let you go if you didn't want to stay late would probably be about 5 o'clock. So I don't know how much you'd get done, but you'd have the option to get started this today, or we just start fresh in the morning if we finish up any time after 3:30 or 4 o'clock. So how many would want to continue on today? 1, 2, 3, 4, 5, 6, 7, 8. 8 out of, what do we got, 18? How many would rather come back fresh tomorrow? Knowing that some of you aren't coming back. Okay, and of course, as always, I'll make the final decision, but I certainly will try to follow your wishes. So, okay, with that, Mr. Binger, it's yours.
Thank you, Judge. Good morning, ladies and gentlemen. I want to assure you that everything the judge just read to you is a copy of, so you have a chance to look it over yourself and what I just told you. I think it's no surprise that this is a case that there's a lot of noise and a lot of static surrounding it. So what I'd like to do at the beginning is crystallize it in a nutshell for you and keep it as simple as possible. This is a case in which a 17-year-old teenager killed 2 unarmed men and severely wounded a third person with an AR-15 that did not belong to him. This isn't a situation where he was protecting his home or his family. He killed people after traveling here from Antioch, Illinois, and staying out after a citywide curfew.
Your Honor, I'm going to object. There's no curfew charge anymore. There's no gun charge.
Although he claimed
there's no charge, but and there has been some discussion about the lawfulness of the curfew, not in this case, but elsewhere. So it's there, but there had been a curfew announced. That does not mean that it was technically lawfully a legal curfew, but there had been an announced curfew. So I'll leave it at that.
And it was a curfew that all the rest of us here in Kenosha were aware of, and I think most people, most reasonable people, obeyed.
Shut up.
Although the defendant claimed to be protecting a business that he wasn't familiar with, the actual killings in this case had nothing to do with that.
Am I back on yet?
And
or no?
he also
I know
spent the
I'm on
entire evening lying about the fact that he was an EMT.
Twitch.
None of the things that I just told you are in doubt in this case. So when we think about the defendant, I'd like you to consider, as you think about this case, what his true motivations were. Was this a situation where he sincerely cared about CarSource, even though he'd never heard of it, never bought anything there, never worked there, and not even its owners were out there that night protecting it? Was he genuinely interested in helping people? He ran around with an AR-15 all night and lied about being an EMT. Does that suggest to you that he genuinely is there to help? He's not there for the same purpose as the protesters. So why was he there that night? When you think about these things, I think there are some things that we can all agree on. In America, it's hard these days. People are polarized, and there's a lot of political issues back and forth. And the judge has made it clear this case is not about politics. There is common ground here. We have all agreed, and I asked you this 2 weeks ago today. Raise your hand if you agree life is more important than property. And all of you raised your hand. We also agree that no one person's life is more valuable than another. You don't get to kill someone simply because they're a drug dealer. You don't weigh a pastor's life over a teacher's life.
Oh,
you don't weigh a
YouTube?
police
Cool.
officer's life over an engineer's life. All life is sacred.
I guess
I
I'm
think we
back
can
on
also
YouTube.
agree that we shouldn't have 17-year-olds running around our streets with AR-15s, because this is exactly what happens. And finally, I want you to keep in mind that we've all read stories and heard about heroes that step in to stop an active shooter or to give their life to save others. In fact, many people in Wisconsin went out and got carrying concealed weapon permits just so that they could be there in case there was an active shooter and wanting to stop them. So when you consider this case, look for the truth. So many people look at this case and they see what they want to see. They have a preconceived notion and they tailor the facts to fit whatever they believe. And you all agreed to keep an open mind. You all told us you didn't have any of those preconceived notions. Now you've heard the evidence, and it's time to search for the truth. So consider, for example, whether or not it's heroic or honorable to provoke and shoot unarmed people. Consider whether it makes someone a hero when they lie about being an EMT. I think all of us are familiar with someone who does the sorts of things that the defendant has done. They enjoy the thrill of going around and telling people what to do without the courage or the honor to back it up, and without the legal authority to do so. And when you think about the defendant's behavior in this case, contrast it with Anthony Huber, a man who was there because he knew Jacob Blake, who carried his skateboard everywhere, and who rushed towards danger to save other people's lives. So when I talk to you here in my closing argument, I'm going to focus first on the murders that the defendant committed. Second, I'm going to address some background issues, give you some context, and talk about some of the things that I don't think are relevant to this case. And finally, I'm going to tie it all into the jury instructions that the judge just gave you. As prosecutors in this case, my colleague Jim Krause and I have tried to present you with all of the relevant evidence that we think you should consider in this case. And I told one of you in jury selection that at the end of this, you would be the expert. You would have all the information. You would be the one
who would know all about this case and make that decision. And that's what we've tried to do. So let's go to August 25th, 2020. The defendant came from outside our community, carrying a gun that wasn't his, because he expected and anticipated violence that night. And he pretended to guard what turned out to be an empty building owned by people he'd never even met, while fraudulently claiming all night long to be an EMT. There were a lot of people out that night. Some people stayed home protecting their homes and their families. Others went to their businesses, boarded them up, and protected them. And a lot of those people had weapons. A lot of them had guns. There were other people who came along to protect Car Source or Ultimate Gas or other businesses. And many of them were armed with AR-15s, just like the defendant. In fact, you're going to see a video, and you've already seen it, of a clash between people with AR-15s at Ultimate Gas and other folks that are, I guess, protesters. And there's people getting in people's faces, there's yelling, there's shouting, there's even shoving. And yet, in this entire sequence of events, from the shooting of Jacob Blake on Sunday, August 23rd, 2020, all the way after that, everything this community went through, the only person who shot and killed anyone was the defendant. Yes, there was property damage. No one's here to defend that. No one's here to tell you it's okay to commit arson or looting. No one's here to tell you it's okay to be rioters. I'm not defending any of that. You know, because you've been told in the testimony, I'm prosecuting Joseph Ziminski for arson. That's not okay. But what you don't get to do is kill someone on the street for committing arson. So let's keep that in mind when we're talking about the people involved in this case. So let's begin with the provocation and the murder of Joseph Rosenbaum, because it's all captured on video. As the defendant and Mr. Rosenbaum arrive at the 63rd Street Car Source, Mr. Rosenbaum is ahead of the defendant. And as you see in the FBI video, when Mr. Rosenbaum starts to run, the defendant starts to run as well at the same time, as if he's pursuing him. Mr. Rosenbaum could not have possibly have known the defendant is behind him. There's no indication in this record that he knew the defendant was there. It's not an ambush. It's not a situation where he goes there and lays in wait for the defendant. The defendant arrives at that location, and you hear him yell, "Friendly, friendly, friendly," because he's aware of the fact that the people that he's about to confront are hostile to him. And I'm going to show you in a moment the video in which the first thing he does when he arrives at that location is drops the fire extinguisher that he's holding in his left hand so he can raise the gun with his right and left hands and point it. This is when you hear someone, I think the testimony is Rosenbaum, it's not clear to me, but either way, yell, "Gun, gun, gun." And then Mr. Rosenbaum charges around to try and stop the defendant from pointing his gun or shooting anyone. So let's take a look at some of that video. This is Exhibit 73, the full drone video. And as we've pointed out to you before, and Jim will point out to you here in a second on the screen, when the defendant originally arrives at that scene, the first thing you see him do is drop the fire extinguisher and point his weapon at people. And then the chase occurs right after that. And you're going to see that entire sequence of events here on the full drone video. The defendant turns as he's being pursued and points the gun at Mr. Rosenbaum. And then as he enters the area between the parked cars, he slows and turns, and before Mr. Rosenbaum can even come close, he fires at him, shooting and knocking him to the ground. Now I'm going to show you the slowed down and zoomed in video of the defendant when he first gets there. And Mr. Krause is going to help me by directing your attention on the larger screen here to exactly where you will see the defendant. I'm going to replay it a few times so you can see quite clearly that the defendant sets the fire extinguisher on the ground with his left hand and then brings his left hand over to the gun and raises it and points. Guys, check the gun. Make sure it's empty. Under Wisconsin law, you're not allowed to run around and point your gun at people. This is the provocation. This is what starts this incident. The defendant rushes in and immediately points the gun. And as you'll see in a little bit, Mr. Rosenbaum doesn't take kindly to people pointing guns. I don't think anyone does. That's not unusual. No one wants to have the gun pointed at them, and no one wants to watch anyone else do this to someone else. We have the gun. It is in evidence as exhibit number 28. I'm having the detectives check it to make sure that it is safe. The defendant comes running in and drops the fire extinguisher on the ground like this. And then raises his left hand to the gun and points. This is what we see in the video. Him putting the fire extinguisher on the ground and then raising the gun.
Your Honor, I'm going to object. He's facing the wrong direction.
That's an argument.
I'd like to actually have, well, I'll leave it alone.
So what you see in that video is his left arm reaching for the gun, holding it up. You can see it again on the video here. His left arm reaching up towards the gun. That is what provokes this entire incident. And one of the things to keep in mind is that when the defendant provokes the incident, he loses the right to self-defense. You cannot claim self-defense against a danger you create. That's critical right here. If you're the one who is threatening others, you lose the right to claim self-defense.
Have him put the gun, or just have him put on the glove.
Then we have the chase that occurs after that. And we have taken that drone video and we have slowed down portions of that chase for you. So what we have right here on the screen, this is Exhibit 84, and this is the middle portion of that incident. And you can see Mr. Rosenbaum chasing after the defendant, throwing that plastic bag, and then the defendant turns and points the gun back at Mr. Rosenbaum. And this is the moment in time when Mr. Rosenbaum essentially does sort of a little hop with both of his hands in the air. And the defendant has testified. He saw at that moment that there was nothing in the defendant's hand, or in Mr. Rosenbaum's hands. He was unarmed. There's the defendant turning and pointing the gun. Mr. Rosenbaum leaps, his hands out to the air, and then watch here at the end. This is where the shooting occurs. Mr. Rosenbaum is not even within arm's reach when the first shot occurs. I'll play that again. The defendant is pointing the gun at Mr. Rosenbaum. Mr. Rosenbaum raises his arms off to the side. The defendant approaches these cars and slows down, and then turns and shoots Mr. Rosenbaum. Finally, I'm going to play you Exhibit 86. This shows you the final part of that, zoomed in and slowed down. Here's the defendant running in between those parked cars, slowing down, and you can see just how close, or rather how far away, Mr. Rosenbaum was when the defendant shot him.
He was touching the gun almost.
You can see from this video that Mr. Rosenbaum is not even within arm's reach of the defendant when the first shot goes off.
He's right where the barrel of
defendant
the gun
fires
is.
4 shots in quick succession. And I'll come back to this in a moment, but you'll note during this entire sequence, it's the defendant who chooses where to go. He's the one who decides to run where he runs. And he slows down right as he gets to these parked cars. That's what allows Rosenbaum
He can't run through
to
the
get
parked
closer.
cars.
We've seen this on the aerial footage from the FBI, and I want you to see that perspective as well. This is Exhibit 25. This is the annotated aerial footage. You see the defendant approach, running in the same direction as Mr. Rosenbaum. This is where the pointing occurs in the direction of the Zeminskis. You can see Joshua Zeminski's right there on the screen. I'm going to put the cursor over where the Zeminskis are. They're right in there. The defendant is pointing his gun right here, and he's pointing it in the direction of the Zeminskis because they're standing next to that car. And then the chase occurs. Now, what's interesting to me is watch when the crowd starts to run. The crowd's already starting to run here even before the defendant has fired a shot. That's likely because they heard the first shot from Joshua Zeminski, and the crowd starts to run away. The defendant has testified that that shot from Mr. Zeminski had nothing to do with his decision to kill Joseph Rosenbaum, and I'll come back to that in a second. Finally, I'm going to show you this incident from the perspective of Drew Hernandez, because he is behind all of this, and then he comes upon Mr. Rosenbaum's body. Is that audio playing? Why is the audio not playing? Is it coming? I'm not sure why you're not hearing the audio on that. Is Brian around? He's not. All right. Can you text Brian, please? At any rate, for this purpose, I'm sorry? At this point, the defendant has shot and killed Joseph Rosenbaum, and Mr. Rosenbaum is laying face down. That's where he falls. Richie McGinnis actually rolls him over after trying to stem the bleeding here. You can see in the foreground that plastic bag that Mr. Rosenbaum threw on the ground. I don't think there's any dispute. There was nothing harmful in that bag. It was a clear bag containing some clear items.
Objection. There is a dispute what's in that bag.
Then you can make that dispute in your argument.
It's argument, and you'll be allowed to respond.
You can see in this video the crowd is attempting to save Mr. Rosenbaum's life.
Look, the guy's still filming though. Here, let me keep one hand on my camera while I'm trying to save your life. My camera is more important than your fucking life or my live stream, whatever. Did they stop me again?
So, we have shown you the defendant murdering Joseph Rosenbaum from 3 different angles. The drone footage, Drew Hernandez, and also the FBI video. The defendant admitted that during this entire incident, he knew that Joseph Rosenbaum was unarmed. I'm going to come back to this in a little while, but there's this alleged threat that Mr. Rosenbaum made earlier in the evening to kill the defendant. I will debunk that. That did not happen.
Thank you, guys.
It is the one fact in this case the defendant wants you to believe that there's no video of.
Do you mind me
And in
commenting?
fact, I have the video
on
of the
here?
entire incident. I've played it for you, and I'll show it to
Or
you
you want me
again.
to shut the fuck
There's
up?
no threat. There's also no
Bullshit.
evidence that
There's
Mr.
hundreds of
Rosenbaum
people chasing
ever
him.
wanted the defendant's gun. He never said, I'm going to take your gun. He never said, I want your gun. There's no indication of that.
Oh, you said fuck you a
Dr.
million
Kelly
times.
has testified that the first shot that the defendant fired at Joseph Rosenbaum hit the victim in the right pelvis, fracturing it. Mr. Rosenbaum was incapacitated at that point. He is, whatever threat he might have posed, it's over. There is no further threat. He is falling to the ground, and the defendant doesn't stop after that first shot. He tracks Mr. Rosenbaum's body all the way down, firing 3 more shots. A second shot, which goes through Mr. Rosenbaum's hand, and then a third and fourth shot, one that grazes the right scalp and one that goes right into Mr. Rosenbaum's back. And that is the kill shot. That is the one that took Mr. Rosenbaum's life. There is no evidence reaching for the defendant's gun. And after that first shot, there's no way Mr. Rosenbaum could have taken that gun even if he wanted to. He is already falling to the ground. He is helpless. He is vulnerable. And as I said, the kill shot is the one to the back. This is that wound. Dr. Kelly testified that the angle of this shot was from the left shoulder towards the center of the back, and the bullet continued on down towards the right lower back area, tearing through bodily organs and killing Mr. Rosenbaum. Here's a picture of the wound to the hand. There's been a lot of testimony about this wound. This is one in which the evidence suggests that Mr. Rosenbaum's hand was most likely turned in this position, palms outward with his thumb to the ground, when the bullet goes through the area in between his middle finger and his ring finger and penetrates the lower knuckle of the middle finger and the index finger before exiting. Dr. Kelly testified there's soot in that area, suggesting that the hand was close to the end of the defendant's barrel of the AR-15 at the time of that shot.
That means his hand was on it, maybe, too.
The defense wants you to believe it's there because Mr. Rosenbaum is deliberately reaching for the gun. Well, that doesn't make any sense.
Why not?
First of all, this occurs after Mr. Rosenbaum has been shot in the hip and has got a fractured pelvis at that point. He is falling. He is not able to walk. He's probably not even able to control much of his movements at this point. When you're reaching for that gun, this is not the way you're going to do it. This is not going to be effective. I submit to you, ladies and gentlemen, to the extent Mr. Rosenbaum's hand ever got close to the end of the defendant's gun, it was completely inadvertent, not at all intentional. Now, we've heard a lot about the Zeminskis in this case, and I just want to carve them out of this case right now because it's a red herring. It has nothing to do with any of this. There's been some focus on that because I think the defense was hoping they could work this into their self-defense claim and make an argument that that first shot by Joshua Zeminski somehow made the defendant fear for his life. Unfortunately, the defendant wasn't on board with that because in his testimony, he told you that that shot had nothing to do with his thought process. It didn't affect him in any way. He said he didn't think the shot came from Joseph Rosenbaum. He knew Joseph Rosenbaum was unarmed, and he admitted to me, you can't kill Joseph Rosenbaum for something Joshua Zeminski did. So let's just carve Joshua Zeminski out of this case. I'll deal with him on his arson trial in January, But until then,
Sure you will.
it doesn't factor into any of the
It
decisions
was
the
only
defendant made.
arson.
And in fact, as you see on the FBI video, the Zeminskis continue walking straight on down the sidewalk. They don't pursue the defendant. They don't threaten the defendant in any way. Now, the defense wants you to think Joseph Rosenbaum was there to attack the defendant.
He was.
We'll never know what Joseph Rosenbaum was thinking because the defendant killed him. So we're just guessing. But let's assume for a minute, yeah, Joseph Rosenbaum is chasing after the defendant because he wants to do some physical harm to him. He's an unarmed man. This is a bar fight. This is a fist fight. This is a fight that maybe many of you have been involved in. Two people, hand to hand, we're throwing punches, we're pushing, we're shoving, we're whatever. But what you don't do is you don't bring a gun to a fist fight.
What about your witnesses, sir?
What the defendant wants you to believe is that because he's the one who brought the gun, he gets to kill. So I want you to contrast this. Two different scenarios. One scenario where there's two guys who are throwing punches at one another like a bar fight. I think we'd all agree you can't kill someone. You can't punch the guy, knock him to the ground, and then get on him and strangle the life out of him. That's murder. So what's the difference here? The only difference is the defendant brought a gun. He brought his AR-15. That's why he's got to come up with this cockamamie theory that Joseph Rosenbaum was not only going to take the gun, but take it and then turn it on the defendant. And the defendant actually told you that he thought Joseph Rosenbaum was going to take that gun and not only kill him, but kill other people, which is really ironic considering the defendant is the one who killed people in this case and the only one. But putting that aside, they have to convince you that Joseph Rosenbaum was going to take that gun and use it on the defendant because they know you can't claim self-defense against an unarmed man like this. You lose the right to self-defense when you're the one who brought the gun, when you're the one creating the danger, when you're the one provoking other people. The defendant fired 4 shots at Joseph Rosenbaum and caused 5 wounds total. The first shot fractured Joseph Rosenbaum's pelvis. This causes him to be helpless. He is falling face first to the ground and he is vulnerable. The second shot went through his left hand, probably ricocheted off the ground and hit his lower left thigh. It's a flesh wound. I'm sure it hurt, but probably not all that serious. The third and fourth shots are as Mr. Rosenbaum has fallen almost completely to the ground. He's parallel to the ground. He is almost face first to the ground. The defendant fires a round into his upper back, which is the kill shot, and another round which grazes his right scalp. At this point, as you saw in that video, a crowd rushes to that body to try and save Joseph Rosenbaum. They're trying to put clothing on the wound to stop the bleeding. They're going to take him across the street to a hospital. KMH, Frederick South, is literally right across the street. And this crowd, except for the defendant, are all focused on trying to save this person's life. A person, by the way, they probably had never even met before.
Hey, trade for Trump.
Because that's what most people do.
Yeah, I got 7th place in my tournament.
Richie McGinnis testified. I rode with Rosenbaum in the back of that SUV. I told him we'd have a beer together when this was all done. Mr. Rosenbaum was unable to respond. The defendant decided to pull the trigger on his AR-15 4 times. That was his decision. And he is responsible for every bullet that comes out of that gun. He doesn't get a pass by pulling the trigger fast. He could have chosen to stop after the first shot, after the second shot, after the third shot, and assessed whether or not there was still a need to keep firing. But he went 4 times in 0.76 seconds. The defense has made a big point of this, how fast he fired, as if that somehow excuses him. Exactly the opposite, ladies and gentlemen. He controls how quickly he pulls the trigger. He is in control of that decision-making process. No one else made him do that. And this is indicative of someone who doesn't care about the consequences, doesn't care to stop and figure out, am I good? Do I need to stop? Or I'm just going to keep on going. And as I said, he tracks the body all the way to the ground with those second, third, and fourth shots. The only way that you could possibly justify the murder of Joseph Rosenbaum is if you believe that Joseph Rosenbaum was actually reaching for the defendant's gun, and that a reasonable person in the defendant's position with that AR-15 strapped tightly to his chest would think that Joseph Rosenbaum was even capable of taking that gun away as he's falling to the ground with a fractured right pelvis. And then, not only all that, you'd also have to believe that Joseph Rosenbaum was going to turn that gun around and use it to kill the defendant. You have to believe all of those things to justify the murder of Joseph Rosenbaum. That's why the defense is trying so desperately hard to convince you that Joseph Rosenbaum threatened to kill the defendant, which never happened. That's why they're trying so desperately hard to convince you that Joseph Rosenbaum was reaching for that gun. Because if he's not reaching for that gun, and he's not going to use it to kill the defendant, it is not justified. There is no valid self-defense claim. One of the things the judge has instructed you is that when the defendant provokes this situation, he has to exhaust all reasonable means to avoid killing someone. Did he? He didn't have to shoot. He's the one who chose where to run. He chose to run in between those parked cars. He slows down as he gets there. The crowd's already running away. You know, the defense wants to make a point. There's a whole bunch of people over there who are doing stuff to cars, and the defendant had no escape route. The crowd's actually already running away at this point. They've heard the first gunshot from Joshua Zeminski, and they're already starting to scatter. But if you look on the video, there's a huge open space in that lot where the defendant could have circled back around, and he actually does circle back around after killing Rosenbaum, where he could have gotten away. He has to exhaust all reasonable means of escape before killing Mr. Rosenbaum. Your Honor, I do have some more video I want to play. I'm having a little bit of technical problems that I'd like to work on, so I think this would be a good time to pause, if that's okay. Okay, thank you.
All right, please don't talk about the case during the break. Read, watch, or listen to any account. And we will begin again at, it's 1:45 too soon? Did you say 12:45 or 1:45? Oh, well, I thought we'd have it leisurely. No, how about 12:45? Is that a better idea? Let's do that. Please don't talk about the case.
All right, we got to be quiet now. Let's see, what else do we want to do? Boop, 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 boop. Sorry, I was doing something real quick. You guys want to see? I guess. Let's see what. So it's 11:50. Are they taking a lunch? How long of a lunch are they taking? I wonder. What do you guys want to see? They're taking a lunch. I don't know. Should we stay here? Do you guys want to stay here, or do you want to go somewhere else? I know some people. Let's see. I'm gonna leave it running for a few minutes, anyways. Just
all right.
Sometimes we hear shit.
When we get to the point of reducing the number to 12, we have to decide what to do with the other 6. And the alternatives would be to just let them go about their regular business and tell them we might call them if we need them. Or we can keep them here where they can sit and watch daytime TV. I don't know. They have to, obviously, there are limited channels they can watch. And of course, they will not be permitted to talk about the case. So, any preferences?
My preference is to keep them here.
Yes? Okay, we'll do that then. And we'll have to find some way to entertain them. Make sure it doesn't involve some of the channels that are available on the television. Okay.
12:45, Your Honor?
12:45.
12:45. So that's 35 minutes from now. "35 minutes from now." Hold on, I'm entering a code. You know me, I'm multitasking. 2, 3, trying to enter a code real quick. All right, let me go here. Let's go to the new tab then. Let's go to YouTube. We'll go to my channel. All right, now I guess we could watch. Well, Crowder's still alive, huh? Crowder was supposed to do something special today, right? So I wonder what they're doing. Want to see what they're doing?
Just pulling the trigger. 2 people died, 1 was wounded. The whole issue here is self-defense. As the prosecutors try to take that away, that's
CNN.
the defense saying he felt threatened, he was under threat, so he was protecting himself. Grade the prosecutor so far, again, with a ways to go.
Is she going to speak in a bass?
And
No.
also a key point there, not only
Do you like surprises?
self-defense, but provocation, right? That's the
Reggie?
key issue in this case, whether or not prosecutors would be even allowed to argue about provocation, which under
Sexist.
Wisconsin
Hate you.
essentially takes away that self-defense claim. It's a kind of a tricky
My
legal,
right eye was once
burden
Sammy
shift,
Davis
if you will.
Jr.
But I really think, commentators were saying that the
Cuts
prosecution
her
had
like,
upheld
I think you made a great case, man.
Cigarette. She's got big diamond pinky rings.
Once I was afraid, I was petrified.
Mr. Bojangles, any days for you.
Courtroom. The judge sounded like a first-year law student in a criminal exam.
Oh, shut up.
He had like a kind of a stream of consciousness talking to the
Yeah,
jury.
it's called
really
common
think that
sense.
the
called grandpa
He had a stream
energy.
of consciousness. I know that's foreign to you, what with former Vice President Biden on television all the time.
She said he had a stream of consciousness. And
It's
I'm
almost
like,
like he's just talking like a regular person and isn't given.
Looks like
everything
hers
to
just
say.
stopped midstream.
Yeah, she's a drawing of Sean Penn in Fast Times.
But just one half duplicated on the other side.
And hit herself with an off-the-wall sneaker.
It's pretty easy to turn a ringer off in a courtroom when you're at the most
Are
critical
you an
stage of
Easter
a trial.
Island head in a
Dum 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 dum.
Were you built by druids?
Yeah.
This night at the museum
Worshiping
too.
some god that we've all forgotten about.
Is it night at the Wax Museum and it's half melted?
How does that is that just a confusing drama that didn't need to play out?
My
amateur
face?
hour,
Yes.
Or does it impact the jury?
It will impact the jury, John, and
No,
it
it won't.
really was.
There we
kind
go.
of
You scooted
shocking
into the
behavior
middle of
by
the frame.
judge
Thank
because when they had these extensive discussions about the charge,
Sorry, I'm
the
trying
judge
to
was
do
very
to go after
intelligent in
Superman.
analyzing the charge and saying, well, this element has to be explained this way,
This
and this
special is
element
covering
we
the
should
trial for
discuss it
overtime.
another way. But it just fell apart
Yeah. Hey,
when he
Snookies,
started
do I get to
presenting
join
it
you in that
to
shower?
the jury. And there's a way to simplify
That
this,
seems
which
pivotal.
he eventually
Yeah.
discovered, which is you should
Seems
list
kind of important
each
there,
of
Ethan.
the potential
Fell apart
victims here, and essentially
What a
say
stupid comment.
that if
It's when he told the jury what happened that it all just
Well, he's
fell
saying,
apart.
saying it like it is.
He's saying the judge giving instructions to the juries when it all fell apart.
Oh, I thought he said the guy
this
delivering
This
it.
is all criticism of the judge because he had his phone
Okay.
on and made some obviously racist comments. We could all agree on that, right?
Well, I don't know. Asian food, that's racist? I know I can't call it Chinese food.
Well,
Yeah, I
I
know.
can't call it Oriental food
No, you
because
can't.
you guys all make a big stink about that.
Just food, sir.
I'm
Food.
trying to do the right thing there.
He made a
Just
song.
food.
But it's Asian food.
No,
There is.
I
but
mean,
it's just
isn't
food.
it? Is it not in
Very
the
beginning.
continent?
But quenching it in a
Oh, okay, yeah, they always do.
Clothes.
Flower RealDealEddieBlock.com.
I always thought that a press like me could squeeze and hold it in my cheeks like a turtle pea. We please the masses by clenching it in our asses. Tijuana, Mexico, holding it to Tokyo. People know me though. I swear my cheeks always work. It's like I'm about to give birth. Unexpected fun. Oh, you heard? Kamala heard. She said it smelled like dead trout. I tried to blame the dog, but it was on its way out. I didn't know what I was trying to say. Well, it's alright. It's alright. I never know the month, the time of the day. Well, it's alright. It's alright. Here comes the ready or not. You know what brings this podium round. Here comes the ready or not. Holy shit, that was loud. Here comes the ready or not. Oh shit, I think it's about to come out. Here comes the ready or not. Man, I need a towel. Here comes the ready or not. You know what brings this podium round. Here comes the ready or not. Holy shit, that was loud. Here comes the ready or not. Oh shit, I think it's about to come out. Here comes the ready or not. Man, I need a towel.
That's Goldie. I'm still in shock from the intro.
That's
wow.
I mean, it works.
Yeah.
Hit song.
Yeah. We're still on the YouTube,
Shit
right?
song.
We are still on. We are still on.
Today,
Or now.
top 40 shits.
Yeah.
Casey Kasem.
Golden shits.
This one comes in from a request from Al in Schenectady, who has his lover across those cold trucking nights. Poop, featuring Joe Biden. All right.
Is Joe requesting anything? His mind is gone.
Help.
Actually, he's confused. What is he?
I have no idea. All right, look, we are starting late today. Why? Because bring it on up in a little quadrant there, Quarter Black Garrett. We are covering the Rittenhouse, I guess, live stream right now. We've been covering it since the beginning. Seems like people have caught on now, and everyone else has been talking about it.
No,
Oh, it's weird.
everybody
We've been
asked me to
talking
start
about
from
this
the
from the
beginning, so I
get-go.
went to the
I
beginning.
think that your right to self-defense is on trial right now. Let me be really clear about this. I actually am really concerned that they're going to do their closing arguments today. They're going to present them. I'm concerned that this is too much of a layup case. In other words, they're saying, well, wait, he came up and he aimed his gun at you. I really don't think that we want to set the precedent of having to scream friendly, friendly, friendly while people are throwing gas bombs in buildings, running as far away as you can until you run into a barricade, turn around, see a shirtless pedophile telling you that he's going to kill you, hear a gunshot in order for you to be able to defend your life. I think that at the very first moment said someone, I'm going to kill you, click bang. In other words, if someone lunges at you.
Yeah.
I am of the personal belief that if someone throws a gas bomb, a Molotov cocktail into your place of residence or your place of work, that they forfeit the right to live. I'm not saying they deserve to be executed. That's not what I'm saying.
Let's do the
But I'm
Rakita
saying
law.
the second someone puts you in a situation where you could.
I want to do that. Let's do Rakita law because they are doing the. I want to hear their analysis.
Where mistrials tend to happen is some sort of comment made in the closing.
Thank you for suggesting that.
That kind of prejudicial. So you're really, really careful not to introduce that sort of thing. This is where he has to be on his feet and saying, no, that's not what happened. That's not what's in the evidence, because you absolutely can't manufacture evidence at this stage. This is
I'm wondering-
horrifying to watch.
I'm wondering though,
Vivid
just
danger.
to give a little bit of a devil's advocate position here, I guess. You know, he did object one or two times during his during his closing argument so far, and I believe one or both of those times the judge basically responded, "You can address that in your closing argument."
Right.
So I think that he kind of got the message that he said, okay, if I object again to any of this kind of stuff, he's just going to tell me the same thing, and so I might as well reserve it and not. I don't know, annoy the jury.
With objections,
save it.
The problem with objections is that if you overly object to something, it makes it seem like you're afraid of it, right? It's like, it makes it seem like oh my God,
have almost 60,000 people watching him. Wow.
You want to use your objections strategically, but you
I'm
don't
gonna
want to
say
be
hi.
overzealous to make it seem like you're trying to run away from something. But I also think in response to this, I would start putting Binger's credibility on the stand. You know, on the opening,
it goes by
remember
so
when you were
quickly,
told
nobody can see me.
that the evidence was going to show that Rittenhouse was chasing blah blah blah. Guess what? He's just said the opposite, and then so that gives you all of that. You know, you put his credibility to the test because he's saying things different than he earlier said. So now, who are you going to believe? The evidence or the prosecutor? I think that's the way they have to attack.
Gotta believe the evidence.
And the only objection I'm holding against them, the single objection, is on the Zeminski thing, simply because the judge in bright red lights said this is something that's not permissible. So the one objection that I think would have been sustained would have been that one. Otherwise, completely agree with Alita.
Well,
and Nate there. That you
I would have gone with the hand on the barrel. I would have gone with, because you run the risk of getting the judge to say, yeah, that's not exactly what the evidence showed. And in which case, even if you get to respond to it on your rebuttal argument, you still have objected and sowed that seed right
he
there.
said rebuttal.
But for people who are saying, Binger is not persuasive in substance. People just have to appreciate it's what people hate lawyers for, is that they will get up there and they will distort the facts and strawman them for their own position in a charismatic way.
Yeah.
Like when Bill Clinton got up there and said, I did not have sexual relations with that woman. It was charismatic. It was convincing. It was a lie. And that's what made it what it is. And that's what makes it so deceitful. So this is not to compliment Binger. It's just that his demeanor, his presentation gives persuasion to the outright evidentiary fabrications that we are seeing twisted right here. But Richards will have his turn. I disagree with Alita. He could object until he's blue in the face. The judge is probably 99 out of 100 times going to say, rebut when it's your turn to rebut. Let him have his moment now to strawman all he wants.
The two things he had to scream object about, the two are the two that Nate and Legal Minds had covered. The hand in the wrong direction, because that's implying what Rosenbaum was doing and effectively wiping away his right to self-defense in theory, based on the way Binger was presenting it. And it was a fact there's no evidence of that. There was no testimony on it. You have to object on him presenting a claim that is completely unsubstantiated by any of the evidence presented. And secondly, you have to put in there the point about about the Zeminskis. You must object on that. And I respectfully disagree with Alita and any of you or Nate who is saying you can't over object. Those two things, because the Zeminski thing creates the whole provocation. And that is the one thing that is the only way that this case can be saved by the state. You must object to that. And if he overrules you on that objection, allows you to continue, I think that potentially creates an appealable error to reverse the finding. So I don't see sitting back on your hands. And I think we're cutting him too much slack there, because I think that's just his thing, is he always sits on his hands and far too infrequently objects.
I want to add that there's one more point that was particularly egregious, and that was when he stated that the law was that if you bring a gun and the other person doesn't have one, that you lose your right to self-defense. You lose your privilege of self-defense.
That's mine. That he had to be on his feet for.
Yeah,
no self-defense if he's merely armed with his fists. It's like, I don't know. Well, pretty sure that's not the law.
The way that goes.
To me, even in rebuttal, that's, you say, do you really think that in the United States of America, if you have a gun, you've lost the right to defend yourself?
You don't put that on rebuttal, because it's a statement of law. He's contradicting the judge. You say, like, you got to get the objection in there, I think.
I'm trying to live with the strategies that the defense has put forth here.
I don't think that's a viable strategy at this point.
I'm not disagreeing with that.
Can we all say this? We just hope Richards is not closing. If Richards closed, it's going to be a disaster.
Barnes said
Richards is not going to that's going to be a horror show.
Well, the evidence is so bad. I mean, you can get Binger up there to misrepresent it all he wants, and then you're basically having Binger say to the jury, what do you believe, me or your own eyes? I mean, it's He can do it all he wants. He can be wrong on the law. And, going to Ian's point, he can be wrong on the law. And then Richards or Sheriffezy can come and say, he's wrong on the law. And if carrying a gun means you're precluded from invoking self-defense, that's a very bizarre way of viewing self-defense in the United States. So he can effectively rebut those on rebuttal and even have it be more impactful because it will be the last thing that the jury hears in terms of arguments prior to the re-rebuttal, whatever. But it's
the rebuttal goes to the prosecution.
Yes, well, that's what I mean. So you get the closing on the defense, and then Binger will come back and say, "No, he's wrong on me being wrong on the law," and then maybe you get the judge to determine that at some point. But
that's why I attacked Binger in my closing. All these, I'm looking at it from a different perspective. I'm looking at it as all these lies and stuff are good, especially the lies that I can prove for the fact, because my closing is now being written to address all that, right? Remember when he told you that? Guess what? None of the evidence. Remember when he told you that? Guess what? Remember when he told you? And if you go
remember
right
when he tried. Sorry, I'm totally interrupting.
Right, no, exactly.
I was just gonna add in.
And the more you can build up, now you're questioning his credibility. And then we go into Viva's. Are you going to believe him, this guy who's told you all these false things, or are you going to believe your own eyes? Let's look. What happened? You remember when he said that Rittenhouse chased him? Well, look at this. Do you believe him or do you believe your own eyes? Do you believe it? Hey, can you point in this video where you see the Zelenskys? Matter of fact, can you even point to where you see Kyle? Oh, obviously, because it's hard to see. That's why. And I think I would attack Binger, but then I would do it in a way where I go through the evidence and obviously show self-defense. But I'm not sure if Richards is going to do that. But I think Binger has left himself open to that. So even on rebuttal, I think Binger now is going to try to rehabilitate himself rather than rehabilitate his case. I don't know. Again, that's
Binger
my
can
theory.
suck my balls.
Yeah. No, I was going to add in. One of those things, Nate, would that I think would be great would be showing that remember you heard from Mr. De Bruin that they asked him to change his statement. They asked him to change his testimony.
Yep.
And because that was something that they were able to witness for themselves. But yeah, I completely agree with what Nate's saying. That all of that is ripe for them to use.
And I would take it one step further. I love your approach there, Nate. I would take it one step further and say, apparently the state is sitting at a different trial than you and I are sitting at, because we all know what we saw. And this way you sort of make yourself aligned with the jury and get them into thinking the way you're thinking, and that you're both seeing the same trial, that the state is just in la-la land, imagining that they're seeing the Zelenskys there, imagining that they're seeing Kyle there. And that just further, I think, would undercut the state. I love that approach on Nate.
Go ahead.
So for those of you that
We've
show
seen
up
this
tonight,
to be really political from the outset, and I think Nate's exactly right that if
I
you
found
start
some cool
putting it
stuff
on
from
them
my
in terms
mom.
of their credibility, they'd rather
that I'm
save
gonna show you
themselves than
guys
save the
tonight.
conviction here.
On
They spent a
tonight's
whole
show.
lot of
So you guys
time
might wanna
cross-examining on.
make sure
we
you
didn't
see
really
tonight's
tell
show.
you to do that, right? We're actually honorable people.
Not old pictures of me.
They could end up in a situation where their entire rebuttal is actually, no, please don't disbar us, which would be fun.
Yeah, it's again, I don't know if Richards is smart enough to do the tactic, but
Like, I mean, baby
sitting there
pictures
like,
of me.
okay, he's saying all, and just be taking those notes, and I'm assuming they will, but I think this hurts the prosecutor more than it hurts the defense, because like Viva said, it's right there on video.
Yeah.
Oh,
He's trying
and
to
if I
tell you
may,
you're not looking at what you're seeing.
to the point where he says, there's no evidence that Rosenbaum was trying to take his gun. I would just pull up a tweet.
That's what your question is.
Can we hear this?
So your interpretation of what he was trying to do or what he was intending to do or anything along those lines is complete guesswork, isn't it? Well, he said "fuck you" and then he reached for the weapon.
I mean, what you read? You read that in. You read that right in. You say,
Who are you going to
This
believe?
is what Binger said. This is what he said.
Who are you going to believe? Me or our witness that we brought to you? I mean, it's like
No, the prosecution brought to you.
Yeah, his witness.
No, that's what I meant. We brought up our own witness, testified, F you, and reached for the gun. But you don't know what he was thinking. No, I just know what he said and did after he cornered Kyle in some cars where Kyle retreated to. Even if there were provocation in the first place, he still retreated and was chased down.
I have to do more to try to lose the entire chat, because I want to do more of praising the devil here. I always personally like.
Does anybody
the
know what
harder
clampers
position to
are?
fight
What like
from.
e-clampers vitus means?
I like the more difficult position because it
I'm going through my
problem
stuff.
solving. You know, Nick has
Look,
done this. Runkle's done this.
my
Nate has
official
done this. Good
clamper.
Logic has done this.
I
Viva's
belong
done this
to
to
this
some
one is
degree,
Grub
writing
Gulch.
closings or writing portions of closings, because it's relatively
This
easy.
one
The
is the
defense has
Fresno
so
Jim
much to work with. Their
Savage
facts are so
clampers.
great. As we all know, there's so
And
many
then
different
this
ways to
one
write
is,
this, and all the ways they've come up with are great.
Jim
And they're all mutually
Savage.
compatible with each other because the
Jim
defense has so much to
Savage.
work with. What
Oh, this is
makes
Samuel
me
Drake
admire the
George
prosecutor
chapter.
is because they're in a very difficult position. The facts do not support them. So they have to figure out
I
how to
belong to a
solve
lot
the
of
problem.
different
How do
clamp-
I solve the
clamper.
problem of creating something from nothing? Now, on an
But I'm
ethical
picking
level,
up
they
fights.
have to
admirable
do
from
this.
a prosecutor.
These guys are
Well,
boring.
I was saying,
These guys are
well,
boring. Well, clampers are they're historians. It's like a historical club. What we do is we go around and build like monuments. Have any of you guys ever watched oh my gosh, Pawn Stars? If you guys watch Pawn Stars and you know the guy, the beard of knowledge, he is like the number one. He's like a clamper too. He's a historian. You know that's why he's a clamper. I should put him up on the why I should, huh? Watch. Let me show you. Basically, we're just a historian club. We build monuments. Let me see. And you know, we just go around and do stuff like that. It's pretty cool. Like let's see. We always wear red shirts because see it came after the history of mining. And so the miners are so the miners wore red, so that's why we wear red. So if you look at it, you'll always see us wearing red. Like let's see if they show any of the monuments. Okay, like this is a monument. This is a monument. I'm surprised I was at this monument. Oh, you know what? I think I took the picture at this one. You know, but this is a monument that we built. So it procures the history of California. If we build a monument for something, it has to be 100 years or older in history. So you know, this is just, you know, it's also a drinking club. I'm not gonna lie, we like to drink. We also like so this is one of our winners balls. This is not our ball. This is Peter Lebec's. But like they have you come and you dress in the times, right? So this is, you know, the girls wear clothes from, you know, the 1900s, right? We go camping a lot. We call it clamping. Trying to see. Like here's another monument. See, like this is fun. It's funny. All the monuments are built by us. This is Grub Gulch chapter 41, 49. That's my chapter. I didn't even type our chapter in, and most of the pictures I'm finding are ours. Like who's this one? This one is in oh, that's 6029 or 6023. But we just build monuments all across the country, you know, and it tells you different stuff about history. Kind of a cool club, right? Let's see. We also help out veterans. This is probably our fire truck. Yeah, we have a guy at our club that has a fire truck, and so he goes out and like for parades, he does like they did the Fresno parade the other day. It's not that hard to build a monument, especially because we do it so much. And here in Raymond, in our area, we have a marble company that really hooks us up with cheap prices on marble to build the monument. Let's see if they show anything in here. This is our main website. Here's monuments. These are pictures of monuments. Like the chapter of Eclampus Vitus, Grub Gulch 4149 encompasses all of Madera County, included in the links under the heading. Why are they not showing us our? That's funny how they go to ours. They're not showing the monuments though. That's interesting. Wonder what happened to all the monuments. But anyways, there you go. Something about a little bit about me, about Eddie's history. They're still there. We'll turn these guys up. Oh wait, here I'll let a couple people see a little preview. You guys want to see what I looked like when I was a little baby? Hold on. There's Eddie as a baby. What's up, Brownie? There's one of my babies, Brownie. So there. There you go. Donnie's outside getting in trouble. All right, let's put you back on these guys. I don't know. These guys are kind of boring. We got what? They're supposed to be back pretty soon. We have like 12 minutes left, but you know the judge. He's always freaking late. Dude is always late. Now Donnie's trying. Donnie, come here, monster. Sorry if I yelled in your guys' ear. Let me go back to these guys. Let me go check on him before he tries to jump out. Because you know he likes to do that shit.
You know, kicking Kyle in the face, but no one specifically testified to that other than Ted from Huber. So you've got reasonable fear, even from one of the complaining victims. And finally, with Gage, you've got, of course, the amazing correct that went viral when he said,
Right.
you know, he didn't shoot at you until you pulled your gun, stepped towards him, and pointed your gun at his face. Right? Correct. So I mean, you've got all of it.
Oh, they say 12:45.
Most of it
Well, shit.
with video and testimony, and one thing with specifically video. It's
It's not about what you know. It's not about the facts. It's how it's argued, and I think the defense.
If you
needs to
don't
see,
know,
right?
then
And
you
the theme
know.
is, what do you see, but what is being said, or something like that to show the contrast in the facts versus the story.
You know what?
Let me give you the
Damn, I
facts
still
and
got
then
love
at
letters
the
in
end,
here
like
from a
if I say
long time
OJ
ago.
case, we all know the theme. If the glove don't fit, you must acquit, right? That was the theme of that, and everybody. And if I just say that one line, everybody knows OJ, right? And you get that with every great case where you get a nice acquittal, is because the defense gives you this theme that you can take into the jury room, and then eventually one of those jurors is going to say it. Well, do we believe?
Does
what
anybody
we see,
still
or
have
do we
love
believe what he
letters
tells
from
us?
one time
Something
ago?
like that, so they can hang that hat
Or
on.
am I
and
the
say,
only
you know,
one?
This is it's obvious what it is.
I got it, because
Yeah,
I
these guys
know
are
Johnny
boring.
Cochran would have gotten Rosenbaum's priors in. So
Here, you guys are talking about when I was at the riots last time. Hold on. Donnie, don't you think about it. Come here, monster. He's looking at that fence like he wants to jump over. I found some bigger fence here on the property, so I don't even have to buy none. AG, whoops. Henny pin. Hopefully I put the 360 video up. Did I do it in 360? I did not, do I? Did I? Is this 360? Interesting. I guess I don't have the 360 footage. This was on my way there. Hurting your ears? Ladies and gentlemen, this is junkies. I must have really bad service there. I hardly ever watch. Do I stream gaming? No, I don't play games. Sorry, but I don't play video games. Man, we're doing the trial right now. We're just on break. Oh, that's right. I did have. I want to show that building. I wasn't trying to get in your shot. I'm sorry. So when I was in the middle. Can we get to a better spot? I'm buffering right here. You know, let me show you my own footage. I don't think I have it on my hard drive anymore. Shit. Let's go to the other footage. Let's see if it's better. This is the hour-long one. It's just as bad. Hey everybody, don't forget to help me out. I'm trying to buy a live view. I finally got my live view. So hopefully that won't happen anymore. You want me to show you when I was right down there in the middle of shit?
Thank you. Take care.
You want me to show people the water bottle one?
Just make sure to get you.
Yeah. Well, this was me right in the middle of everybody. Here we go, I'll show you more. Exactly, guys. Look, how many people have this shot right here, right? Like I was right up in the front. Is there any other Patriot? Sorry, I'm covering the mic so I can talk quietly. Is there any other Patriot that's here getting this good of footage? I don't think so. So if I got to take some pictures with some people, Because I'm taking pictures of some people. That's George Floyd's girlfriend in the red right there.
Oh, you're good. You're all good. I just felt in the back there. I was like, oh.
I'm always in the middle, I know, right?
Everybody hear him? He's about to stop.
I wasn't going to say that when I was there, though.
Good afternoon, everybody. My name is Mohammed Ibrahim. That's Mohammed.
Hold on, you want to see something funny? I even got this guy who's like the head, he was like the head Democrat person. Look right here. See this guy? I get this guy to take a picture with me. People are like, why are you taking a picture with him? I'm like, good.
A picture with you real quick?
Later
Just saying hi.
Look, I wanted to go and put this picture up on Twitter saying, look, this guy's hanging out with EddieBlockFilms. Freaking, look at the Democrat hanging out with the white supremacist. Because, you know, they like to call me white supremacist. They were hunting for me. Watch. Let's go to Twitter. Let's see, Twitter. Search. What day was that? Eddie Block. Hold on. They're always searching for me. Eddie Block. Let's see. Right now it's going to be a whole bunch of junks. Christopher Brow participated in the attack on. Look, they're already talking. They're talking about me right here, even with met with Proud Boys in D.C. This is an hour ago. Well, that's from me. Eddie Block, and then let me type in Hennepin. I think that's where. No. What day was that? Let's see. So we're just gonna have to go find April 20th. Where's that? It's gonna take forever to find April 20th. Let's see. Let's see what people are talking about me. What's this one? Oh, they're showing how I got to meet
Yeah, that was Alex Jones.
Alex Jones.
Sorry.
That's me taking a picture with Alex Jones. They're trying to show that. Let's see. What's this? Mr. Nice Guy. Let's see. By the way, they still prefer the old too little too late approach to OPSEC in the Eddie Block sector. What are they talking about? And it's funny, they're showing them raiding my house again. They haven't raided my house in so long. What did they exactly say? They said like get him or something. Let's see if I can go all the way down here. Oh, and of course they got to show when I got a DUI. You know what? People have issues in their life. Things happen. I'm not the first person to have an issue in my life, and I don't think I'll be the last, right? As long as you learn from your issues, that's all that matters. Let's see. Portland Proud Boys Cake Party. They're showing. Oh, this is who I forget. That's Portland Andy. Portland Andy was hanging out with me in Portland. So we still got to go way back. We got to go back to April. Yeah, I got a DUI, but you know what? I had full coverage insurance. Actually, what happened is, to be honest with you guys, I fell asleep. I was running for county supervisor. I found out my wife was cheating on me. I hadn't slept in like a week. I was stressing out. You know, things were not going good for me. And it is what it is. And to be honest, you want to know what? You want to know how I haven't even it's been over a year and a half. It was last January. So 2020, before all this bad stuff happened. And you know what? I haven't been taken to court. They haven't charged me. So that shows you that it wasn't really a DUI, that even the government knows that I fell asleep. Jennifer, April, May. Oh, so April, I got to go back more. So, I mean, if it was a real DUI and they had enough evidence, don't you think the courts would have taken me to jail? I mean, taken me to court already? right? Especially somebody running for county supervisor who's well known like me. I think they would have definitely taken me to court already. Eddie Block isn't pictured here. Both right side photos are of behind enemy lines. Here's a picture of enemy. Oh yeah, so this is them trying to go get me. Here we go. Yeah, behind enemy lines. That's my buddy. So let's see. Congratulate for being. Let's see, Dave. Left Coast Right Watch. Yeah, there's is that right here. It is. Primetime Patriot is there too. Think they already got called. That is Eddie Block in the frame. Here's where they're trying to tell us. Where is it? Something to be aware of. Eddie Block is a streamer, associates with the Piss Boys. He's currently in Minneapolis. Go say hi and give a big fuck you to Eddie Block over there trying to be super spy for the Patriots. There we go. Where's that Proud Boy streamer? Eddie Block is in your town right now with this camera. Keep your eyes open for this right-wing fuckwad Eddie Block. He's live streaming. Thanks for the tip. Let's see. Let's see. They're showing pictures of me so people can find me. Oh no, they found a picture of me with Alex Jones. I don't know why they keep showing it. Anyways, they like talking about me on Twitter. What are they talking about? Oh, now they're talking about that Huntington Beach fight. Anyways.
Hi. Hey, how are you, buddy? Right on. Thank you, sir.
I had my mic turned up way too loud on that.
But now you do too. During the funeral of George Floyd, I had the privilege to spend the day with Martin Luther King III, the son of the late Dr. King Jr. and his family.
Want to see his girlfriend
Martin
talking?
Luther King Jr., a civil rights icon,
I think she
who
talked
freely
first.
gave his life to teach the world that dreaming was
I
possible.
think she talked after this.
And in that
Only 4. Now we've got 2. 2 is the number of cops.
Here's her talking.
This to me has been like a sign from Floyd. I've seen the sun shining. I've seen the
Mr. Nice Guy, yeah, they mentioned you in one. I don't know what they said. Probably because your songs are, you made my songs.
I love Minneapolis so much. Floyd,
Now I'm sitting, this is right about, let's see, right now I'm sitting there.
Sorry, guys.
Hold on. So I'm sitting here in the middle of that, right? And I think it was Mr. Nice Guy. Mr. Nice Guy, was it you? You started texting me and you're like, hey, Eddie, they're fucking looking for you. And so I'm like watching it. I'm like, uh-oh. And then so I stayed there for a little bit longer. And then I was like, I better get the fuck out of here.
Guilty.
Doesn't mind if I sneak through here? Sorry, guys. Excuse me. Excuse me, ma'am. I'm gonna sneak right by you. Sorry. Excuse me, sir. Can I get by you? I don't want to run over your foot, bro.
Yeah, somebody was like, Eddie, you need to get out of here.
Can I get right by you?
And the fact that somebody said Ty Hill had already gone back.
How do you say sorry? How do you say sorry?
I was
sorry.
told-
Okay, thank you. All right, guys.
On this day, I was totally the fuck. I was there with Ty Hill, right? And then me and Ty got separated. And then Polish American Brotherhood was there, but she was all in Black Bloc, so she was safe, right? But I had my EddieBlockFilms sweater on, and you know. Where are you at? I'm on my scooter. It's not like you can't tell who I am on my scooter.
All right, guys. That was the girlfriend. I'm gonna get out of here for a little bit. I just got a text message that they found out who I was and they're looking for me. So I'm gonna try and get out of here while it's still safe, if you know what I mean. All right, guys. So I'm gonna turn the comments off because I'm about to go through a big crowd. Hold on, let me turn it around. All right, guys. Excuse me, sir. Excuse me, folks.
Excuse me. Now here's the other thing. I just gotta say something real quick. So there was a whole bunch of fellow streamers there that day, fellow conservative streamers. The only 3 that actually showed up right there in front of the courthouse at as the jury was announcing their verdict was me, Taiho, and Polish American Brotherhood. Not one other single person was out there streaming from the right side that were distinguishable or that I knew. Right? There was 3 streamers in particular that I know was in town that was talking shit about me, but I didn't see them there. Maybe I'm wrong and maybe they were, but you guys know who I'm talking about, and I don't think they were there at the courthouse that day. I know Jake from Behind Enemy Lines and Part-Time Patriot. They were stuck over at Cut Foods where the actual incident happened because nobody thought the jury was going to come out at that time. But the other people I know had a hotel room right by there and the car, so I don't understand why they weren't there. Just so you know.
I see you with the screw.
Are they back already? I'm back. I'm still here. They're not back yet. They're not back yet. Yeah, it would have been curtains for them, but it's funny. I'm in a wheelchair. I'm on my scooter. Everybody knows who. If you know who I am, you know how to find me. It's easy. And with people going on Twitter saying, "Hey, go get Eddie," you know what I mean? But yet, I was out there.
Alright, I can see comments now. Alright, guys. I turned the comments back on. Sorry, guys. I got a text message.
I just bought this microphone, so that's why it's really loud. I wasn't used to the sound levels.
That they know who I am, and they're coming for me, so... Excuse me. Hold on. You know, I do some... Whoa, sorry.
We're just on hold.
So I do some stupid shit. I do some real stupid shit, folks, but I'm not doing that stupid shit. You know what I mean?
Okay. No, I had a.
I was on CNN.
Or no, I didn't. San Jose Sharks mask.
All right, guys, I'm gonna turn it back around on me.
Probably should have been wearing.
All right, guys. Yeah, like I said, I do a lot of stupid shit, but I'm not gonna be that stupid to where I'm sitting right the frick down there when somebody says they're coming after me. I'll be back out though. I'm gonna just take a break, go to the bathroom.
Watch this guy got attacked. See him? He's all
right, sir?
Somebody just beat him up.
You see
and
that?
saw
That
the
guy
very
got
end
tore
of it.
up. Is Terrace still alive?
They just started their closing arguments.
Where is the National Guard now? They're not siding with Derek Chauvin now, are they? No, they're not. They're just sitting up there like good little boys and girls.
I actually have 360 footage of this too.
Hey, is Terrace still out here, guys? Yeah, that dude's bleeding. That dude had somebody hit him. You know what? I'm gonna do something. Hold on. Hold on.
A lot of people get kicked off of YouTube, Facebook. They're all commies.
Alright, guys, this is what I want to do here.
The National Guard has taken themselves. They have the police.
Yeah, I had footage from the night before too. Unfortunately, I don't get to go to Kenosha this time. That poor dog owned by a liberal. I was trying to get like some, you know, cool
Sorry,
stuff.
I'm just getting some footage.
I should have signed the wall. I should have put All Lives Matter on the wall, huh?
Fuck, I forgot what else.
Never even thought about it.
That's why I'm doubling back too, folks. Going back and forth, back and forth. Hey, is Tara still out on this side? Is Tara still on 3rd Street?
Somebody wrote I just saw a video of a bunch of them beating up white people. Yeah, you got people outside
Alright,
the
guys,
courthouse.
I'm heading to
Mr.
my
Nice
hotel.
Guy.
I'm gonna end this live feed right now. I'm gonna go get the heck out of here, go warm up for a little bit, but I'll go live again when I get to my hotel room, and I'll do a live show from my hotel room talking about what I saw. How about that?
Oh yeah, I ended it right there. But I actually had people. Yeah, Mr. Nice Guy, if you got a link, send me the link. Send me the link, bro. We'll watch that.
Drawing this from is Day versus State.
Are they back now?
It's
Let's see, they're still not back yet. They no back yet. They are not back yet. Let's see, what else can I... What was this one? What video was this?
Alright, we're live. I found where I gotta go, guys.
I was hanging out with Primetime Patriot. Oh no.
Hey, I just got a message on...
Oh, this is when I went to... I was actually going to...
We got tons of back express, guys.
What's that place? I was down to City
This is Brooklyn Center.
Brooklyn Center.
Hey, Polish, where you at, girl? I'm here.
I was calling out people.
Wall Street. Oh, hold on. Street.
I was kind of lost, but I was at Brooklyn Center where all
and
the shit
died
went
at
down.
41 years old to protect this fucking country, and I'm...
People were threatening me here too. Watch. Listen to me. I got really stupid here. I'm all alone at Brooklyn Center, which is where all the shit went down.
This is what real men fucking do, assholes. I don't care anymore. I'm sick and tired of fucking you fucking people trying to take over our goddamn country and ruin it. My dad fought in the Air Force in fucking Vietnam and died at 41 years old to protect this fucking country, and I'm handicapped because he did that shit. So you know what? I got every right to fucking stand up here and be a man and show these motherfuckers what's up. Look, Walmart's totally boarded up.
This is where the riot was the night before.
Walmart is totally boarded up. Because you know what? My dad and millions of other people fought for this fucking country, so you guys could have the rights to go out there and fucking loot and riot. Right? So if I have to lose my life to protect my goddamn country like my dad did, so be it, bitches. Bring it on.
Oh, my audio was off. My audio was way off.
Do I see the wing stop? I thought I saw a wing stop. I don't know where it went. But yeah, everything is fucking just bored. Excuse my language. I'm sorry, guys. Little trolls are pissing me off tonight. I hate to see the person that fucking actually steps up to me tonight because I'm so pissed off and I got so much adrenaline rushing through my system right now.
People are actually...
You know, fuck the police. I'm right here. How about this? I'm here. There's no cops around. Look, this place is fucking empty.
Where I am.
You want to talk shit? Fuck the police? Here's where I am. Come find me. Come find me, motherfucker. Because I know you won't, because you're being a little bitch. Because if you were really down there at the fucking police station, you wouldn't be on my channel watching this shit right now. That's what I thought, bro. At least I'm out here.
Oh my gosh, this was hilarious. I do some stupid shit sometimes.
What is DTLR? Down to, you know what DTS means. I'm not seeing, let's see. Wingstop. I'm not seeing the Wingstop, guys. Thank you, Future. Yo, T, I'm here for the rest of for a couple more days.
Oh wait, hold on, you just sent it to me.
Anybody ever watch
right,
Clerks, the movie? Remember Clerks? Had to put that big old sign up there. We are open.
We're gonna break on this.
Oh, they're saying the trial is back now?
I gotta go underneath the freeway. Single Creek Road will get you to the police station. All right.
Is that live? No,
And I gotta find Single
that
Creek
link you
Road.
sent me
I'll go ask
doesn't
the
work,
security
Mr.
guards.
Nice
How about
Guy.
that?
That link you sent me doesn't work. You sent me to a court thing. You want to see what the link you sent me what to?
Let's see. I'm gonna show you guys the stuff. So TJ Maxx store is currently closed until further notice.
Hold on. The link you sent me to, Mr. Nice Guy, is this. Where's my history?
You see Dustin on his wheelchair coming.
This is the link you sent me, Mr. Nice Guy.
Dustin runs for me, guys.
Behind.
Dustin already told me he won't fight me. He said he's gonna run away from me.
Yeah, that's what you
because he knows
sent me,
I'm
bud.
stronger than him. What store is? Oh, this must be TJ Maxx.
But yeah, I was sitting here
Bass
calling
Lake Road.
these
That's
fuckers out.
Think about it. There's places.
Then I got back on the bus and took the bus back. Eddie, don't fuck around. Let's see. Let's watch this one again. This one's always funny.
Fuck off! Much him doing all that. And I just.
Hey, it's a wannabe Colin Kaepernick. Fuck off! Fuck off!
Hey,
Sorry. What are you doing, bro? You in my way. Sorry, you in my way, bro. You in my way. You ran right in me. Sorry, bro.
And every time I said sorry, I hit the gas.
You saw that, right? You see that? Yeah.
You know what? I guess maybe we can look on Facebook, huh? Let us look. I don't think there's gonna be people outside yet. Do you? Only reason I think that is because it's still too early. I don't think the jury's gonna do anything today. I really don't. Let's see. Crowder's still alive. Chicago Scanner. Is this guy maybe? Maybe over there? Oh, that's just a scanner. That's just a scanner. Let's see. I'm looking, guys. I don't see anything. Let's go to Facebook. Sometimes Facebook. Let's see. Search Facebook live streams. Because there's like a special way you can do it. There's a certain way you can do it. How do I find live videos on Facebook? Like, because they changed it now. Click on live. Let's see. From your newsfeed, click watch on the left. Then click live before watching the left. Okay, let's try it. You guys can add me on Facebook, by the way, if you want. It's called Thrift. It's my ex-wife's old business page, but it's Thrift. The only way I can put my name is there is put as a middle name. So it's Thrift EddieBlock BNB. If you want to find me. All right, so let's go to watch. Oh, there's live. Oh, there we go. Oh, is this outside? No way, Linda's there? Or
They will censor dissent, shame those who stand up. Nothing is off limits. They seek to enforce a one-size-fits-all solution and hold your children's education hostage. Among us, there's many questions here today, but the question is how to stand courageously in this terrifying point in our history. I admit, and I admit myself, it's tempting to use the powerful motive of hate.
I don't want to text her because it'll end
Scripture
her stream.
makes it clear. Hating our brothers will leave us blinded in darkness. We will lack the discernment needed to wisely step forward. Let me suggest the strongest motive we have here today lies in our love for one another, our love for our communities, and our love for our families. Ultimately, this is in obedience to the God we will answer to, not the government, what our life has done. I believe this is the key to the courage that we need to do what's right in the face of such opposition. So as we fight for political victory today, remember, history promises us there will be no end to the chaos in this world. But we also know that it's in dark times such as these that character is revealed.
That's right.
And our light shines the brightest.
Yes.
It's in these times where we must walk boldly in the truth God has put on our heart, no matter the consequence.
That's right. 100%.
This is your victorious act of courage. This is the example that you will pass on to your children.
I can't play it right now, Mr.
This
Nice
is a
Guy,
gift
because
the
it'll
world
come through
cannot
the
touch.
audio. I'll watch it after
So
the show,
students
bud.
and teachers, remember this as you stand in the center of the storm on your campus. Parents, remember this as you protest, when you speak at board meetings, and when you encourage your children to stand with courage and with humility. Administrators.
Live now. Filters. Let's do turn live on. Okay. So we're searching for Kenosha. I hate Facebook video though, because it's such shitty video. It's always shitty video. So I'm not seeing anybody outside right now. Maybe there's no action going on. I wish I was there. I really do, but I don't have a way to get there right now. I can't fly because I got Donnie. I don't know if the paperwork that I have I think you have to send it ahead of time for your service dog paperwork. He gets to fly for free, but I can already hear the shit they're going to give me. You got a 120-pound freaking service dog? It's like, yeah, he's for my protection. Right? And the other thing is, I don't know if I want to take Donnie to events like this, you know? Share your flyer from tonight. All right, did you send it to me again? Let me look for your flyer. Your flyer from tonight. Your flyer from tonight. Let me find it. The showdown one, is that the one you're talking about? Is this tonight? Yep, it is. Okay, hold on. Let me plug my phone in, guys. I'll show you what Mr. Nice Guy's talking about. They got this going on. Hold on. He'll be live on. I don't have Instagram anymore. Shit, maybe I can get Instagram again. When they kicked me off of Facebook, I lost my Instagram. Let me show my phone. That's not my phone. That's me. Here we go. All right, let me make this bigger. That's what she said. This is it's called a school board showdown. You can't see the whole clip for some reason. These phones don't show it right. It says all parents need to stand against the pedophiles indoctrination that's happening in our children's schools. Downers Grove North High School, 4436 Main Street, Downers Grove, Illinois, tonight at 6 p.m. Mr. Nice Guy's gonna be there. Whoa, look at that picture. Holy jeez Louise. I gotta make that smaller. I'm sorry, Mr. Nice Guy. That's disgusting. I can't believe they're teaching our kids that shit. You know what I mean? I just can't believe that shit. What's up, Donnie? You finally came inside? You guys want to see the monster while we're waiting? Monster's right here. Come here, monster. Hey, Bubba, say hi. Say hi. Oh, there's a big old monster, huh? What do you think? He's good at staring down. He always beats me. He always beats me at the stare down, huh? Huh? You always wanted to stare down? Anyway, so I don't know. Dude, I found some more Patriot bucks. So for Christmas, I don't have to buy as many this time. All right, they're coming back. Yay! We're back. They're calling the jury in. Hold on. We got to do this again.
It's time!
No, I like that one. Wait, we got to do this one then, too.
Let's get ready to rumble!
There we go. Should we play this one, too, while we're waiting? I downloaded a whole bunch of new ones. Then, of course, we always got my opening song.
Yo, it's the Eddie Block Show. Drunk uncle on the side, ready, let's go. Hey, it's the Eddie Block Show. If you agree or disagree, let them know.
Did I get a copyright strike again?
Drunk uncle, drink more. Yo, it's the Eddie.
Hold on, wait a minute. Am I in trouble again? Did I get in trouble? Can you guys hear me?
He was only a good vice president because he understood how to kiss Barack Obama's ass.
Am I still on? Nobody's answering me. Shoot. Where did I get in trouble? Oh, we're good on both sides so far? Okay, thank you. Oh, Donnie's barking. I gotta get him inside because it's about time for the FedEx to show up.
Thank you, Judge. Good afternoon, ladies and gentlemen. I'm going to continue on. I hope your full stomachs won't distract you too much from the presentation here.
And I'm going to get some freeze-dried
So
mangoes.
I had been talking about the murder of Joseph Rosenbaum. And as you can tell, I'm trying to go in chronological order. I'm trying to go through these events in a way that makes the most sense. So count one of the information is with regard to Joseph Rosenbaum. The second count of the information pertains to Richie McGinnis, who you heard testify. He testified that he was in the line of fire behind Joseph Rosenbaum as the defendant fires 4 rounds with his AR-15, which is loaded with full metal jacket ammunition. And I'll talk a little bit more about that type of ammunition in a little bit. But you've heard testimony that it's the type of ammunition that is capable of going through body armor. It is capable of going through a squad car. It is designed to go through the target and continue flying on for up to 550 yards. Richard McGinnis testified that when those shots went off, he thought he had been hit. He thought his life was in danger. One of the rules that I think most people who are familiar with firearms knows is always check your background.
They ate it.
Meaning know what's around your target and know what's behind your target. This is true when you're hunting, it's true when you're target shooting, and obviously it's true when you've got an AR-15 in downtown Kenosha in the middle of protests with houses and people nearby. But there's no indication the defendant cared one bit about his background, cared one bit about where those bullets were going to go, and as I said, he put Richie McGinnis in danger. Richie McGinnis, after this incident you've seen on the videos, goes to try and help Joseph Rosenbaum, and has his own video shows when he first gets there, he finds Mr. Rosenbaum's body face down on the ground.
Once again, I hear that song in my head.
And I'm going to play this exhibit 15 for you.
You okay? Just don't move, man. Don't move. All right, can I flip you over real quick? Oh. I'm gonna flip you over real quick, bro.
Stopped again?
Just gotta get pressure on this, dude. Where's it at? Turn it off. Where's it at, dude? Get a light on it. Get a light. Give me a fucking light. Where? Where, dude? Where? Where's the hole? Get the fucking mask up.
Put pressure, put pressure, put pressure. Keep your eyes open, keep your eyes open. You shot him.
I didn't let it go. Just make pressure on this shit. We gotta keep alive. I got it. Listen to me. Listen to me. Listen to me. Y'all thinking the hospital right here. Get him out. Get him out. He's not quiet. Don't keep pressure on him. I got him. Get him. I got him. Keep pressure on him. Get his arms. Get his arms. Get that down. I got you.
You want to talk about medics? You want to talk about people who care? You want to talk about people who are there trying to help? You just heard them and you just saw them. People who didn't know Joseph Rosenbaum. They just knew somebody needed help.
Well, my pit bull
And
doesn't
while
like
that's
it
going
now.
on, the defendant flees,
Wouldn't you?
callously disregarding the body of the man that he just shot and killed. And as he's running off, he's lying to the crowd
Wouldn't
about
you?
what just happened. This is exhibit number 12.
Panda, don't growl at Donnie. If you're not going to eat your snack, then don't growl at him. I'm trying to take it.
So there were just like 6 shots. It went off.
The defendant says he pulled a gun. That statement, he pulled a gun, was a lie. It's not true. The defendant knew it wasn't true.
Bullshit.
He's lying to the crowd as he's running away. Joseph Rosenbaum didn't have a gun. The defendant knew he didn't have a gun.
No, he didn't.
The defendant is lying to save his own skin instead of going and trying to help the person that he has just shot and killed. In exhibit number 3, Gage Grosskreuz's Facebook Live video, he tells a similar lie. As they're running, Mr. Grosskreutz asks the defendant, "Did you just shoot someone?" And the defendant says something about the police and then says, "I did not shoot anyone." And this is similar to the lie that he told Jason Lukowski at exactly that same time. As
Dude,
he passes
if
Mr.
people were chasing
Lukowski,
you down, you would
he
say the
says,
same
"I
fucking
did not shoot anyone." And that was established through Mr. Lukowski's testimony. And again, I think it's worth emphasizing at this point that Jason Lukowski had just met the defendant maybe an hour. This is about 11:50 at night. Mr. Lukowski got there about 10:45. This is Gage Grosskreutz running towards danger, running to try and help. This is exhibit number 3.
Hey, what are you doing? You shot somebody? Who shot? Who shot? Hey, what are you doing? You shot somebody? Who shot? Who shot?
Listen to the second thing he says.
You shot somebody? Who shot? Who shot? Hey, what are you doing? You shot somebody?
He's scared, of course.
Who shot?
It's hard to tell what his exact words are. I hear the word "not."
I'm back again. Yeah, I'm back.
Pretty clearly in there, as in I did not shoot anyone. I did not do anything. Jason Lukowski, he lies to. The crowd, he lies to. Gage Grosskreutz, he lies to. So at this point, the crowd is dealing with what they perceive to be an active shooter. Someone who has just shot someone, who is still in possession of the gun, who is fleeing the scene, and how are we supposed to know where he's going next?
No, that's just my restream.
You know, all night that night,
Restream just a chat.
the crowd has been hearing the sound of gunshots. They've been hearing fireworks, firecrackers. But now, someone actually has been shot. The crowd sees the defendant running with a gun. He's lying to them. He still has the gun. He's shot someone. This is provocation to them. This is someone who has committed a criminal act and is putting people in danger. It is entirely reasonable for that crowd to believe at that moment that he is a threat to kill again. The defendant could have made it unequivocally clear what he was doing. He could have stayed at Mr. Rosenbaum's body, helped protect him, helped preserve his life, call 911. As he's running, he could have announced to the crowd exactly what he was doing, told them. He could have fired warning shots to try and keep him away. He could have dropped the gun. He could have raised his hands and surrendered. He could have signaled to this crowd that he did not pose a threat anymore. But everything he does is indicative of someone who is still a threat. Now, the defendant is going to tell you he wasn't. But from the crowd's perspective, how are they supposed to know any different? He does nothing to demonstrate to the crowd that he isn't a threat to kill again. And it turns out he does. It turns out within a few seconds, he does kill again. I submit to you, ladies and gentlemen, that in this situation, the crowd has the right to try and stop an active shooter. They have a right to protect themselves. The defendant is not the only one in the world who has the right to self-defense. But what does the crowd do to try and stop the defendant? I submit to you, and this is not a criticism of them, but they use almost the least minimal, least intrusive means possible.
Kicking him in the face?
They could have used deadly force against him. They could have shot at him. But instead, somebody comes up behind him and knocks his hat off. Anthony Huber comes up with a skateboard and the defendant blocks it with his arm. And then the defendant falls to the ground on his own. No one knocked him down.
Really?
This man that the defense wants to call jump kick man. He's got no weapons, no gun, no knife, no nothing.
His foot is a weapon.
Comes in and tries to kick the defendant in the face. Anthony Huber comes back and tries to grab the gun. Actually does grab the defendant's gun and tries to pull it away because he's trying to disarm an active shooter. And Gage Grosskreutz comes running in, stops with his hands up in the air until he sees and hears the defendant adjusting his weapon as if preparing to fire again. And then what does Gage Grosskreutz do? He reaches for the gun to try and disarm the defendant. Gage Grosskreutz had his own gun in his own hand. He could have aimed it and fired at the defendant, but he did not. And you heard Gage Grosskreutz testify about that, about how that is a decision that he was not prepared to make at that point in time. He is not the type of person who is just willing to take someone's life in an instant, unlike the defendant, who took 2 lives that night, very quickly and seemingly very easily. There is a video, Exhibit 5, which is the BG on the scene video, which traces this entire incident, which we call the second event. This is going to show you Mr. Huber, Mr. Grosskreutz, and the other individuals who are trying to stop an active shooter using what I would characterize as the least intrusive means possible.
Ooh, I like that 3P Patriot. That's good.
Someone knocks his hat off. Anthony Huber comes in with a skateboard. In just a few seconds, the defendant kills one person, attempts to kill 2 more, and blows off Gage Grosskreitz's arm. It's that fast. This is someone who has no remorse, no regard for life, only cares about himself. And these folks that are coming at him, the jump kick man, Anthony Huber, aren't armed. They're not a credible, imminent threat to his life. They are trying to stop an active shooter. And they have a right to do so. Imagine if the crowd couldn't do that. Imagine if they weren't allowed to try and stop someone in this type of situation. After killing Anthony Huber, after severely wounding Gage Grosskreutz, the defendant walks away like he's some sort of hero in a Western. Without a care in the world for anything he's just done. You know, it's interesting. This occurs about a block away from the police line, right down the road. If the defendant's so concerned about his safety, the police are right there. And in fact, they pull up to this scene almost instantly. The defendant's got his medic bag on. He proclaims himself a medic. He doesn't know at this point if Anthony Huber's dead or alive or capable of being saved. And yet the defendant offers no assistance, makes no attempt to try and help anyone else. All he cares about is himself. We have taken that video and we have broken it down into individual frames. And I want to take you through, frame by frame, the incident with Gage Grosskreutz. Because a lot has been made about Mr. Grosskreutz's motions and what he does and where he goes and things like that. So I think it's helpful for us to take a look at this. So this is Exhibit 80, beginning with frame 356. At this point, you can see that Anthony Huber is staggering off after being shot in the chest. The wound has entered his lower left rib cage and has wound up almost exiting near his right shoulder. It has ripped through his ribs, his heart, his aorta, and he may not technically be dead, but he's going to be dead within a few seconds. He is stumbling away. The defendant has the weapon pointed towards Gage Grosskreutz here, who is cowering, hovering, hiding, covering his head, trying to stay out of the way. And I'm going to go frame by frame here slowly as we see the movement. Now we see the gun is moving down towards Gage Grosskreutz. It is pointed directly at him from a distance of just a couple of feet. Gage Grosskreutz has his right leg planted as if he's pushing backwards, trying to get away. The gun is still pointed at him. The defendant here is going to adjust the gun, turn it over as if he's making some sort of adjustment on it. Gage Grosskreutz testified that this was a movement that he interpreted as the defendant preparing that gun as if it was going to fire again, as if clearing a jammed round so that he could shoot it at Mr. Grosskreutz. At this point, Mr. Grosskreutz is, I think, probably thinking to himself, if I can get away, I will, until he realizes that the defendant is getting ready to fire again. In none of these frames is Mr. Grosskreutz's right hand with his Glock pistol pointed at the defendant. You can see Mr. Grosskreutz is actually backing up with his right leg. Let me go back a couple of frames here. This is frame 444. You can see his right foot is on the ground, but it's starting to move back. Now as I move forward in the frames, 447, his right leg is moved back. This is someone who is about to retreat. His hands are in the air. He's backing away from the defendant until, as he's testified, he sees the defendant start to manipulate that gun in such a way that it makes Mr. Grosskreutz feel like he's about to be shot. And only then does he take action. What action does Mr. Grosskreutz take? Does he hold that gun with both hands, the Glock that he's got, and point it at the defendant? No, never. Does he even take the gun with one hand and point it? No, never. Instead, you can see him start to lunge in with his left arm forward. The gun is not in this hand. The gun is in his right hand. He's lunging forward, reaching for the defendant. Probably reaching for the gun. Probably trying to block the gun. You can see now he's going to take a step with his right leg across the defendant's body. Not directly towards the defendant, but across the defendant's body. As he's reaching in, almost swiping away at that gun with his left arm. He has bladed his body in such a way as to try and present as minimal of a target as possible, which is probably what saves his life. His right leg is about to hit the ground here. The gun, the AR-15, is pointed directly at him from just 2, maybe 3 feet away. He's trying to shield himself with his left arm. And as we approach frame 500 here, the gun goes off. At no point in this process is Mr. Grosskreutz pointing his gun at the defendant. Frame 499, the gun is just fired. Frame 500, you see the puff of smoke. 501, the bullet has hit Mr. Grosskreutz's right bicep, severing it. I'm going to continue forward after this because you can see that his right arm, this is an interesting frame right here, 504. You can see that gun. I'll go back even more. You can see that Mr. Grosskreutz's arm with the right hand with the gun, his right hand is pointed off to the side. What pulls that gun down closer to the defendant is the fact that Mr. Grosskreutz just had his right bicep severed. It's not a voluntary action. It's an involuntary, the muscle is severed. Now watch, frame 502, watch his right hand. 503, 504, 505, 506, 507.
Yeah, Kyle was
508.
closer. He saw the gun before you guys did.
At this point, yeah, absolutely. That right arm is probably dangling down towards the defendant. It's not going to be able to pull that trigger without a working bicep muscle, and it's not a voluntary thing. It's done because the defendant just blew his arm off.
He still got a gun in
But
his
yeah,
hand.
this is the time after the shooting when, yes, the gun happens to be pointed at the defendant. And I got to stop here for a moment and highlight the hypocrisy of the defense. Because
What about
according
the
to the
hypocrisy
defense,
of the
if someone has a gun, they're a threat. If someone points a gun, they're a threat. There's only one exception to that. The defendant. By their logic, he gets to run around with a gun all night. But, oh, we're not supposed to take him as a threat. He gets to point the gun at everyone. But, oh, we're not supposed to take him as a threat. No, it doesn't work that way. The same set of rules apply to the defendant as everybody
His gun
else.
was legal.
There's no exception in the law for Kyle Rittenhouse. There's no exception that says, if anyone else has a gun, you're a danger, except for Kyle Rittenhouse. There's no exception in the law that says, if you point your gun at people, oh, that makes you a threat and I can kill you, except for Kyle Rittenhouse. I can do it all night long. The same rules apply to him as everyone else. And everyone else has a right to defend themselves also, not just the defendant.
This guy's going to take forever.
We have shown you photos and videos of Gage Grosskreutz's injuries. Exhibit 60 is a video taken right after Mr. Grosskreutz was wounded by the defendant.
Great shot.
But this is what we're dealing with. When you fire an AR-15 at someone from close range, this is what it looks like.
Any gun, dumbass.
I guarantee you, ladies and gentlemen, the defendant had no clue what his gun was capable of. He didn't even bother to pay any attention to it, didn't concern himself with what he would be doing to other people. But this is what happened. Let's not flinch away from this. It's important that we understand what that gun was capable of that night. It killed 2 people, and it did this to Mr. Grosskreuz's arm. When those shootings occurred that I just played for you, what would a reasonable person in the defendant's position at that time think? The good news is, ladies and gentlemen, you're going to tell us. As part of your decision in this case, you will represent the reasonable person, of ordinary and prudent person, and you will put yourself in the defendant's shoes that night. I submit to you that at the time of those shootings, a reasonable person in the defendant's shoes would have known that he had provoked Joseph Rosenbaum by pointing his gun at someone else, that the defendant had put someone else at risk of dying by doing that. The defendant should have known that the crowd was aware of the fact that he had just shot someone and that they felt their lives were in danger. That is reasonable. It is also reasonable to understand that at that point, Gage Grosskreutz had just witnessed all of this. He had heard the defendant had shot someone. He'd heard the defendant lie about it. He saw the defendant shoot at Jump Kick Man at close range, miraculously missing. Had seen the defendant kill Anthony Huber. Gage Grosskreutz reasonably believed his life was in danger at that moment. And he was proven correct, because the defendant shot him too. So when you consider what's reasonable in this case, consider whether or not it's reasonable for a criminal to be able to shoot himself out of a crime scene. When a bank robber robs a bank and runs away and the crowd comes after him, can he just shoot anybody and claim self-defense? If someone comes up to that person and tries to stop them, tries to disarm them, like Anthony Huber did, do they forfeit their life? Did Anthony Huber forfeit his life by trying to be a hero and stop an active shooter and protect others? Is that justified? Can the defendant just kill him? In this case, the crowd was right. The crowd knew the defendant had just shot someone. When they're coming after him, they know he's
You don't
just
know
shot
what the
and
crowd
killed
knew.
Joseph Rosenbaum.
You don't know what was in their head.
You know,
That's
not every active shooter situation does the
hearsay.
crowd have perfect knowledge. When they're told that person running up the street just shot someone, we don't have time in the moment to go back and take a look at the body and replay the video and make a decision before going after the person with the gun. You know, we've had several police officers testify that in an active shooter situation, their first instinct, their first training is to go in and stop the threat. They don't sit there and wonder, well, maybe it was self-defense. I don't know. I'm going to, wait and see. And every day we read about heroes that stop active shooters. That's what was going on here. And that crowd was right. And that crowd was full of heroes. And that crowd did something that, honestly, I'm not sure I would have had the courage to do. If I see a guy running up the street with an AR-15 and I hear he just shot somebody, my first instinct is not to approach.
Because you're a
Huber was
pussy.
different.
Sorry.
Jump Kick Man was different. Gage Grosskreutz was different. That
No,
doesn't
they're
make them
freaking
a
rioters.
threat to the defendant's life. It doesn't make their lives worthless. They don't give up their right to defend themselves. They have just as much right as the defendant. I told you I wanted to begin by talking about the murders committed by the defendant. Now I want to go back and put it all in context for you. And that
Like you
context
did already.
starts with, bruh, I'm just trying to be famous.
Really?
The defendant's TikTok profile. 4 doors, more whores. Picture of him up in Ladysmith, probably in early May, proudly holding his new AR-15. Up until August 25th, 2020, this is the only time he'd ever fired that gun. Maybe put 100 rounds through it or so at that property up there with Dominic Black. They purchased that gun on that same trip. The defendant admitted he knew as a matter of law he could not buy that gun because he was only 17. Yet he wants to tell you that he thought legally he could possess it, which didn't make a lot of sense to me. We don't have a lot of defendants come in and say, well, I possess cocaine. I knew I couldn't buy it, but I thought I could possess it. No, it's not the way it works. Dominic Black conducted what we call a straw purchase for the defendant. He purchased that gun for someone who was not legally allowed to purchase it for themselves. I'm prosecuting Dominic Black for that, as you know, just like I'm prosecuting Joshua Zeminski. Because what Dominic Black did was wrong, and we don't tolerate that. The agreement was Dominic Black was going to keep that gun until the defendant turned 18. It was Dominic Black's gun. It was legally his. And the defendant knew that it was going to be held onto until he turned 18, that he was not going to have it
You don't know
until
what
that
he
birthday.
knew.
I want to focus a little bit on this AR-15 because I think it's important when you consider the recklessness of the defendant's conduct, how much he knew, cared, or didn't know about this deadly weapon. He'd only fired it that one time, maybe 100 rounds through it. He loaded the gun with full metal jacket ammunition, which I'll talk about a little bit more. He wanted it because he said it looked cool. Didn't seem to know or care much about the type of ammunition or the type of gun. You had a couple of witnesses tell us in this trial, and I could not believe it. A gun is a gun is a gun. Don't even start with that. And a bullet is a bullet. No, it is not. It is not. And anybody who says that is ignorant and reckless.
I guess I'm ignorant and
Because there are
reckless.
some important distinctions here. Full metal jacket ammunition is capable of piercing body armor and squad cars. And you heard Officer Krieger testify that when they heard someone was running around with a rifle, he went and got his plate armor out of the back. Wasn't going to.
Oh, I think you're wrong.
Ryan Balch
Percy
talked about
Light.
how full metal jacket ammunition is designed, and this is a former Army infantryman, is designed to go through a target like a deer or a person and continue on. He says it can hit a target 550 yards away. That's 5.5 football fields. And he explained that he had a handgun that night, which he put hollow point ammunition on. And that's what he was planning on using for self-defense. Because hollow point ammunition acts differently. It's going to hit its target.
Man, their stream is all
So
fucked
you
up.
will hit what you hit, but you're not going to put the rest of the community at risk, especially on a night when there are hundreds of people out on the streets in a heavy residential area. We can see on that map the car source, there are houses, there are churches, there are daycares, there are schools nearby, and you're firing full metal jacket ammunition around. I submit to you, ladies and gentlemen, that that AR-15 had no lawful or legitimate purpose that night. Now, the Second Amendment allows people to carry guns. That is true. There are people who can't carry guns, convicted felons, for example. But, generally speaking, I'm not saying people don't have the right to carry a gun. What I'm saying is that AR-15 did not accomplish any of the goals that these folks said it was going to. So, for example, Ryan Balch says the handgun is what he was going to use for self-defense. Several witnesses agreed you can't point this gun or shoot this gun at people to protect property. So if you're going to protect the car source building, how is this gun going to help with that? The defendant has admitted The gun was useless when he was going to treat people as a medic because it got in the way. He had to take it off and hand it to someone. So you can't use it as a medic. You can't use it to protect the building. So what's it there for? Well, it looks pretty imposing, and it has some deterrence value, but Jason Lukowski, Dominic Black, and Ryan Balch all said they never actually intended to use their guns. So why is it there? The defendant was wearing a sling that night. He purchased that sling at Jelinski's that afternoon. The purpose of the sling was so the gun couldn't be taken away. Wouldn't fall off, he wouldn't lose possession of it. It was designed to help him retain possession of that gun. And he loaded it with 30 rounds, the full magazine, capable of killing 30 people or more. Why do you need 30 rounds of full metal jacket armor to protect a building?
When there's hundreds of people, yeah.
This AR-15 is completely incompatible with the role of a medic. Richie McGinnis testified he's been to demonstrations in Seattle, Portland, Washington, D.C., New York, Minneapolis. He's never seen anyone walking around claiming to be a medic with an AR-15. And certainly when you see someone like that, it doesn't exactly send a warm, fuzzy message. Oh, come to me, I'm here to help. And the defendant acknowledged he had to take off his AR-15 to treat people. No serious, credible medic wears an AR-15 slung around their body. That's because the defendant was a fraud. He was not an EMT. He lied. He lied to the press. He's being interviewed by Richie McGinnis, who he hears is a member of the media, and he says, I'm a certified EMT. You're lying. You're absolutely lying. Jason Lukowski and Dominic Black said the defendant had to borrow his medical supplies from us. This is an emergency situation. Everybody's anticipating violence. Everybody's prepared for people to be hurt, harmed, injured, and yet the defendant's going to go there and walk around claiming to be a medic? He's like a quack doctor practicing without a license. That puts
And you
lives
said her a
at
quack
risk.
freaking lawyer.
And one of the things I had Gage Grosskreutz testify about is that tattoo on his right arm which said, "First, do no harm," which is one of the precepts, one of the fundamental tenets of the practice of medicine. First, do no harm. So how do we evaluate the defendant's performance as a medic that night? Well, on one hand, he wrapped up an ankle and I think maybe helped somebody who got a cut on their hand. Yay. On the other hand, he killed 2 people, blew off Gage Grosskreitz's arm, and put 2 more lives in jeopardy. So, you know, when we balance your role as a medic that night, I don't give you any credit. He showed no remorse for his victims, never tried to help anybody that he hurt, and even on the witness stand, when he testified on Wednesday, he broke down crying about himself, not about anybody that he hurt that night. No remorse, no concern for anyone else. For him to call himself a medic is an insult to anyone like Gage Grosskreutz, who spent hundreds of hours training and working hard to become an EMT. It's an insult. The defendant made a series of reckless decisions that night, going armed with an AR-15 at 17 years old when he knew he shouldn't have done so, because that gun is normally locked in a safe that he doesn't have access to, and it's not even legally his. He's out after a citywide curfew. He's intentionally and knowingly entering into a dangerous situation, and he expects it because he brings along his AR-15 and some body armor. So don't tell me you didn't know. He brings along no non-lethal means of defense, which means his only option is to kill. I don't know about a lot of you, but I remember that night. I didn't come down here. I don't think most reasonable people did. In part, because we all knew it was going to be violent and dangerous. Most reasonable people, to the extent they came out, they were gone by then. Because you don't willingly put yourself in this situation unless you want it. unless you're looking for it, unless you want trouble. Now, to put this in perspective, at this time here in our community, there were people who were scared. There were people who were worried about themselves, their homes, their families, their business. That's understandable. But this is different. There are also people out there who are exercising their First Amendment right to assemble and to have free speech because of whatever they believed in. And they have that right too. But that's not what we're talking about. The curfew, the riots, the arson, the looting that we'd seen on those prior nights, roadblocks set up around downtown, closed exits on the interstates, all of this was sending the message to reasonable people, go away. Don't come down here. Who was left at 11:45 at night? Most reasonable people had gone home before the curfew or never even came at all. But the defendant's down there, he says, because he wants you to believe he's protecting CarSource, even though he had no actual ties or genuine concern for this building. You have this caravan of people from West Bend, Ryan Balch, Jason Lukowski, Joanne Fiedler, coming down from some other community, having no idea what's going on here at Kenosha, having no idea what businesses are, having never dealt with CarSource before, just injecting themselves into this situation. CarSource that night was empty. The owners testified. They moved all the cars off the lot. They took the tools out from inside, and they didn't even feel the need to protect that building. So who's there? These guys with their AR-15s are just wannabe soldiers, acting tough, trying to manufacture some personal connection to this event, furthering their own personal agenda. Just a small part of the deluge of chaos tourists we saw here in Kenosha, trying to feed off of what we were going through. Despite everything we did to try and tell them, go away, stay out. Did those owners, Sam and Sal, ask anyone to protect their business? You know, I called them to the stand because I wanted you to hear from them.
And they lied on the stand.
I had their statement, but I wanted you to hear from them. And I'm sure you formed your own impressions about them.
Yeah,
I'm not here to tell you that I believe what they said on the witness stand. I don't think it really matters much, except I wanted you to have a flavor of who these people were and what was going on at that building. What was interesting to me is that text message from the defendant to Sam asking for the address of CarSource, even though the defendant says he's already been there. That didn't make any sense to me. It's not hard to find if you've driven past there every day. You know, Kenosha is one of the easiest cities in Wisconsin to navigate. It's all east, west, north, south. How hard is it to find this place? But the agreement was the defendant was supposed to stay at the 59th Street location. There's another group at 63rd. It was their responsibility. And the defendant testified that when the shootings occurred at 11:45 or 11:50 at night, he didn't even know if that other group was still there or if they'd left. But crucially, you heard the testimony of Kriston Harris, who's out there reporting for his Rundown Live, and he's making some video. And he tells the defendant, stay on your property. Don't go out in the streets and engage with these protesters because you're just making it worse and you're escalating the situation. He tells the defendant specifically that, just 20 minutes before the shootings. Kriston Harris probably said that because he knows this is a crowd that is feeling threatened by the defendant and his group. Richie McGinnis testified when he left the Stella Hotel and immediately ran over to 59th Street, he saw guys up on the roof and he felt threatened. These guns, he said, were the thing that changed the dynamic for him. Drew Hernandez, we showed video of Drew Hernandez having laser sights pointed at him. And he said he felt threatened. He thought someone was pointing a gun from the roof and putting his life in jeopardy. These are two people who are veterans. They've been to protests in Seattle, Portland, Washington, D.C., New York. They've been through this before. And yet here in little old Kenosha, the defendant's group made them fear for their lives. That's the kind of impact these AR-15s had. The crowd is yelling at the defendant's group, stop pointing your guns at us. Stop pointing these laser pointers at us. And the defendant sees this. He's well aware of the fact that the crowd out on the street is hostile. They don't react well to him. And he knows that by 11:35 at night, this crowd is all the way down there south of 60th. That's where they're at. So if I go down there, I need to be prepared, and I need to expect that these folks are not on my side. Joseph Rosenbaum. He's dead. So we don't know what he was thinking. We don't know what was going on in his mind. That makes him an easy target for the defense today, because they can stand up here and pile on him and destroy his reputation, and he can't speak for himself.
He was a pedophile.
That happens a lot in homicide trials. Blame the victim, who can't speak for themselves.
What about the kids?
So I'm going to tell you a little bit about Joseph Rosenbaum, and you've heard some testimony about him. He had been in the hospital, left it that day, had a clear plastic bag with his possessions, toiletries, a water bottle. We've all seen this. You get it in the hospital. It's pretty common. He's walking around like it's pretty much his only possession in the world. He visits Carrie Ann Swart, his girlfriend, and then happens to wander downtown into the middle of civil unrest. No indication he planned to be there. No indication he's part of any sort of movement. He just happens to stumble into it.
Just happened.
So what does he do that night? Oh, let me tell you all the awful things Joseph Rosenbaum did. He tipped over a porta potty that had no one in it. He swung a chain. He lit a metal garbage dumpster on fire. Oh, and there's this empty wooden flatbed trailer that they pulled out in the middle of the road, and they tipped it over to stop some bearcats, and they lit it on fire. Oh, and he said some bad words. He said the N-word.
Oh, so you approve of the N-word then?
If he were alive today, like Joshua Zeminski, I'd probably try and prosecute him for arson, but I can't because the defendant killed him. But that's the way we deal with people that do these things. When you commit arson, we prosecute you. We don't execute you in the street. And I'm not that Joseph Rosenbaum did condone that kind of behavior, not at all. But he didn't deserve to die for it. You can't kill someone for these things. He's 5'4", 150 pounds. Jason Lukowski characterized him as a babbling idiot. Lukowski says, I turned my back and walked away. This guy wasn't even a threat. I think we all know somebody like Joseph Rosenbaum, the Napoleon complex, the little guy who just wants to chatter, but when it comes down to it, it's all
Y'all
bark.
better not say me.
It's no bite. It's like a little dog. Bark, 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 bark. But
Kyle
really
Rittenhouse didn't know
ain't
that.
gonna do anything.
He's never met the guy before in his life.
There is no dispute in this record that at no point that night did Joseph Rosenbaum hurt anyone. Never had a gun, never had a knife, never had a bat, never had a club. And in the Drew Hernandez video, that fight at Ultimate Gas that we showed you, he's being shoved around by the crowd like a rag doll. And yeah, he's mouthing off, he's talking a lot, but he doesn't actually threaten anybody, doesn't actually hurt anybody. They're pushing him around like he's a tiny little person, which, frankly, he was. And in the background of this video, you will hear somebody say, point your gun at me, or something like that. That's Joseph Rosenbaum. He's upset because somebody pointed a gun, and that triggers him, which is understandable. I think most of us would be triggered by that sort of thing. And that's what's upsetting to him. But he gets right in the face of people who have AR-15s. Never reaches for their guns, never rears back to punch anyone, never even lays hands on anybody. You're going to watch this confrontation here at Ultimate Gas, and I want you to keep in mind that there's a group of people on one side with AR-15s and a group of people on the other side. And none of the people with the AR-15s feel their life is in danger. None of them shoot their guns.
Because they have a gun.
They can handle themselves. The defendant can't.
ready to shoot. You can tell they're ready to shoot anybody comes near.
That sound you heard was somebody throwing some sort of plastic thing at one of the stanchions underneath the gas station, and it makes a sound that almost sounds like a gunshot. So add that into the mix. You've got people with guns, loud voices, clear hostility, and the sound of something that, frankly, to me sounds like a gunshot. And yet
That's because you don't know how to shoot guns. People that shoot guns know the sound.
Nobody fires a gun. And watch how they push Joseph Rosenbaum around like a rag doll.
Oh, did you guys put somebody in timeout? I missed it. We had a punk in here?
Watch this guy in yellow. He's going to shove Joseph Rosenbaum about 8 feet away. Wow. I guess it was a different guy that did that, but they're shoving him around like a rag doll. Nobody feels threatened.
Those guys are also a lot bigger than Kyle Rittenhouse and older.
Mouthy little guy. He's a little dog that barks. And you know what he's going to do now? He's going to tell him, hey, I need to come grab my bag. I don't have my bag. So they let him on through.
Thank you, Snuggies.
There he is about to reach down and grab his bag off the ground. That's Joseph Rosenbaum. You've heard testimony that he tells people, shoot me, asking them to shoot him. I'm curious how that's a threat to anyone else. He's triggered, as we saw in that video, by people pointing guns at other people, which is reasonable. Most people would feel that same way. And then we get to the crux of the defense, this threat that he supposedly made to the defendant.
Yeah, Snookies don't play.
The defense would love to be able to play you a video of this threat. They would love for you to see it and hear it yourself. This is a night in which there are dozens of people out there, reporters and regular folks who are recording with their cell phones and with other cameras all night long. We have shown you video of almost every minute of the defendant's night from multiple different angles. And yet, you have not been shown a single video with this threat. Nowhere. It's not out there. Ryan Balch testified, and we have his transcript.
Why'd they turn the sound off?
We have his testimony,
No,
and
he
what
gets
he
2.5
says is
hours.
there was an incident in which Dustin Collette had put out a dumpster fire and said something to the effect of, fuck around and find out. And Balch steps in, and he has an exchange with the protesters, and he turns around, and Rosenbaum is right there in front of my face yelling and screaming. And I tell him to back up. And he goes, you know what? If I catch any of you guys, blah, blah, blah. So that's the timing, according to Ryan Balch. Right after that dumpster fire. Kriston Harris from the Rundown Live was there, physically, standing right next to Ryan Balch. Not only was he there during the dumpster fire, but he stays with Ryan Balch and or the defendant for the next 6 or 7 minutes, recording everything. And I've played this video for you. It is Exhibit 18, and I played for you a period of time from 1 hour and 22 minutes to 1 hour and 28 minutes. And I asked Kriston Harris, I call him to the stand, and I said, I'm going to ask you 2 questions. Number 1, do you independently remember seeing Joseph Rosenbaum, hearing this threat? And he said no. And then I said, okay, well, maybe you missed it, because, you know, there's a lot going on. So will you rewatch your video for me and tell me, is it in there? And he said no. This video captures that entire period of time with Ryan Balch and the defendant right there, and there's no threat. There's no Rosenbaum. It didn't happen. The defense desperately wants this because they've got to give you a reason why it's okay to kill Joseph Rosenbaum. And this threat is critical to their case. But it's not there. In exhibit number 3, and I'll play it for you here as I'm talking. Joseph Rosenbaum isn't even visible. Now, I submit to you that even if, I'm sorry, this is exhibit 18, even if there was a threat made, it's still not enough because Joseph Rosenbaum's unarmed and you can't kill him. But the defense has pinned a lot of their case on a threat that didn't happen and they can't prove. It's not on video. It's not there. So I'm going to pull up exhibit 18, the Rundown Live video.
Pull it up, bitch.
And I'm going to go to that mark.
Oh, they came back again? Let them keep coming in. It's all right. Every time they jump in, it just adds to the algorithms. Don't forget to hit like and share.
And I'm here with a bunch of... Kristan T. Harris here to Rundown Live. If you are live, share this in all your groups, your forums, start watching. Protect. It's just like the year, man.
So here's the dumpster fire.
You're the dumpster attorney.
I could use a doobie right now.
Joseph Rosenbaum is not in this video. Here's Dustin Collette about to put the fire out.
Hey. Come on, reel in. Don't cause problems when there's none here. Yeah, that's true. Just stay on your property.
Dogs might start barking, guys. My stepdad's back. I'll be right back. I gotta go help my stepdad for a little bit.
I have to agree with her.
There's Ryan Balch standing right next to Gage Grosskreutz. Joseph Rosenbaum isn't here. And the defendant and his group are being told an important message. As long as you stay on your property, but don't go out there and cause trouble.
I have to agree with her. They shouldn't be on the street. They're just protecting their property. One of the guy's an asshole.
I thought they were yelling at them. I was like,
no. Well, we did get it lit up. One of the guys losing his patience. We should go inside. Yeah, if you guys can switch them out.
He's talking to Ryan Balch right now.
He's got a lot of rage. He says the wrong thing. That's whole proper as the guy's lie. Protect your property. They're respecting that. Just keep it there.
This is where Ryan Balch goes and talks to a protester.
He's just trying to protect his property. He doesn't want anything. He has no problem with you guys. He just doesn't want to burn down his shit. I can't blame him. I understand. Hey, your job isn't to be in the street. You gotta stay on your property. That's why you got problems already with people. No one bothering your property. Don't look for trouble or anything. A medic? I know you are, but like, they got their own medics. And if somebody's close by, take care of them. I know you're just trying to make peace. I get that, but they don't look at it that way. They look at you guys as it's a different. It's as much as you guys are afraid of them before they march down here. I know, but like when the conversations are having. Thanks, guys.
The rest of the video is the crowd being warded off by gas launched by the police. They launch tear gas, which affects the defendant, which affects Ryan Balch, it affects Kriston Harris, and that group all runs alongside the 59th Street car source, away from the street, away from any protesters. At no point in that video do you hear any threat that Joseph Rosenbaum makes. It's not there. Trust me. If the defense had it, they'd play it for you. Now, they want you to believe that that threat is made, and they also want you to believe that it was something that the defendant took into account when he decided to kill Joseph Rosenbaum. One of the questions that occurs to me is, how would the defendant even know who that guy is? Because earlier in the night, Joseph Rosenbaum is wearing a red shirt and a blue bandana. But by the time he's killed, he's got no shirt on. He's got no blue bandana. This is someone the defendant has never even met before. He's one of hundreds of people in the crowd. And yet, we're expected to believe that in a split second, the defendant remembers this guy? I don't believe so. So then, that video that I just showed you leaves off at about 11:35 p.m. The police have moved the protesters south of 60th Street. They've tear gassed the crowd, and there's no protesters left. 59th Street is no longer in any danger. It wasn't much danger to begin with. There wasn't anything left there to protect. But by this point, there's no more danger. As law enforcement comes through, you've heard this video where they tell the defendant and his group, "We appreciate you," and hand him out bottles of water. As long as you stay on that private property, yeah. No one is saying you don't have the right to stay on private property and protect private property. What people are saying, what the crowd is saying, is stay there. Don't go out looking for trouble. The defendant hears this message from the police and takes it the wrong way. He thinks, oh, well, now I'm junior policeman. I can go run around stopping crime. But I asked him and I asked some other witnesses, if the police are there on the scene and the protesters are gone, go home. Why are you still here? Shouldn't have been here in the first place. But why are you still sticking around? And interestingly enough, one of the questions I've always had in the back of my mind is, what's the end game here? When is this crew going to be done and decide that it's time to leave? Well, right after the defendant kills Joseph Rosenbaum, kills Anthony Huber, and comes back, they all flee like rats off a sinking ship. But it's boring at 59th Street. There's no protesters. There's no action. So the defendant decides about 11:35 p.m. to cross the police line and go looking for trouble. He knows at this point he's entering a hostile crowd. He's seen this crowd. He knows what they're like. That's why he has to yell friendly to them, because he knows they're not going to see him and think he's friendly. And he knows he's got to have Ryan Balch with him, some sort of buddy to protect him. And he's immediately confronted by that man with the yellow pants who says, "You just pointed your gun at me." And the defendant says, "Yeah, I did." He admits that. Now, what's interesting to me is they want you to believe this never happened. They want you to believe this guy in the yellow pants made it up or is lying. But he's just standing there by the side of the road, minding his own business, when the defendant happens to walk up to him. Do you think he just sat there and thought, oh, I'm going to make up a lie about this guy on the spur of the moment? Or did it really happen? And is it consistent with everything else you've seen about the defendant? Does he sound like the sort of guy who would point a gun at someone for standing on a car? Does he strike you as the kind of guy that would threaten deadly force to protect property? Because that's what happened. The man in the yellow pants says it happened. The defendant agrees. And then he comes into the trial and says, oh, I was being sarcastic, like he's a little 17-year-old and he wants to get out of it. Shortly after that, the defendant loses track of his protector, Ryan Balch. So now he's in a position where he knows that he's surrounded by people that consider him a threat. He knows that he's not supposed to go anywhere without Ryan Balch. He knows he's supposed to go back to 59th Street. And he does. He tries. He walks up to the police line. He says, I work there. That's my business. which isn't true, but whatever, and they won't let him through. Now, Ryan Balch makes it on through shortly thereafter, but the defendant gives up. He could go 1 block in either direction and make it back easily if he wants to, but he stops and decides, you know what, I'm going to stay here and maybe see what's going to happen. So then he talks to these people with fire extinguishers, and he's going to go down to 63rd Street, and he asks one of them to come along, and they say no. Now at this point, doesn't have Ryan Balch. He knows he's supposed to go back. He knows he's supposed to have a buddy, and yet he decides to go it alone. He decides to run down to 63rd Street or walk down to 63rd Street. Doesn't even know if that other group is still there. Doesn't even know if he's really needed, but he can't wait to take this opportunity to go down and confront people. Because he thinks he's some sort of cop, some sort of law enforcement agent, some sort of junior cadet who's out there with the responsibility to fight crime. Nobody asked him to do that. Nobody gave him the right. Nobody deputized him. Ryan Balch says, the police told me the crowds, we're going to push them down by you, you're going to deal with them. The Bearcats hand out water and tell him he's appreciated. As he's crossing the police line, they warn him about people throwing rocks. What is the message the defendant takes from all of this? The wrong message. Oh, well, now I've got the power. I've got the gun. I'm going to go confront these bad guys. I'm going to stick my nose in things. So what does he do when he gets down to 63rd Street? The first thing he does, we showed it to you at the very beginning, that drone video. Grabs that gun and points it at someone to protect property. Points it at the Zeminskis. Because why? Because they're, what, about to mess with some sort of fire? They're not threatening anyone's lives. He doesn't need to protect anyone. He doesn't need to protect himself. He's pointing a gun because he thinks he needs to protect property. He says he wants to put out a fire, but the first thing he does is drop the fire extinguisher on the ground. His AR-15 isn't going to put out a fire. So why is he really there? And we all agree, you can't use or threaten deadly force to protect someone else's property. You are here to decide whether or not his actions are legally justified, not to buy pathetic excuses that might be given to you. As a teacher, when a student says to you, the dog ate my homework, that's an excuse. It doesn't get you out of the homework assignment. If you panic in a situation that is not reasonable, that is an excuse. It is not a legal justification. If you're 17, if you don't have training or experience, if you put yourself in a situation where you're in over your head, if you're scared, those are excuses. Those are not legal justifications to kill. They do not erase your personal responsibility for your own actions. The court has read to you the instructions in this case. They lay out the law that you should apply. That reading took a long time, and I understand there was a lot to digest. And one of the things that you will have the opportunity to do when you go back and deliberate is read through those instructions yourselves. Because I get that listening to them doesn't always make it clear. But I encourage you to focus on some things when you consider the defendant's behavior in this case. You are told that criminally reckless conduct is conduct that threatens other people's lives and poses an unreasonable and substantial risk to other people. There is no dispute the defendant's activities here threatened other people's lives. He took 2 lives. You know, this is not like a normal murder case. A lot of murder cases we're in here trying to convince a jury that the defendant killed somebody. That's not in dispute here. That's the easy part. The question is, does he get a pass? Do we think that's okay? Do we think what he did was right? That's the question you have to answer. And when you consider whether his conduct was criminally reckless, consider, did it pose an unreasonable and substantial threat to the safety of others? Count 4 charges him with first-degree intentional homicide of Anthony Huber. There is no doubt that the defendant intended to kill Anthony Huber or committed conduct that he knew was practically certain to kill Anthony Huber. That gun was pointed at Anthony Huber's lower left rib cage, and the defendant deliberately pulled the trigger. That was no accident. And when you do that with an AR-15 against someone's body, it is practically certain to kill. We all know this case comes down to self-defense. But there's a high bar for using deadly force in a self-defense situation. The law says that the defendant may intentionally use force which is intended or likely to cause death or great bodily harm only if the defendant reasonably believed that the force was necessary to prevent imminent death or great bodily harm to himself. So did Joseph Rosenbaum pose an imminent threat of death or great bodily harm to the defendant? No way. Did Anthony Huber pose an imminent threat of death or great bodily harm to the defendant? Absolutely not. Did Jump Kick Man or Gage Grosskreutz? No. None of these people posed an imminent threat to the defendant's life or to cause great bodily harm. The standard when you make this decision is what a person of ordinary intelligence and prudence would have believed in the defendant's position under the circumstances that existed at the time of the alleged offense. The reasonableness of the defendant's beliefs must be determined from the standpoint of the defendant at the time of the defendant's acts and not from the viewpoint of the jury now. So put yourself in the defendant's position. Would you have done the same thing? Would a reasonable person have done the same thing? Would you have engaged in the reckless conduct that led to this course of events? Would you have gone out after curfew with an AR-15 looking for trouble? Would you have aimed at other people? Would you have tried to use the gun to protect an empty car lot? No reasonable person would have done these things. The court has also instructed you on provocation. You cannot hide behind self-defense if you provoked the incident. If you created the danger, you forfeit the right to self-defense. By bringing that gun, aiming it at people, threatening people's lives, the defendant provoked everything. And if he does that, he has to exhaust all reasonable means to avoid a confrontation. All reasonable means. So if Joseph Rosenbaum's running at him, Joseph Rosenbaum is no threat to his life. And not only is the defendant expected to run, he's expected to yell, push, shove that rag doll around, run back for help, call 911, call for help, do all sorts of other things besides just turn and fire 4 shots as Joseph Rosenbaum falls helpless to the ground. Ladies and gentlemen, there is no doubt in this case that the defendant committed these crimes. He committed a first-degree reckless homicide against Joseph Rosenbaum. He put Richie McGinnis's life in jeopardy. He put Jump Kick Man's life in jeopardy. He intended to kill Anthony Huber, and he attempted to kill Gage Grosskreutz. All of those elements are true.
Unknown caller.
The question is whether or not you believe that his actions were legally justified. And I submit to you that no reasonable person would have done what the defendant did. And that makes your decision easy. He is guilty of all counts. Thank you.
Thank you, Mr. Mayor. Let's take a break and about 2:25, hopefully. And please don't talk about the case. Read, watch, or listen to any kind of the trial.
Wow, he's actually finished? Holy jeez. What a bunch of BS that was. What do you guys think? Oh my goodness. Lordy, 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 lordy. I cannot believe this guy. What a joke. What a little weasel. I need to download the weasel. That's what I need to download. Oh my gosh. Yeah, that's total BS. Let's hear, let's see if there's any remarks or something. There's probably going to be something going on. Here, you guys want to, while I'm doing that, you guys want to watch me play poker? I joined another tournament, so.
And I wondered if I'd have given a print command, you know.
I get shitty cards and look, 3-5 come up. Can't call with that though. even though it's suited. You guys can help me play. You guys can bring me good luck.
About 225 on that clock.
I clocked the closing hour 45 minutes. Is that what you have?
You know, you could have gotten away with murder because I wasn't timing it. After having
That's kind of some bad words to use right now.
2 hours and 8 minutes. What? I can give the exact starting time.
What's that?
I said I can give the exact starting time.
Well, why don't we call one of the networks and they can tell us because.
Detective Howard was standing.
What?
Detective Howard was standing.
I don't trust Detective Howard.
Let's get everybody under oath and.
I don't trust Detective Howard.
I'll work it out, and if necessary, we'll.
Because remember, the reason why they're doing this, he's only allowed 2 hours and 30 minutes in total.
That's all that came through.
So he's only allowed 2 hours and 30 minutes in total time. That's why. What's up, Matt? How's it going, big guy? That's why they're doing that. All right, let me put you guys want to watch me play my tournament some more. See, look, let's see. Wait till I'm gonna have to fold this hand. Even though I like suited connectors, I could get lucky. Let's all right, so let's go here. We'll show you where I'm at right now. All right, so expand this out. All right, so this is me. I'm player number 73. Hold on, I gotta fold King 5 offsuit. So I'm in 9th place right now. They're paying the top 12 places. Oops, I'm in the wrong one. So they're paying the top 2 places. If I get 9th place right now, why is it not working? All right, so if I get 9th place right now, that's 55 bucks. So it's not bad. Could be better, could be worse. What I want to do is I want to get 1st place though, which pays 355 bucks. So yeah, so that's what I'm playing right now. I'm in 10th place now. But I've already if you look, see where it says, let's see. Oh, you can't see it. All right, so see right here, I've already made $15 off this tournament because of knocking people out. You get paid $5 for every time you knock somebody out or something like that. Or plus extra money. And so like your bounty goes up. Like watch, I'll show you. So my bounty right now is $15. It's a progressive bounty. You can't call that hand. That sucks. So you like look at this person. So they have $9.37. So if I knock them out, I get $9.37. This person I only get $2.50 because they haven't knocked anybody out yet. Same thing with this person. This person you get $3.75 if you knock them out. And so what happens is, so if I knock him out, $3.75 goes into my account, which I automatically win, and then they add $3.75 to this, so that'll raise up. So it also gives people a reason why to try and knock me out. It's back on Facebook? Or are you back on Facebook? I play at Bovada. That's the only one you can pay that my credit card works on in the United States. What did 3P say? Look at these. I keep getting... I'm all card dead right now. Your blood pressure is raised? Yeah. He didn't take it to Kenosha, Willow, or he didn't take it to Wisconsin, Willow. They bought it in Wisconsin. It stayed in Wisconsin. He never crossed state lines with it. So they actually dropped that charge from what I understand. Does Drunk sell Delta 8 edibles? I know he sells a lot of Delta 8. We'll have to ask him tonight, Julius. We'll have to ask him tonight. I mean, it's clear self-defense, but it all depends on the juror. You know, if they're all liberals on there, right, then we're in trouble. If they're all afraid of the retribution they're going to get for voting not guilty, then we're all in trouble, right? I don't know. It's just, it's a rough situation. It sucks. Like that. Look at the Chauvin trial, right? I mean, yeah, the guy was a jerk. He shouldn't have knelt on him, but it wasn't the degree of murder that they took Chauvin in for, and they're appealing that, right? I'm sure there's going to be an appeal case on it. Maybe I should go back to Minneapolis for that one. I don't know. They're trying to say he brought it to a hostile environment, but here's the problem. If I was the defense, I'd like, well, you know what? So did the other guy. He brought it to a hostile. Should I just go all in right here? No, I got too many chips. I'm gonna have to raise it up big time now. Oh, he went all in, so I'm calling his all in, no, for sure. It's you and me, buddy, and I got you out kicked. And thank you. See, so I just won $2.50. Watch, this is gonna go up. See, now I went up to $17.50. But I also, if you go look over on the other page, it'll show you that I have. Is Drunk Uncle in here right now? You know, D8 is legal. That's the reason why that they're. Oh, what's up, Drunk Uncle? You are in here. So D8 is legal, right? So you should be able to buy that shit online, I would think. But Drunk Uncle is the shitty cards. Drunk Uncle is the expert on that. I got you, Willow. It's all good. I'm not an attorney, but by the way, I am not an attorney, and I cannot give you attorney information, right? Vinny's saying he could have walked away, yeah. What's up, Drunk Uncle? See on the dealer button, but I can't call this hand. Those five. Oh no, the other guy raised it too. No way I'm calling. What's distillate? Well then, Julius, you're in Florida. Drive up to North Kakalaki and go see Drunk Uncle. Go to his store. Go support Drunk Uncle's store. Oh, look at this. I would have been good. I bet you nobody. I bet you that he's got. This guy's probably betting with. Oh, he's probably got a pocket pair, maybe. This guy's calling with like ace, king, something. I don't know. Let's see. Because I would have two pair, eights and sixes. I don't know. I think I would have won this hand. I couldn't have stayed in though. How's work going, Drunk Uncle? So I won't even know what he had. He's not going to show it. So I want to take this guy out. I get his cash. I can take him out. I got enough to beat him. I'm just shy of beating this guy. With him betting, it's not a good hand to call with. Oh, the doctors won't let you drive yet? That sucks. You know, my doctors wanted to put a morphine what do you call it? A morphine pump in my back, and I said no because I was afraid I couldn't drive. But I have a friend who has a morphine pump, and he still has a license. He says they won't take your license from you because it's such small dose of morphine. I almost wonder if I should do that now for the pain. Do a bluff. You want me to do a bluff? It's not a good time right now to do bluffs. Are we in the money already? Let's see. How many people are gone? No, we have 15 people left in this tournament, and they're only paying 12, so it's not a good time to bluff all in or bluff right now. I mean, it kind of is, but it's not. It all depends on the situation. Let's see, how much did I bet last time? We'll bet 3,200 again. Let's see what this guy does. See, he's got a lot more chips than me. Oh, he folded. Good. It was a semi-bluff. I had a good hand. I don't think this guy had enough chips. Or I don't think he had anything. See, if this was suited, I would play it. Who's defending the pedo? Oh, first E-Light. First in light H. right, Andy? It's up to the prosecutors to prove it's up to the prosecutors to prove him innocent. I mean guilty. It's not for the defense to prove him innocent. That's the way that works, and they have to do it by beyond a reasonable doubt. Oh, did somebody get rid of him? What about him protecting property? You can't shoot somebody for protecting property, all right? So you can shoot somebody for coming after you. That has nothing to do with the case. You were totally wrong, in my opinion. That has not one freaking thing to do with the case. What has to do with the case is that they were coming after him. They were chasing him. They ran him into a spot, and they said, "Well, you slowed down." Well, yeah, there was a whole bunch of cars there and a whole bunch of protesters. What is he supposed to do? Right? He defended himself, and that's all I see. Man, I love 7A, but it's not suited. Otherwise, I'd call. Let's see, are we down to anybody else now? We're still at 15. Somebody only has 52. Oh, this guy only has 5,000 chips, though. He's not going to play a hand at all. He's just going to wait till he gets donked out. Unless if this guy bets at all, he's got something good. Yeah, it's funny how, they keep bringing up, everybody wants to say, well, he shouldn't have had a gun there. Well, you know what? Hence the number. It is that easy, actually. Okay, but then what about Gage bringing his gun to there? Gage, who didn't have a license to have a concealed weapon. Gage is a felon, so he's not allowed to have a weapon anyways, because felons are not allowed to own firearms. So let's see, a guy down there with a weapon illegally concealed, and yet you guys are saying, oh, you see, you can't bring that stuff up because the other guy, it's called clean hands. You got to come to court with clean hands, at least in a civil trial. But still, I don't care. That's my opinion. I think he had every right to be down there. Wisconsin is an open carry. Kyle was open carrying. He never hit his gun once. So I'm sorry. It's just the way it is. Just saying. Hey, Diggler, I got a question for you over there. In Florida, so in California, if you have a medical marijuana card, they report you, and I heard you cannot buy a weapon. Is that true in Florida? Is that true? I don't. I'm gonna call this hand once. Too many people are in the hand. Why am I playing this game? Because I'm in a tournament and I can win money, Vincent. We're in a break, so I'm just showing you guys what I'm playing right now. Because look, well, I can't switch. I should have never been in this hand. Because look, I can win up to $355 right now. So that's why I'm playing this game. Because I'm real close to the money right now. Everybody's scared. I'm going to bet 3,000. Let's see. You guys want me to bluff. Okay, here's my bluff. Let's see oh, there's one caller. Okay, now give me an ace. Okay, let's see if Hugh had the flush draw. If he had the flush draw, he would have bet. No, he checked. Oh wait, I see all black cards. I'm looking at the wrong screen. Let's see if he calls me again. We got the same amount of chips. Too bad there's no 5 in there. I'm gonna bet one more time. Let's see what he does. Hopefully he folds. I hope he's on a flush draw. Hopefully he's on a draw. He probably thinks I have ace king and he has ace queen. That's probably what he thinks. If he has ace queen, he'll hopefully fold. Oh, shit. Well, you know I can't call him. All I can do is catch a bluff catcher. All right. Hopefully he's not watching this stream right now. Definitely out of his hand. That sucked. You think so, Jacob? It is what it is. I thought the guy was chasing. He probably was, too. Let's see, what are we down to? We still have 15 people? Oh, no, we're down to 14 people. 2 more people and I'm in the money. That's the other thing you got to remember, too. We're close to the money, so people are afraid of playing right now. You think so? Weakness the whole way, huh? Too late now. Too late now. Well, none of us are the jury. We're all just stating our opinions here. That's what's great about America. We can state our freaking opinions. Oh, thanks, Snookies. I need them. I definitely need them. 39 to 45. What are you talking about? All right, somebody call. Oh, somebody did call. Good. Knock this guy out. Knock this guy out. That'll put me closer because we got 14 in the tournament left. If you take him out. Ooh, ace. Ooh, we got jacks. There's an ace, okay. 2 pair. Damn it. Damn it, damn it, damn it. Okay, I gotta go all in on this. Should I go all in or just bet big? I'm just gonna make a big bet. Actually, these are guys. You know, I have to call. I have to. I got pocket queens. There's nothing I can do. Nothing I can do. Just keep it low. Keep it low. Keep it low. Yes, full house. Doubled up, baby.
Did we resolve the issue about the length of
Oh, they're coming back.
Mr. Binger's presentation?
Judge, I don't think we agree. I did just get asked Mr.
What's
Attorney
up,
Richards
Don
for the
Break? How you doing,
timestamps.
beautiful? You didn't miss much. The judge hasn't yelled at anybody yet.
Second portion of the argument, it would have been from around an hour and 13 minutes.
Hour and 13 minutes?
Detective
Bullshit.
Howard and I both timed the first part, and we have it, well, Attorney Richards has it as 37 minutes. I have it as 32. So I don't think it's 2 hour, even with his timestamps, it's not 2 hours and 8 minutes.
Well, look, you know, I actually wouldn't have strictly enforced it.
Oh, you asshole. Don't say
make
that.
My usual statement, but I won't because someone will accuse me of being biased against my own religion. But,
where are you going, Willow?
I usually have been quite permissive about this. I set very strict rules.
You going to go visit Digglewort?
I'm somewhat indulgent. So I probably won't call anybody about it. But, so you can both talk for 8 hours. And,
oh, come
okay.
on.
Yeah, you got it.
Damn it, Judge. Damn, I should have stayed in. I would have got a flush with that shitty hands. Come on, jury. Oh, the prosecution's gonna talk so much it's not even funny. You know that, guys. Yeah, you missed the prosecutor's closing. It was a whole bunch of boring BS lies. That's all it was. Whole bunch of lies. Oh, I just doubled up in the tournament. Well, until then. Look at that. I'm up to 66. And are we down to... We still got 14 players, though. Oh, this guy's going all in. Shit. Look at all the people calling all in, though. Look at everybody calling them. Man, there's two. I got to call just to see the flop. And I'm out. Hopefully everybody just checks. Hopefully nobody bluffs at it. Yeah, I still can't win. If there was another 2 more hearts, I could have. Nope, I'm totally lost on this one. Let's hope we knock somebody out. Queens, good, good. Knock everybody out. Yep, cool. They knocked 2 people out. That means I'm in the money. It should pop up right now. Congratulations, you're in the money. Oh, it didn't say it. But I am.
Please the court, ladies and gentlemen of the jury. Good afternoon. Showing you a snippet of State's Exhibit 18, which Mr. Binger just spent 3 or 4 minutes showing that Mr. Rosenbaum wasn't around. And my client couldn't know that he wraps his head in orange. Chain, bag, orange. Ladies and gentlemen, we've had this video almost as long as they've had this video. But Mr. Binger will use this video to lie to your faces and tell you that Kyle Rittenhouse was taking advantage of the situation.
I love it.
It's in the picture.
It's argument.
Ladies and gentlemen, this case is not a game. It is my client's life. We don't play fast and loose with the facts, pretending that Mr. Rosenbaum was Citizen A #1 guy. He was a bad man.
Video.
He was there. He was causing trouble. He was a rioter. And my client had to deal with him that night alone. When I say that the truth matters and this is not a game, what do I mean by that? Mr. Binger is the one who put on the Kandiri brothers. The reason he put them on, in spite of what he might say today, is because he wanted you, now 18, soon to be 12 people, to say, gosh, that kid just went to that place and just protected it. He wasn't asked. He was asked. Mr. Kandiri's asked Nick. Nick got a group of people to go down there. The people from West Bend came. Provocation, another thing. Think back on November 2nd, when this case started. Did you hear one word out of Mr. Binger's mouth about provocation? You didn't, because it was never said. But when his case explodes in his face, now he comes out with provocation. That was opening. And most importantly, in opening, quoting from Mr. Binger's first paragraph of his opening statement on November 2nd, 2021. This occurred after the defendant chased down Mr. Rosenbaum and confronted him while yielding an AR-14. Ladies and gentlemen, you've seen the videos. Mr. Rosenbaum.
Did he just say AR-14?
I'll show you the video in my closing argument. You'll see Mr. Rosenbaum take off when he sees my client coming, along with the Zeminskis, to set up the ambush of my client. Provocation? I don't think so. The things that I just pointed out to you, why is that a problem? Because 1, he's lying. 2, he's misrepresenting.
Yeah, he did say AR-14.
Or He wasn't prepared when he started this trial, and his closing argument has been a change to try and fit what has come out. Remember how when he was talking, there's no proof that the Rosenbaum and Zeminski knew each other? Maybe they did know each other that night, but they were together throughout the night. You see them together in pictures wreaking havoc in this city. And now we have the magic pixel camera that brings forth his provocation. I'm going to go through the charges, and we'll talk about each one of them. Then I'll go through the witnesses, and hopefully I'll bring it home in an honest and forthright fashion. Count 1, reckless homicide. My client shot Joseph Rosenbaum. Ladies and gentlemen, make no mistake, there was nothing reckless about my client's conduct that day in regards to Mr. Rosenbaum. Mr. Rosenbaum was coming at him. My client ran from him, retreated, which is not needed, continues to run. The plastic bag is thrown, the metallic plastic bag. Kyle doesn't know what it is at that time. It causes him to turn and look over his shoulder, pointing the gun in that direction. Mr. Rosenbaum, is he dissuaded by that? No, he is not. He continues running and advancing on my client. That whole time, the state doesn't say anything about Mr. Zeminski firing the shot, Mr. Zeminski having his gun up. Think of the circumstances as they existed at 11:50 on August 25th of 2020. He runs through that parking lot. He continues running on. He turns as he comes into that box canyon with the cars, the van, and I believe it's a Pepsi machine. And he turns because he has no place else to
getting a lot of donations.
I'll show you the Zanine video later on. What's important about the Zanine video, you see that mob of people destroying the cars at Car Source 3, which Mr. Binger doesn't want my client to go and try to protect, even though he was asked by those individuals to protect that property. Nick Smith called him, hey, they're bashing up the cars and starting fires. Go down there. He goes down there. He has as much right to go there as anybody else in the city of Kenosha and be unmolested by the likes of Joseph Rosenbaum,
Pedobomb,
Kelly, and Joshua Zeminski. And Mr. Binger says, oh, we'll get the Zeminskis later. Well, ladies and gentlemen,
then
last time I checked, this is still United States of America, and he has the burden of proof. If he wants you guys to believe that my client pointed a gun at him, call the Zeminskis, put him on the witness stand, ask him questions, and let me or Mr. Sharafasi cross-examine him. That's how we do things in a court of law, but not in Mr. Binger's court. He says, I'm blaming the victim. As a defense lawyer, I might get accused of that more than some other people. Ladies and gentlemen, Mr. Rosenbaum was shot because he was chasing my client and him take his gun. And Mr. Binger wants to make a big
join us now
about the shot in the back. Remember his opening statement. You shot him in the back. And that's why I'm sitting here in front of the jury like this. Did he shoot him here? Did he shoot him there? Because of the way the bullet went in, but not in Mr. Binger's bullet ended up in the hip.
Much better quality.
He says, I'm blaming the victim. As a defense lawyer, I might get accused of that more than some other people. Ladies and gentlemen, Mr. Rosenbaum was shot because he was chasing my client and going to kill him, take his gun, and carry out the threats he made. And Mr. Binger wants to make a big hullabaloo about the shot in the back. Remember his opening statement. He shot him in the back. And that's why I'm sitting here in front of the jury like this. Did he shoot him here? Did he shoot him there? Because of the way the bullet went in and where the bullet ended up in the hip, you know full well that the individual, and I asked the doctor, is on a horizontal plane. What is that horizontal plane consistent of? Somebody leaping, lunging at my client. And we know how close Mr. Rosenbaum was to my client. The furthest he could have been when it started, the first shot, 4 feet with the stipling. We know that his hand was on the gun. Mr. Binger wants you to believe that that was just happenstance and accident. Come on, people. Physical evidence does not lie. Use your common sense and good judgment. He talks about Mr. Rosenbaum just somehow ending up down at the riots. Remember that?
Pedal bomb.
Mr. Rosenbaum, according to the testimony, walked from the bus center 4 miles out to Ms. Swartz's house, and then he couldn't stay there for some reason, and 4 miles all the way back. That's not just ending up. That's going someplace with a purpose, and throughout the night you saw his purpose. And there was more than one piece of testimony about Mr. Rosenbaum, whether it was a hospital or whether or not it was a jail. Remember that? And there was testimony regarding his medication. Ms. Swartz said we couldn't get medication because the Walgreens were all boarded up. She said, the hospital said, they gave him his medication. So whatever facility gave him his medication. Mr. Binger, the man with the burden of proof, why didn't he bring in a hospital or a jail to prove that Mr. Rosenbaum was properly medicated? He'd been off his medications, according to Ms. Swart, for 7 to 10 days. We know that he was acting like somebody who wasn't on their proper medication. He was not acting normal. Next. Richard McGinnis. Reckless. And here, Mr. McGinnis, I'd like to talk about, because the self-defense does not go to Mr. McGinnis, but if Kyle was privileged in exercising self-defense against Mr. Rosenbaum, it carries over to the endangering count of Mr. McGinnis. And Mr. McGinnis, specifically, if the defendant, and I'm reading directly from an instruction, page 9, second full paragraph, which you will be given, if the defendant was acting lawfully in self-defense, his conduct did not create an unreasonable risk to another. That is Mr. McGinnis. Ladies and gentlemen, when my client shot Joseph Rosenbaum, he feared for his life. He feared because of the prior threats, the prior statements, and the violent acts that had been witnessed by my client. Mr. McGinnis, as a witness, I think he helped us more than he hurt us. He talked about, and this was on cross for Mr. Binger, how do you know what Mr. Rosenbaum was thinking? He goes, I don't, but I know he yelled, fuck you, and then lunged at Kyle Rittenhouse. Why is he yelling the FU? One of two things. One, to intimidate, or two, he got into a situation over his head, thinking, as he said before chasing him, you won't do shit, MFer, to my client. Well, he was wrong. He states Kyle did not know that he was there, meaning Richard McGinnis. He's a citizen journalist who was running along with his hand, in his phone in his hand, up in the air, in to get a story. My client is not responsible for endangering him when he runs into danger. Plus, the instruction says that if he was privileged as to Rosenbaum, he's privileged as to count 2, Mr. McGinnis. Count 3, jump kick man. The uncomplaining, unidentified witness in count 3. There will be some video later on when I'm going through some of that. You'll see, and I ask you to pay attention. The state has said he's not kicking him. He doesn't hit him. When you watch the video, and it'll be in slow motion, watch where his foot goes, watch what happens to Kyle's head. The force of him kicking him in the face spins his body 180 degrees around. And then it's on. Huber coming in from behind, hitting him in the neck with the skate.
Right back. FedEx is here.
Ladies and gentlemen, what you see throughout event number 2, and this is the beginning of it, is individuals working in a mob. They don't know what happened at Car Source 3, event number 1. But somebody said, hey, he shot somebody. Doesn't know that he was being chased by a crazy person. But they're going to get their licks in on Kyle Rittenhouse, or, as they perceive him, somebody from the other side who has been putting out their fires, causing problems for them, stopping them from wreaking havoc in Kenosha like they did the night before. And ladies and gentlemen, the standard is likely to cause death or great bodily harm. Great bodily harm is defined as likely to cause serious bodily injury. A kick to the head is likely to cause a serious injury. Did my client suffer a debilitating injury as a result of that? No, but that's not the standard. Mr. Huber, he's a rioter, pushing a dumpster lit on fire, going to the barricades to pick up pepper balls, throw them back, pointing his middle finger at the police. He's assisting Rosenbaum at the gas station, hits Rittenhouse 2 times with the skateboard, and attempts to disarm him. You'll see it all in the slow motion video later on. And Kyle Rittenhouse is running away from Anthony Huber. The state wants to call my client an active shooter. And the reason they want to do that is because of the loaded connotations of that word. Everyone has heard of the theater killings, the school shootings, and things like that. Ask yourself, the definition of an active shooter is somebody with a plan to inflict multiple casualties, usually out of anger or animus towards a group. This case, what caused Kyle Rittenhouse to shoot somebody? Joseph Rosenbaum. He runs after shooting Joseph Rosenbaum for almost 2 blocks before scene number 2. Mr. Binger makes a big thing about Kyle Rittenhouse not staying around Car Source 3 after the shooting. Ladies and gentlemen, if Kyle Rittenhouse had stayed at Car Source 3, all that would have happened is it would have made the police have an easier job, because scene 1 and scene 2 would have been put in the same location. My client ran 2 blocks without shooting at anyone, pointing at anyone, doing anything to try and get away. He tells the individuals he's going to the police, and he's running in that direction when he stopped. He's hit in the head with a hand with a rock in it, knocking his hat off. Mr. Binger says, oh, he just knocked his hat off. I don't think that individual was trying to steal Mr. Rittenhouse's hat. He was trying to take his head off. Who comes in next? Anthony Huber, for the first time. Hits him. Opening statement, Mr. Binger, was he takes a swing at him. Now it's he blocked because we took the videotape and lightened it up. Huber strikes him in the head and arm the first time. Jump kick man comes in, kicks him in the face, spins his body 180 degrees, and Anthony Huber comes in for the second lick to the shoulder neck area, trying to take his head off. And when he does that, his other hand goes grabbing for the gun, his bare hand onto the gun and pulling it away from Kyle Rittenhouse. Mr. Binger wants Kyle to sit there and hope and pray to God his strap works, and Anthony Huber can't get the gun. We don't know that. We'll never know that as he's running away from him. A shot as the gun is being separated from his body, and you'll see the butt way far away when the shot is finally fired. Even Gage Grosskowitz said he was concerned about the blows that Jump Kick Man and Anthony Huber were inflicting on Kyle's head. That's probably the only thing I agree with Mr. Grosskowitz. Gage Grosskowitz. The state must prove beyond a reasonable doubt that what Kyle did under those facts and circumstances was unreasonable, that he was not entitled to self-defense. Consider all the events that had occurred that evening. Him being attacked, kicked in the head, hit in the head with a skateboard, other individuals running up on him, and now Mr. Grosskowitz runs up on him. And the first action of Mr. Grosskowitz, and I'll go through the video later, is really he's running in, the hand is coming up, and the gunshot with Huber goes off. And the natural reaction is the flinch. He covers up. And then he pulls his hands up. And as he's standing with his hands up, look, he's not gripping the gun anymore in a pistol grip. Hands apart, hands up. And as he comes in to finish the job, the hand is on the gun going for Mr. Rittenhouse. And he says it's an involuntary movement. The shot comes before it gets directly to his head, but the motion is coming, the shot, and it continues on with that momentum. Enough momentum to go through the bullet and point directly at Kyle's head. Does Kyle fire again? No, he doesn't. Actions likely to cause death or great bodily harm, and he is coming in with a loaded Glock. And we asked Mr. Gage Grosskowitz about it. He wouldn't even admit that there was one in the chamber. That's why we had to put on the officer to talk about the unfired shell casing. Lukowski talked about clearing the weapon and a live round coming out. Because Grosskowitz won't say anything that puts him in a bad light. Grosskowitz, the person who has 10 million reasons to lie. And we all know he did lie, because he never gave a new interview after giving his statement saying he dropped his gun going down the street. Ladies and gentlemen, those are the charges. Those are a synopsis of the charges. As I stated, the burden is on the state, and they must prove beyond a reasonable doubt that my client did not have the right to self-defense. Kyle, as he sits here, is presumed innocent of all charges. If there is any reasonable hypothesis to reconcile with Kyle's innocence, that is what you are to choose. Remember, when looking at the burden of proof, they have it. Think about some of the things, the shoddy investigation, the rush to judgment from the Kenosha District Attorney's Office, the Zeminskis not being called as witnesses. They have the burden of proof. We don't. They want it to be that Kyle was out there doing something improper. Kyle was a 17-year-old kid out there trying to help this community. He was asked to provide help in protecting property at the car sources. It started, and he did it. He did provide aid, and he was asking if anybody needed aid. Whether somebody chooses to accept that aid, that's on them. But Mr. Binger wants to poo-poo his sincere belief that he's helping people because he borrowed bandages from Dominic Black, and I think he might have borrowed something from Lukowski also. But in the picture, when the Kindiri poses with all the people who are going to protect his property, there's Kyle's big orange gator box. He's got his pack on, filled with things, and he's willing to do that. Ladies and gentlemen, Kyle was not an active shooter. That is a buzzword that the state wants to lash onto because it excuses the actions of that mob on the 25th of 2020. Whenever Kyle was there, he reacted to people attacking him. There's numerous times, and you'll see him on the video, he does not shoot. He runs 2 blocks from 63rd to 61st Scene 2 without firing his weapon. Individual hits him in the back of the head. He does not turn around to address that threat. Huber takes a swing at him with the skateboard like that. Kyle blocks, and the skateboard's knocked out of his hand. He doesn't turn around and shoot him. He keeps running and falls from the 2 hits. He's run that far, and yet somehow he just fell over on his own. As soon as he's on the ground, they're there attacking him. And you see the people the law of self-defense. You've seen it, you've heard it. Now I'm going to go through the witnesses. Oh. Dominic Black, first witness, charged by Mr. Binger for providing the gun to my client. 2 counts, looking at up to 6 years in prison. His case has been adjourned so that he can help the state. I don't think he helped the state that much. I think he was a pretty truthful witness, all in all. He told them about Kyle there to help people, that they had permission from the Kindiris, that he saw Kyle help the woman with the foot, help the person with the hand. Mr. Binger wants to just say, oh, that doesn't matter. If it wasn't Kyle, it would have been somebody else. The point is, he was there and he did it. There was no pointing by Kyle of any laser sight. There was no ability for Kyle or him to point laser sights at anyone because their guns didn't have the type of optics that did that. He said Kyle was there to help. The only person helping was Kyle. And he can say what he wants about whether or not he let Kyle take the gun or not take the gun. He never told him not to. He went to the location with him. They bought straps at Jelensky's together. He's trying to cover his butt a little bit. The guns were there, and they took them. They took the guns, as he said, to deter people attacking them. He saw Kyle at the end, sweating, was in shock, and said that he shot someone, he had to do it. That is Dominic Black. Corey Washington saw the rioters breaking up concrete at the church parking lot, described Rosenbaum as erratic, stated the crowd was suspicious. I don't know what that means. One of the things that I thought was strange was the night before they were burning garbage trucks, but they only burnt the old ones. I think that tells you something about his point of view, that there's a certain amount of property damage that is justified and okay. Kenosha was using those garbage trucks that the rioters lit on fire. And nothing regarding property destruction was going to do anything to help Jacob Blake. We also learned that Kyle Rittenhouse smokes cigarettes, and that he has an affinity for the Dinosaur Museum. Detective Howard, ladies and gentlemen, Detective Howard's testimony and Detective Antaramian's testimony is the stuff of what reasonable doubt is made of. Two detectives, both lead officers on this case. They've sat through every minute of this trial, and their opinions of the actions of Mr. Rosenbaum from testimony, videos, couldn't be more diametrically opposed. Detective Howard, on cross-examination, knew that the guy was hiding in the car and jumped out from behind the car and began chasing Kyle Rittenhouse. Oh boy, that's not good for the state's case. So there's the old chit-chat between Mr. Howard and Mr. Antaramian and the prosecutors after, and all of a sudden we've come up with the new theory. And you heard the new theory that he raised the gun and that's what's on the video. Could I have the firearm, please? Told me he checked it.
He checked it?
He told me he checked it.
Okay. When? Before lunch. After lunch? Before lunch. Check it again.
Think about when Kyle Rittenhouse is firing the gun, when he's seen holding the gun throughout the events of the 25th. Shouldering the gun, and I'm not going to bring it all the way up to my shoulder, to the right shoulder, which would be a stance like this. The reason I objected in his closing argument is because that's not the way he was standing. If he's standing like this is right-handed, pointing the gun this way, up at the ready, his back would be to the drone footage. In the drone footage, you see the arm. It would be somebody having to hold the gun left-handed. This is a right-handed firearm. If this gun is brought up to his face and it is pulled back, the shell casing, hot, and the fire that ejects it is going to be going right into Kyle's face. The photograph I'll talk about later. You don't see the straps on his shirt. It didn't happen the way he said. It doesn't happen the way in the photograph. I'm going to need this again, but I'm going to set it down. Burden of proof, once again. The telephones, the searching of telephones with search warrants, the subpoenaing of records. I have no problem with that. It's good police work. But when you pick and choose and you make favorites, it's not. My client testified, and I'll say it this way, the detective testified that my client's phone was sent to the FBI. It was unsearchable because of the operating system. The FBI and the federal government had not cracked it yet. We found out about that. We had nothing to hide. Here's the numbers. Search the phone as long as we're given a simultaneous copy. So we have what you have. We can have our experts look at it. They can have their experts look at it. So we know that there isn't anything added or deleted. We did that. We gave that to the state. If we had something to hide, they never would have gotten in that phone. They took the phone, they made a copy, they searched it. Lo and behold, nothing of an incriminating nature in it, nothing militia, white supremacist, any of that. Gage Grosskowitz, different story. They had a valid search warrant for it. The only search warrant that these guys have never not executed when it's sitting right in front of them. Not just that, but Mr. Groskowitz could have consented to them going in the phone. If he has nothing to hide, why not? Why not let them look in the phone? And let's take common sense and judgment one step further. Police officers get search warrants, they execute the search warrant. Sometimes somebody feels as though their rights have been violated, and it gets litigated in a court of law. If it was illegal, the information in that search warrant never comes out in court. If it's legal, after a judge has said there were no rights violated, it comes in evidence. What was Mr. Groskowitz afraid of? Why wouldn't the state execute the search warrant, let Mr. Groskowitz and his attorney object, file a motion and say you can't go in my phone? Let the judge decide, not the person who's prosecuting and protecting Mr. Groskowitz. Come on, people. Mr. Groskowitz has 10 million reasons for not wanting somebody to go in his phone.
Yep. That lawsuit.
The timing with the detectives and some of their actions, I think, are very important. They get down to Antioch at about 3:30 in the morning of the 26th, less than 4 hours after this happens. By 6 o'clock, 6:30, given the benefit of the doubt, Kyle Rittenhouse is under arrest for first-degree murder. There's not been any autopsy done. There haven't been any witness statements taken. They've got 2 or 3 videos. The bullets, I should say it this way, all of the bullets have not even been picked up from Car Source at this point. But they're willing to make a decision. And were they under pressure? I'm sure they were. They're afraid that there's going to be another night of looting, destruction in Kenosha because of this happening and the way the word got out. He traveled across state lines. He was here. He brought his AR with him. The AR was here. He was a white supremacist looking for trouble. Nothing. Nothing. That's why, ladies and gentlemen, when we picked you guys as jurors, we asked you if you could decide based upon the evidence that happens in the courtroom. Not what you'd heard before, not all of the lies and untruths that have been put out in the media. I heard one guy say, my client discharged the gun 60 times. Ladies and gentlemen, what's happening in court is what you decide the truth on. He was charged on the 27th. Still, they didn't have the information, the autopsy's final, anything like that. Ladies and gentlemen, this has been a rush to judgment. Richie McGinnis, I talked about earlier, citizen journalists. Mr. Binger talked about him seeing guns. But remember the cross of Mr. McGinnis. Guns are not legal in Portland, Washington, or D.C. or New York. They're not allowed on the streets. You can be arrested. There are state laws. And ladies and gentlemen, the gun in this case is no longer an issue. Whether or not it was a dangerous weapon as it applies to the charges is. But my client is no longer charged with minor in possession of a firearm. But he needs his AR-15 and the assault weapon and the fear that goes with that to try and bring home an unjust guilty verdict. Ryan Balch had never met Kyle Rittenhouse before the evening hours of the 25th, has never spoken to him or known him after. And yet the state wants you to believe he made up something about a threat to kill. Why? What's in it for him? the threat. If I get either of you alone, I will kill you. That is a threat with a statement and a promise. And lo and behold, the chance presented itself to Mr. Rosenbaum, and he attempted to execute it. And I don't for a minute believe that he would have done it if it was Mr. Balch, who's much bigger than my client, muscular, well-built, and much more assertive and forceful. Rosenbaum, like any, as he referred to him, I don't even know what he called him, a ragdoll, whatever, but the little guy who gets beat up likes to go after the next littlest guy. He saw Kyle alone, and that's what he chose to. Or he could have been mistaken and thinking it was the other person at the ultimate that he went after and had to be held back. They were dressed very similarly, baseball caps, mask, and the only difference was the difference between shorts and a long pants. I can't answer that. Mr. Rosenbaum at this point, I guess, can't either. But you see Mr. Rosenbaum right around the time in question at that location, menacing with his chain. I'm going to finally get this right. I skipped. That's Mr. Balch. I talked about him going on. Ms. Amber Rasmussen, she was the DNA expert. What I say to you is DNA is an incredibly useful tool, but DNA is only as useful as what you put into it. And if DNA shows anything, it shows that it's not proof positive in this case. We know in hearing from Dr. Kelly that he most probably touched the gun. It was a contact wound is the way he described it. And we know through the videos, Huber touched the gun with his bare hand, and yet no DNA was found on that gun. So don't let your eyes deceive you. Don't let the physical evidence be discounted because of what she said. The end of that barrel was not swabbed. And we know he had to be at the end of the barrel, or it would have had the soot on all of the fingers. Jason Lukowski, thought was an interesting witness. He was the Marine who put the phrase, shout, shove, show, shoot. And I asked him about that, and I don't for a minute disbelieve that that's the Marines' rule. Is there any retreat in there? And he said no. He looked at me like I was stupid. The reason he looked like that was because they don't retreat. Yet Kyle Rittenhouse did retreat. He tried getting away from Mr. Rosenbaum. He described Joseph Rosenbaum as belligerent, with malintent, used the N-word, did the false step thing, did not see Kyle as aggressive. He was there for a shorter period of time than anyone else at CarSource. He also cleared Gage Grosquist's gun after the shooting and made it safe, took the shell out of it. And I ask you to think back to the direct examination of Mr. Lukowski by the state. When they asked him, what did Kyle say to you? His first statement was, I just shot somebody, I need help. That's what he testified to. And then Mr. Binger shows him the statement and gets him to say, well, I told the FBI that. Ladies and gentlemen, I don't know what he told the FBI. The FBI...
Uh-oh, it froze. Why are you freezing on me? It's frozen. Yeah, it's all the way frozen, guys. It's not me. Their video's frozen. Let me go back. I think it's their video. Hold on, I'm in the middle of a tournament. I'm in 4th place, and actually, I'm in 2nd place.
And made it. Binger.
Yeah, they're frozen. It's not me, guys. Let me try a different one. Son of a bitch. Hopefully the other ones aren't frozen. Nope, they're frozen too. Okay, it's not me then. Maybe YouTube's censoring them too. Maybe YouTube's censoring them too. Oh, because he brought up the FBI? Yeah, that's a possibility. Yeah, it's definitely interesting. Look. Alright, let's see what happens.
He'd been off his meds for the week prior. The videos of Joseph Rosenbaum show the state that he was in. No proof that he ever took his meds. Saul Kindiri. He was the first of the Kindiri brothers to testify.
Liar.
Car source. He's in the picture with all the people who protected his property. He's there, and he said he just liked the military garb. Why did he get a picture then with just one of them? How did he wrangle all these people up? Everybody in that picture said that they wanted him there. They gave him permission. Even Dominic Black concurred in that, the state's witness. But as I said earlier, they want these two guys to dirty Kyle up. He's just picking a spot to pick trouble and to be there and cause problems. He was asked to provide security. He did. They deny that they were going to pay any money, yet Nick Smith says they were. And going to pay money to Nick Smith. And ladies and gentlemen, do you get the feeling that they're a little afraid of being sued, as everybody else in this case is? I think so. And when they were up there, I don't remember them saying, oh, you can protect car source 2 or car doctor, but don't go to car 3. They had somebody arranged to protect car source 3, and the word came in that they had left. Dominic, Balch, Joanne Fielder, all of them say they had permission. Why would they lie about that? How does that protect them? They're not charged with anything. Who's the people who are lying here? Sal and Sam. Next, Police Officer Widener. He was the ET. He went and recovered some of the 2.23 rounds from car source. I believe he found 3 of them. The other 2 were found 3 days later. He photographed a mask. He didn't find the bag, and we do not concede that there was nothing in that bag. Not for a minute. They have the burden of proof. They have the burden to preserve a crime scene appropriately, get the evidence, and show it to you. Ryan Balch said he smelled ammonia and bleach. They didn't find the fire extinguisher. We know that the fire extinguisher was there. It's in the videos. But that doesn't fit in the state's narrative of Kyle actually going there to put out a fire, which had been started earlier in the Duramax. Officer Van Wee recovered the last 2 shell casings. Strike that. I love technology. Officer Van Wee. Officer Moretti. He was the driver of the squad car that Kyle tried to surrender himself to. He said it was a war zone. It was a war zone those 3 nights. He described it as the city on fire. The police felt as though they were completely surrounded, described the constant gunfire that evening. Mr. Binger wants to slough it off as fireworks this. It really wasn't that bad that night. Ladies and gentlemen, it was hell in this area downtown. There were violent people causing trouble. And the state wants us to believe it was okay. The police pushed them back. Now they could leave. Car source was safe. and I can't remember specifically what witness it was, but it stuck out in my mind. The witness said the police pushed him back, let him back, pushed him back, let him back. And a lot of the burning happened late at night, that witness said. Gage Grosskreutz, 10 million reasons to change his statement. His attorney is sitting in the courtroom, has been sitting in the courtroom when he testified. If he's just your average complaining witness, why get a lawyer? What do you got to hide? He didn't have a valid concealed carry permit. He wasn't charged. He lies to the police about being armed that night. He said he dropped his gun going down the street. Ladies and gentlemen, that's what's called obstructing. Most people, when you lie to the cops, especially in a murder investigation, you get in a little bit of trouble. I've represented some of those people. Not Mr. Grosskreutz, because he's their star witness. Bought, paid for, and protected. You don't want us to search your phone? Oh, we're going to invoke the never heard before Marsy's Law exception to the search warrant, even though they had a signed search warrant by a judge of Kenosha County. He was also an armed medic. Wants you to believe that he didn't have one in the chamber and he would never shoot somebody. But before he said that, he said key, wallet, phone, gun. Never leaves the home without them. Ladies and gentlemen, I don't carry a concealed weapon. And I don't think I could shoot somebody. But when people carry guns, that's what they're for in the city. This isn't the Wild Wild West. He had his gun. Kyle Rittenhouse had run by him. You'll see the picture. Was by him, gone. Did he go to give medical help? He didn't know that Mr. Rosenbaum was being tended to. No, he decided to run in and advance on the fray. He, the affiliated with the American People's Revolution here in Wisconsin. And I might have that one word wrong, but he did it. And who ultimately put the tourniquet and fixed it on his arm? But Mr. Lukowski, a member of somebody he refers to as the militia and the Stooges. Two different encounters between Gage Grosskreutz and my client. The first one, he does not show or give any indication of a weapon. My client does not point a weapon at him, does not shoot at him, does not swipe the weapon towards him. He states he's going to the police. That is uncontradicted. Why doesn't Mr. Grosskreutz let him be and go give aid and comfort to his fellow rioter? But instead, he joins the mob, chasing Kyle, arms himself, and runs in the fifth or sixth person into the melee in scene 2. And when his friend was called, his friend said in his Facebook post, his only regret was not emptying the clip into the kid. So we know what his intent was. We know what he wanted to do. Kyle shot first as he was coming in. And Mr. Binger talks about, oh, he was going to grab the gun. Ladies and gentlemen, left hand, phone. How's he going to grab a gun with a hand filled with a phone? Right hand, gun. He goes back, loads up, and is advancing. That's when Kyle shoots him. He didn't shoot him when he put his hands up, and if that was it, no intent to harm him, all he does, like everybody else, is back up, and nobody else gets shot. But Mr. Grosskreutz decides he's going to shoot my client. Unfortunately, my client shot him first. If he had retreated, it's over. And when he's got his hand up like this, as I said earlier, the hands are up. It's not gripping the gun, it's loose. But when he goes in like this, the pistol grip is tight.
That's what she said.
Heather Williams,
That's what she
Crime
said.
Lab. She testified that the gun works. I have no dispute regarding that. Detective Krieger, he was in the passenger seat of Moretti's car, pepper sprayed, did not get his ID, didn't ask him about the gun, just told him to go home. Kristen Harris, Rundown Live, stated the video, we showed the video to start this, clearly depicting Mr. Rosenbaum standing there at Car Source 2 shortly after the dumpster, standing there with his chain, the shirt tied up over his head. But Mr. Binger says it's impossible for him to have threatened my client. That's garbage, just like his case. And Mr. Binger makes so much out of him one time saying, stay on your property. My client has as much right to go anywhere in downtown Kenosha as anyone else. Just as the rioters did, and as he walks out to see if anybody wants medical help, he's not doing anything wrong. He's not doing anything to provoke anybody. Detective Antaramian, the juxtaposition of him and Howard, as I said, he is the one who talks about what he sees in the video, totally different. As you see, why did Mr. Rosenbaum go behind that car, 2 cars over from the Zeminskis? What was he doing over there? Why was he doing over there? And why does he come out as soon as Kyle comes down the road? Because they were going to ambush him. They had set it up, and I'll show you the video. James Armstrong. The only thing I can say about James Armstrong is, okay, that's interesting. But what I'd like to say about his photographs, his knowledge of what he did, and some of the statements that the state has made regarding it is, what he did for those 20 hours is hocus pocus, and he makes an exhibit that is out of focus. And that's what the state is relying. The picture does not make sense. As I showed earlier, it has Kyle shouldering the gun in the left shoulder. If he has it in the left shoulder, his back would be to the drone. The drone is moving around, and that changes the focal point. He's right-handed. That's where it goes. You'd see the crosses across his chest. But no, they need him to have somehow pointed a gun at the Zeminskis. I don't for a minute concede he did, but we know that Mr. Zeminski has been armed all evening. How would pointing a gun at Mr. Zeminski provoke Joseph Rosenbaum, who, according to the state, earlier in the case, they didn't even know each other? But I think they had to run away from that because there's so many pictures of them together. Mr. Armstrong's photograph, testimony, it took 3 days and 20 hours worth of work to come up with that picture. It went from color to black and white, and he admitted he never compared it to the original photograph. Still shot. Didn't take into consideration the fact that the drone was moving. The word peer-reviewed, state has said. Peer-reviewed is an independent verification of the events, the exhibit. So there was no testimony to this because it didn't happen, that Mr. Armstrong's coworker did 20 hours on the same photograph and came up with the same result. It didn't happen. When you see, and I'll show it to you later, when you see in the video the mirror and the shininess of the mirror, That's what that is. And by going around, spending 20 hours and bringing things up, it doesn't account for Kyle's arm. It doesn't account for the heat signature of the gun. None of it. Dr. Kelly. Personally, my favorite witness, because physical evidence doesn't lie. The soot, extremely close, if not touching. The location of the soot, I had him circle it on the exhibit. On redirect, after I had him do the demonstration and draw on the photograph, the state tried to get him to back up his opinion and back it off. He wouldn't, because the physical evidence doesn't lie. It's, as they say in the business, an inconvenient truth. They can't change it. It is what it is. That's the demonstration that happened in front of you, the gun and the hand. And if the individual's coming straight at it, the barrel of the gun, it would go through the hand like this. But we know that it was coming from right here, going down, and came out with a very clean exit wound. No soot here at all. So we know that the gun can't be here. We know there's just a little bit of soot on what's commonly referred to as the ring finger right here, and the bulk of it goes this way because it was over the gun, touching the gun. And Mr. Bigger says he was swiping at the gun. Ladies and gentlemen, he didn't need to chase him, didn't need to keep chasing him, didn't need to lunge at him, didn't need to swipe at the gun, i.e. grab the gun. And the shot to the back, as I said, 4 shots in 3/4 of a second. He's backing up, trying to stay away from him, shooting, and he shoots until the threat is immobilized. Ladies and gentlemen, other people in this community have shot somebody 7 times, and it's been found to be okay. And my client did it 4 times in 3/4 of a second to protect his life from Mr. Rosenbaum. I'm sorry, but that's what happened. And this is the prosecutor who said he shot him in the back. He shot him in the back on a horizontal plane consistent with lunging. The shot goes in here and ended up in his lower hip across the back. If he's on the ground or down and shot, the bullet goes into the back and ends up in the stomach or on the other side. It cleared back here, ended up in the lower hip. That's because he was on a horizontal plane when Kyle shot him. He had stippling to the stomach from the first. The pants stopped it from lower, but it was still on the upper. The furthest he was away when the first shot was fired was 4 feet and closing. 4 feet. I think it was Mr. Krause and I who had the fight about how far 4 feet is. It's not that far. It's not that far at all. Brought a tape measure so I could measure a gun barrel for you today, but that's no longer an issue. So I'll show you what 4 feet is. No doubts. From the edge of the jury box to my foot right here, 4 feet. Lunge, grabbing the gun. Think how close that is. Think how fast that distance is closed. What was Joseph Rosenbaum doing? Was he running after my client to give him a key to the city of Kenosha? Was he running after my client to say, hey, thanks for providing security? Use your common sense and your judgment. Look at Mr. Rosenbaum's behavior throughout the night. As I showed you, these are the pictures. One last. Get you the pointer. Exhibit 105, Dr. Kelly. So, right here. Here's entry. The exit's right over here. Goes across, clean, came out right there. This right here, nothing. Nothing on the back part of the hand, no soot. We know what was over the barrel. Remember Mr. Kraus asking the doctor, well, what about that big puff of smoke? That wouldn't have an effect. Soot only goes so far. That was Dr. Kelly's testimony. He doesn't have a dog in the fight. He looks at the bodies, says what they are, makes a determination, and looks at the evidence. We had an expert, didn't call him because Dr. Kelly told the truth. Couldn't agree more. Ladies and gentlemen, facts and truth matter. In most trials, the case would have ended with Dr. Kelly. But we wanted to bring you our side of the story. We had nothing to hide. We were going to put on a defense. I heard Mr. Binger say red herring. The red herrings in this case are by the state, talking about super bullets, this metal jacket. I've been involved in homicide cases. One time it's a metal jacket. The next time the problem is the person had hollow points. Hollow points are designed to kill. Full metal jackets are to go through people. Ladies and gentlemen, bullets are bullets. Hate to tell you, at close range and close contact, they wreak havoc on a body and they kill people. No dispute. Wants to keep pointing at the militia, the militia, the militia. He knows Kyle's not a member of the militia. He has no evidence that he is. They went to the websites. They went to TikTok. They went all of that. All they can do is put up a little thing of a 17-year-old kid from his TikTok trying to be famous. Kyle shot Joseph Rosenbaum to stop a threat to his person. And I'm glad he shot him, because if Joseph Rosenbaum had got that gun, I don't for a minute believe he wouldn't have used it against somebody else. He was irrational and crazy. Talked about active shooter, the power of those words. My client didn't shoot at anyone until he was chased and cornered. Nick Smith got a phone call from Sam, asked on the second night of rioting to go down there. They used the power washer and buckets to try and put out cars. He did that out of the goodness of his heart. Sam asked him to come and protect the next night and be paid, and he agreed to do it. He asked some of his friends to come with to help. Kyle, Dominic Black, talked about another father and a son, and then the people from West Bend showed up. He said that when they first saw Sam on the 25th, Sam gave him a hug and thanked him for protecting his property. He was on the roof when it was chemical bomb. He knew that Sam was grateful for their presence, but he also knew that people on the ground needed weapons. He heard Kyle when Kyle came back saying, "I had to shoot." Body armor. I don't know why the Grays Lake Cadet Program gives people body armor. Don't know. My client had it. And if he wanted to be an active shooter, as Mr. Binger wants to portray him, why would he give up his body armor? Nick Smith wanted body armor. He goes, "Here, Nick, use mine. I'm going to be doing medical." Helping other people. You see him do it throughout. He gave Nick his body armor. Why would somebody give up their body armor if they're going to go out looking for trouble, seeking confrontation? Doesn't make sense. Joanne Fielder, she described Joseph Rosenbaum wearing a red shirt with a green earring. She described yellow pants, who I'll get to later, She stated Joseph Rosenbaum yelled he was going to kill us MFers and cut their hearts out. JR's arm goes up, and within seconds, they're tearing up from a gas bomb. She couldn't say for sure that she saw him throw it, but obviously that's the circumstantial evidence in her belief. She never saw Kyle act inappropriately with anybody, point a weapon at anybody. The size of the weapon might change, but it doesn't change what it can do. Presence speaks volume. It's a deterrent, and they've been pelted all night long with rocks. She was aware that they had consent to be where they are. Nathan DeBruin. Interesting witness. He was out there taking photographs on the nights in question, more importantly the 25th. He filmed the destruction of this community, uptown, downtown, and the ATF and the FBI found out about his videos, his still photography, which I think was incredible. They wanted it, and what did he do? Didn't ask for money, he gave it to them. He sat down with the detective and gave a full interview, showed him the photographs, talked about Mr. Rosenbaum and all the problems he was causing that night, the things he was doing. And that's within less than a month after this. He'd never met Kyle Rittenhouse, didn't know Kyle Rittenhouse, but he had a feeling about what happened that night. And he said if there was trouble, Mr. Rosenbaum was there. I don't think any truer words have ever been repeated. Did he have a lawyer when he met with Detective Howard? No, he didn't. When did he get a lawyer? Remember? After he met with Mr. Krause and Mr. Binger. Mr. Binger, the person who's made it his personal goal of putting my client's head on his wall. Ladies and gentlemen, that's what it did. And it means he's been cutting corners. And Nathan DeBruin said, after meeting with Mr. Binger, I was very uncomfortable. He tried to put words in my mouth. And he had to go and hire a lawyer to protect him. First, it was show him the videos and then ask him the questions, trying to put words in his mouth. He didn't want that to happen. He wanted to be able to tell his story of what he knew, what he did. He talked about Zeminski, the photographs of all the conduct that Zeminski had done that night, and I'll show you some of them. The photos have a timestamp on them, and he related to Detective Howard in September of 2020 about Joseph Rosenbaum yelling, I just got out of jail and I'm not afraid to go back. Those are his words that he heard Mr. Rosenbaum. It was not objected to by the state, and there's been no proof that he wasn't in a jail. They want you to believe he was in a hospital. There's no medical records he was in a hospital. There's no medical records he was properly medicated. And I submit to you that in this case, the way he was behaving, I don't think he was properly medicated. There's pictures of him with the trailer fires, the chains, starting numerous dumpster fires. I submit that he was with the Zeminskis on many of the occasions, and he was emboldened by Mr. Zeminski because Mr. Zeminski was always brandishing his firearm. We saw Joseph Rosenbaum taking the chains. He chose to come down and riot, and that's what he did. Nathan DeBruin chronicled that. Why did he chronicle it? Because it's not very interesting if you take a picture of a protester who's just standing there, but Mr. Rosenbaum was involved in all these different things, and I'll show you those pictures. Lucas Zanin, Kenosha County resident. Every now and again he goes down to Texas in the winter. Testified, born and raised. He stated he had empathy for the small businesses of Kenosha, did not want them looted, did not want them burned. Is that somehow to be called into question? Does any of us want those fires started and to come and burn? I don't think so. He authenticated the video that was taken from his car as accurate, showing the south side of car source 3. And you watch that video and you see people destroying someone else's property. During the video, you look at the one wall, there's nothing there. You see somebody spray painting on it, and they've written the word loot on it. You see another individual going in the hood of the car, trying to do something. It's not his car. He's not some roadside mechanic. They're destroying property. Ladies and gentlemen, Mr. Binger and I will go round and round about it until the cows come home. They were rioters. They weren't demonstrators. Were the demonstrators down by the courthouse earlier in the night? Yes, there were people doing a legitimate demonstration. These people were rioting. And you see in his tape, they're hitting the cars with pipes. You hear the glass breaking. You see the people jumping on it. And the important part of it, and I'll show it to you, is you hear the first bang, which is Mr. Zeminski's shot. 2 seconds later, you hear the next shot, and then you see the exodus of all the people taking off from that. That's why Kyle couldn't run and continue to run from Mr. Rosenbaum, which he was under no legal duty to do whatsoever. Jacob Marshall referred to himself as Gage Groskitz's best friend. We brought Mr. Groskitz's best friend in as a witness because he had posted something on Facebook immediately after this. He testified he couldn't find Gage Groskitz because he was under an anonymous name at the hospital. Nobody knew who Gage Groskitz was, who Jacob Marshall was. But he takes it upon himself to post a Facebook message talking about how, could I have the next slide, please? I just talked to Gage. To his only regret was not killing the kid and hesitating to pull the gun before emptying the entire mag out. Coward. Here's the picture of them hugging each other at the hospital. And this is posted. Ladies and gentlemen, why does somebody post something like that? Because that's what his friend told him. And he wanted to get Gage Groskitz's word out. He didn't repost and say, I lied. He took it down to try and hide it. But unfortunately, the internet has a memory. Next witness was Kyle Rittenhouse. I'm done with the Kandari brothers. We did recall them, but I talked about that. Kyle Rittenhouse did not have to take the witness stand to tell his story. It was told through video. He wanted you as the jurors to hear his personal experience of the night of the 25th. He knew Mr. Binger would cross-examine him for hours, and he was willing to get up on that witness stand, take the oath, and tell his story the best way he could. And he did. Could Mr. Binger pick on him and find little things about it? A little bit. Did he damage his credibility? I don't think so. Getting to Mr. Yellow Pants, which he's been talked about. Mr. Binger talks about, he says with sarcasm. Ladies and gentlemen, you've seen the video. But remember that when Yellow Pants said to Kyle, he goes, you held your gun like this. That's low ready. That's not like this. It's down. He never pointed his gun at him. Did he have a gun? Yes. Did he tell him to get off a car? Yeah. But when he said it to Kyle, Kyle said, I did, and walked away, not wanting confrontation. And remember Richie McGinnis's testimony about that. There was the individual with the slingshot, there was the individual with 2 rocks in his hand, and the other individual with the gun. And when Mr. McGinnis walked up to him, he immediately had to put his hand down because they were the one advanced on him, and he bought him off with a White Claw. My client, when this happened, was 17 years old. His actions are to be judged as a 17-year-old, not by Mr. Binger's standards, but by that of a 17-year-old. And Mr. McGinnis said he didn't appreciate the way people looked at him. And maybe he didn't. And I think the best evidence of that is when Mr. Rosenbaum begins chasing him, you hear on the tape he yells, "Friendly, friendly, friendly," 3 times. He thinks that if he just says the magic words, they'll stop. They don't. They could have, Mr. Rosenbaum could have looked at it and said, "Hey, you're not trying to harm anybody. I'll leave you alone." Is that what happened? No. He said, "You ain't going to do shit, mother effer," and began to continue to chase him. Mr. Rosenbaum made a fatal mistake. That day, chasing Kyle Rittenhouse into the corner, he ran as far as he could, and he shot 4 times in 3/4 of a second. Mr. Binger makes so much of Kyle's residence. Antioch, Illinois. I think most people here know where it is. It's not a foreign country. Antioch, Illinois, right across the border. He worked in Kenosha. His dad lived in Kenosha. His grandmother lived in Kenosha. He worked in Pleasant Prairie. His best friend, Dominic Black, lived in downtown Kenosha. They want you to believe that there's some sinister thing about that. Ladies and gentlemen, we live in a very mobile world. I'm from the foreign country of Racine, Wisconsin, 13 miles away, a little bit further. I'm on the north side. Ladies and gentlemen, when Kenosha burned, people who like Kenosha, they hurt. I remember 34 years ago walking into this courtroom, first time I ever appeared as a lawyer, back in that conference room. And when I saw what happened in Kenosha, it bothered me. Those 3 days. People can protest, but people can't indiscriminately burn property for no reason of innocent people. How does that further anyone's cause? Kyle feels for this community. He worked as a lifeguard. When he came down here, are we to believe that he's working to clean up graffiti, not getting paid because he's here to look for trouble? Is this all some master plan? That's ridiculous. He came down here trying to help, to see the damage, and that's what he did. Next. Dr. John Black, his testimony about the slides, making times, and I'll go over some of those. But specifically, as I argued earlier, the 0 shot from, I should say it this way, friendly, 3 times to the first shot, 10 point some seconds. There's a change in elevation in the video as he's lunging forward. The shot rings out after that. The 0 shot, which is shot 1, then 2 2600ths, the next one 24, 23, for a total of .739. He gets up, he comes around the car because all the individuals had left. After hearing the shots, goes to check. And to believe that he could stay there is preposterous. All I said would have happened, scene 2 would have been moved to scene 1. You heard the one individual yell, "Get the F out of here." The Zeminskis are screaming, "He just shot him, he just shot him, get him, cranium." That's all happening. Mr. Zeminski's walking around with his gun over his head, pointing at Kyle, and I'll show you that in a little bit. In the exhibits that Dr. Black showed the jury, no color was added, no color was subtracted. The videos didn't go from color to black and white. There was no structural problems. He demonstrated his technique regarding changing brightness and contrast right in front of you. And the one video went from a dark mess of nothing, move the two lines, I don't know how to do it, but he did right in front of you, hit it, and all of a sudden it's light and you can see it. The whole event that evening took 2 minutes and 55 seconds from the 3 times friendly to the time he surrendered or attempted to surrender at law enforcement. Officer Brittany Bray, let me go through the, back up to the first one. Total time, 2 minutes, 55 seconds, according to Dr. Black. Next, friendly, the 4 shots, 10.8 seconds. Those are the shot times. Remember the sound he put and synced up with the video? That was the audio graph, the green thing he showed you. You can see when the shot is fired, he matches it up, times them out by the frames per second. You come up with those numbers. And that's because when you show something in slow motion, it looks like somebody can really have the time to think, process, and do all that. You have to remember how fast all this was happening in event number 1. He's running, the bag is thrown, he turns, addresses, keeps running, and makes a decision, a life and death decision, that he has to turn around and address the threat of Mr. Rosenbaum. At that point, Kyle is stopped. Mr. Rosenbaum, like those other people in event number 2, could have put up his hands and just backed up, made a bad decision, shouldn't have done it. No, he goes diving for him, yells the FU, and is going for his gun. Next. Event 2, I have it beginning when he's hitting the head with the rock and ending with the 4th shot, taking 14.9 seconds. Next, police officer Brittany Bray measured the gun, the pullback, the slide, 4 inches, brought the ruler out, because you never see in event number 2 Kyle pull back the 4 inches, slow motion or otherwise. There were no unfired bullets found at the scene for the AR. There was the unfired bullet by the clip and the Glock that had been cleared from Jason Lakowski. Drew Hernandez. Mr. Binger, for some reason, didn't like Drew Hernandez. You could hear it in his questioning. Ladies and gentlemen, Drew Hernandez had a point of view. There's no doubt about it. But what was that point of view? He's a citizen journalist, and he's covering the riots. And he didn't think that the mass media was covering the riots correctly. They were just calling everybody demonstrators and not covering the devastation and the destruction that was being done. That's his point of view. It's kind of my point of view too. But does that mean that his video's lying? Does that mean when he says, I saw him lunge, that he's lying? He doesn't have a dog in this fight. He tried to get all of his video to the state. The Dropbox wasn't big enough. He sees that the case is going to trial. He reaches out, gets a lawyer, and provides it simultaneously to both of us, and we end up playing it. He describes the Zeminskis, Joseph Rosenbaum starting fires in the dumpster, the yelling. He sees Kyle, the yelling of the word, the N-word. He sees Kyle walking around yelling medical, medical, right up until the last time when event number 1 starts. He was standing right at the corner, had a clear view to the first incident. He described him as charging from behind. He saw Joseph Rosenbaum throw the bag. He described hearing a shot from behind Kyle, which we all know is the Zeminski shot, the man who's never been brought before you people. And he saw Joseph Rosenbaum lunge. Ladies and gentlemen, you sat through almost 10 days of testimony. You've heard the openings, most of the closings, and I have yet to hear Mr. Binger explain why Joseph Rosenbaum had the right to chase my client. To me, if I didn't know better, I would think he's a whiny defense lawyer. Everybody's out to get me. Everybody's lying. I'm the one who's bringing forth the truth. Ladies and gentlemen, the videos show the truth. The videos show the actions of Joseph Rosenbaum. Balch is lying. Fiedler's lying. Lukowski's lying. Richie is lying. Dale DeBrune, he's really lying because he's imputing my character. Nathan DeBrune, excuse me. Hernandez, he's lying because he's a right-wing journalist. All 6 of them are lying. And then, I forgot, Detective Howard, he's lying too because he could see through the videos. He could see that Rosenbaum came out from hiding behind the car after my client passed the Duramax. Rush to judgment, as I said earlier, you bet. Highly charged atmosphere here in Kenosha. Make no mistake, you live here, you know. They had to do something. They had to charge the white supremacist, who isn't a white supremacist. They've never reassessed their case. They've never looked at it. They've never said, oh, Dr. Kelly, let's talk about this wound on the hand. What? That means he was touching the barrel? Or his hand was over the barrel when it was fired? Well, that means he was pretty close. No, we're not going to reassess. We're going to march forward. We're going to throw it into the hands of 12 people from the city and let them do our work. Ladies and gentlemen, this is a political case. We can take politics out of it as in Democrat and Republican, but the district attorney's office is marching forward with this case because they need somebody to be responsible. They need somebody to put and say, we did it. He's the person who brought terror to Kenosha. Kyle Rittenhouse is not that individual. The rioters, the demonstrators who turned into rioters, those are the individuals who bring us forth. And I ask you to remember, and I'll show you the videos for the last time from me, the anger in the mob that was going on that night. They were not going to be dissuaded from doing things. They were pushing, firing dumpsters, destroying property, and that was... So you're saying Mr. Rittenhouse put out a fire? Yes, it was a small fire. Last time I checked, small fires turn into big fires. So, kind of stupid. James Armstrong, hocus pocus, out of focus. I've talked about him. He spent 20 hours reworking a frame in a video and having my client somehow miraculously go from a right-handed shooter to a left-handed shooter. The mirror on the truck is the arm. Their whole case relies on that one photograph that he spent 20 hours. That's how they're going to prove provocation. A word you never heard in the opening statement. It was my client chased him down and shot him in the back. Oops, can't prove that. This is the day before, car source burning, car source 1 burning the ground. What's in the foreground? The trailer will be the subject. Pictures later on. There's Kyle earlier in the day on the 25th, setting up his alibi, setting up his I'm a good person story, because he thinks he's going to go out and kill 3 people that night. Ladies and gentlemen, that is garbage. How would he know he's going to be photographed? And what does that do? It just shows he's interested in his community, trying to do good. Picture, Mr. Kandiri at Car Source 3. The state doesn't want Kyle to go to Car Source 3. According to the state, he has to stay at Car Source 2, 59th and Sheridan. Yet, Nick Smith called and asked him to go there because whoever was going to protect that property had left.
On objection, Your Honor, the record does not indicate that Nick Smith made that phone call.
It's argument, folks, you heard the evidence and use your collective recollections to determine what the truth of it is and discount anything that is not supported in the evidence.
Testimony was he received a phone call saying they were destroying cars at Car Source 3, and he went down there. First, Kyle asked for a fire extinguisher, asked the other individual to go down there with him. He said, didn't give an answer, and Kyle took off going down there to try and help protect that property. This is that night, the tear gas, the fires. Here, it's Mr. Rosenbaum pushing one of many dumpsters, dumpster fires. Right there, that's one. Another one. Stop. Bats, guns, Mr. Rosenbaum pushing it in. Either the gas station or Drew Hernandez, police vehicles right down here. They're trying to push it to him. I apologize. They're trying to push the dumpster down to the line of police or to the gas station. It's put out, and the reaction from Mr. Rosenbaum of dumpster number 2. You hear the voice? Why you do that? Get over this. There's Mr. Rosenbaum arguing. Mr. Zeminski, the smiling puppeteer, standing behind him. Yeah, they didn't know each other. Maybe they didn't, but they sure spent a lot of time together that night. Mr. Zeminski with the yellow circle, holding his firearm. Yellow pants, Kelly Zeminski with a flashlight in her hand. Last time I checked, there wasn't any lighting problems. The flashlight is a weapon to bash heads if you have to. Many people with AR-15s, not one person with an AR-15. That's the difference between this, the Ultimate gas station, fracas, and what happened down at Car Source 3. Kyle Rittenhouse was alone. He had been taken away from the herd, and Mr. Rosenbaum and Mr. Zeminski were going to get him. Movement. Mr. Rosenbaum and his bag. He's not dissuaded by the people. He's going right at them. He's not afraid of them. He's pushing in and going at them. He's not afraid of a gun. Yelling. Shoot me, N-word. Shoot me, N-word. Mr. Zeminski holding his gun down to his side, remembering this is a Black Lives Matter rally, and he's there to support their cause. Yeah, right. Mr. Huber, right there, holding him back, actually physically holding him back, but right in the middle of it. Look at the anger in his face. This here I'll start it, but I'm going to point it out first. You saw a video earlier. This individual starting the Duramax on fire. Right here, jump kick man. You see him shoot in the lighter fluid or flammable liquid. You see jump kick man being right involved. This is the calm Tuesday evening that Mr. Binger is alluding to. Mr. Rosenbaum, this time wearing a blue mask, tipping over the porta potty. It was just a little porta potty. The trailer. The trailer is important because it's the way he arms himself with the chain. Here's Rosenbaum pushing it. If he's just a regular demonstrator or misunderstood, a little bit upset, what does he need a chain for? What does he need a bag? Why didn't he leave it with Ms. Swart? Here, three things. The blue circle is bag, backed up by the fire. Look at that bag. Does that look like there's nothing in it? Look at this. What is that? That's not a water bottle, ladies and gentlemen. I can't tell you what it is, but it's not a water bottle. Look at this. 2 feet of chain on each side. He's got it. Taken, I'm sure, from right here. The toe chain. Jump kick man. Right there, the mask, the white jeans, the black. Look at the boots. Those boots would soon be impacting my client's face.
That's funny, drunk uncle.
Rundown live. Here, once again, Rosenbaum, Zeminski at the trailer after it's been taken down the street, set up on its side, and started on fire. You can still see one of the chains hanging from the tongue of the trailer. Rundown live. The state showed this video. I started my opening statement with it. I was going to show you where Mr. Rosenbaum is. I've already done it. Don't need to waste your time. How do I get to the end? Oh. Here's the picture that we showed at the beginning. Right there, the 125-26. Mr. Rosenbaum masked with his chain during the Rundown Live video. Mr. Rosenbaum with the chain. So I said earlier, look at how Kyle's dressed. Look at the pack on his left side, left hip. The crosses going across the front and the back of his chest. Nowhere in the magic picture is that depicted. 11:40, he's crossed over that line, asking people if they want medical, runs into Yellow Pants. He walks away from confrontation. And Yellow Pants said, "You pointed your gun at me," and he goes like this, low ready. The individuals who were there with him, slingshot, rocks in the hand, gun. Mr. McGinnis. Kyle, after having the brief thing with Yellow Pants, he goes away from them, goes over, looks for Mr. Balch. They might have been close to one another, but they did not find one another. He tries to go back. Wants to get back to car source 2. After that, he goes back and waits. He gets the phone call. He testified about the phone call, either from Nick or Dominic. And what does he do? He gets a fire extinguisher. He hasn't had a fire extinguisher all night but he gets a fire extinguisher. The circumstantial evidence shows the call came through. He testified the call came through. You know, if it wasn't in his phone, the state would have brought it up. But now they're playing games once again. This is Drew Hernandez's video. It starts in color and goes, starts in black and white and goes to color. You have Jump Kick Man, the Zeminskis, and you'll hear Kelly Zeminski talking. And during the first part of the trial, we saw this trailer go by, and it cut off the view from this location. And I'll stop it a few times. And did you hear that? Talking about a pepper ball exploding in her ass. That's Kelly Zeminski speaking. Blurry. Keep your eye here and here. Kyle will come into you. That's Kyle right there to the right of the garbage can by that splurge of light. Mr. Rosenbaum, as soon as Kyle is coming, gets up and starts walking away along with Kelly Zeminski, this individual. Jump Kick Man was there earlier. Up there. That's Kyle with the fire extinguisher walking. Doesn't say anything to any of them. They see him coming, they head down to do their ambush. He's not chasing them. He's not running after them. He's walking down to put out the fire. Let's start it over again. You hear Kyle yell, friendly, friendly, friendly. That is the start of Mr. Rosenbaum chasing Kyle. Now they come in. He's thrown. It goes to the small. He's thrown the bag.
Duramax just got. Oh, that Duramax got fucking big.
Stop. Duramax. The shine on the Duramax. Kyle comes right into this area before he's chased. That's shown on the drone video. It's shown on the FBI video. The Zeminskis are standing right here. That's when the chase is on.
Yo.
You can hear the destruction of the vehicles as he approaches. Gun, gun, gun. And he's off and running. We've seen the videos. Here is the Zanine video, parts of it. As I said, watch for the first shot. Look at all those people. standing there, a wall of people destroying cars. The state wants Kyle to run into that wall of people. Listen for the first shot and watch the lackadaisical attitude, and then hear the 4 shots in quick succession and watch what happens.
Oh shit. They shooting. Oh shit. Oh my god.
Think about that, ladies and gentlemen. The first shot happens, they barely begin to move. Between the first shot and Kyle's first shot, which is the second shot you hear, Kyle has turned around. Why is he turned around? Because that wall of people is there and he has nowhere else to run. The cars, the van, all of the people destroying property, the soda machine, he turns around and Mr. Rosenbaum keeps coming. Mr. Rosenbaum keeps coming, he lunges, gunshots. There's Mr. Zeminski with his gun down there at his side as his wife yells, "Effing get him, he just shot somebody," which they started.
He fucking shot him! Get him there!
Pointing the gun, once again, in his right hand.
He fucking shot him! He fucking shot him! He fucking shot him!
Take screenshots. Good shot him.
Gage Grosskitz's cell phone video. Does Kyle ever point the firearm at Gage
John Bliss.
when he runs up on him, unarmed?
Shots. Hey, what are you doing? You shot somebody?
I'm going to get the police. He's going towards the police. He's continuing on. He's past Gage Grosskitz. He hasn't shot Gage Grosskitz. He hasn't pointed the firearm at Gage Grosskitz. The medic, if he thinks someone shot, why isn't he there? He doesn't know Richie McGinnis is tending to him. None of the people who chase him are at Car Source 3. There is no evidence. Zeminski doesn't chase him. Zeminski doesn't want anything to do with it. His wife doesn't want anything to do with it. But the mob has now formed and is chasing him down Sheridan Road in a northerly direction.
Who shot? Who shot?
He turns all the way around, looking towards Car Source 3. Could go there. At this point, he hasn't armed himself. Kyle is zero threat to anyone. This active shooter BS is something that Mr. Binger is trying to sell you people. Has he shot anybody since Car Source 3? No, he hasn't. He's running to try and get to the police. Mr. Binger must live in fairy tale land to think that Kyle could stop, put his gun down, and say, "Hey, everything's good, leave me alone, I'm going to the police." Unfortunately, that's not how the real world works. This was real world.
Hey, stop it!
People yelling to stop him. Next picture, you saw it in opening statements. Mr. Grosskitz chasing down Kyle Rittenhouse. Kept his gun in the small of his back. He's arming himself right here. Look how far Kyle Rittenhouse is ahead of him. No threat. He's run 2 blocks, almost 3 because it's at the far end of 63rd. He hasn't shot his gun since. If he's an active shooter looking to take as many people as possible, he's laying waste to everybody as he's running. Remember, he's got 30 bullets. He's shot 8 times, 4 in scene 1 and 4 coming up. He's He's not indiscriminately shooting, pointing, doing anything. Here's full speed. Pointing the gun at anyone? No. Running down the street, trying to get to those lights where the Bearcats are and law enforcement. He's not running off to the side to hide in the shadows. Blow to the head. First, knocking his hat off. What has Kyle Rittenhouse done? Nothing. Trying to get away from the mob. First strike from the mob. He's not an active shooter. He's gone 2 blocks, hasn't shot anybody. Coming in behind with a skateboard at the ready, Anthony Huber. That will be strike number 1. Remember in opening statements when Mr. Binger said, oh, something happened to his skateboard. He took a swing at him. Kyle blocked it with his arm in the enhanced photos. What does Mr. Huber do? He runs, grabs the skateboard, and comes in for more. He's on the ground. The most vulnerable position you can be in. And what do we have? We have Anthony Huber here, already picking up his skateboard. For this guy with the towel wrapped around his head, coming in on Kyle. Jump kick, man. Guy was hit him in the head. This individual. If we go forward just a little bit, see if it works this far. Nope. You saw this individual over here, who's now obstructed, come in on Kyle. Kyle points his firearm at him. He backs up. Kyle does not shoot. Jump kick man is leading with this foot. This foot is still on the ground. What direction is Kyle pointing right now? Watch what happens after jump kick man kicks him in the face. He's turned around. He's looking in that direction. Anthony Huber coming in with the skateboard. Watch what Anthony Huber does with the skateboard. Blow to the head. Coming in. Kyle's trying to get up. Anthony Huber's hand goes onto the gun. This is the fast one. The gun is pulled away from Kyle. Anthony Huber fires. When Anthony Huber fires, Gage Grosskowitz flinches, covers up, natural, uncontrollable reaction. Back. Get his ass. Now here's the slow motion. He's been hit in the head. The cap is off. Anthony Huber winds up with the full force of his body. From back here, he swings his skateboard at Kyle. Kyle senses it coming. He turns around and looks, blocks it with his arm. Doesn't turn around and shoot Anthony Huber as he's being attacked with what is a deadly weapon. A skateboard can cause death or great bodily harm, ladies and gentlemen. He doesn't do it. He continues to run a couple of steps before the blow to the head, and this has knocked him to the ground. He immediately changes direction, goes running for the skateboard. Want to get through this one. Okay. Now this is slow motion. Just as he's on the ground, he's set up, trying to get up. The individual to Kyle's left is the one who runs in. Kyle points the firearm. He backs off. He is not shot at. Backs up. He's now addressing the second nearest threat. Does not shoot. That individual right there in that picture is stopping. Jump kick man launches, contact, fire, turned around. In comes Anthony Huber. Blow to the head and neck. Now, I'm going to start it. You'll see Anthony Huber pull on his gun. And you'll see the butt of the gun separate from Kyle's body going in that direction, away from him. See the gun being pulled away from him? Shot. Mr. Huber goes down. Grossquits. Flinches, freezes. Stops. Hands up. No pull. Mr. Grossquits is standing like this, and all of a sudden you see him kick his foot back and launch forward. He loads his back foot going forward at Kyle with a loaded Glock handgun. Kyle sees it coming, gets within a couple of feet, he fires. If he's got his hands up and wants nothing to do with Kyle, like everybody else, just back away and you don't get shot. Mr. Grossquits decides he's going to take him out, and his only regret, as stated in the Facebook post, he didn't fire first and empty his clip into the kid. He's hit in the arm, he's shot at once, he's backing up, that's the last shot. I went through the quickness of the shots from the rock in the head to that fourth shot. He gets up. You still see this individual armed with a board or a 2x4 or a fence post. Doesn't shoot at him. This person he doesn't perceive as a danger. His hands are up. Doesn't shoot at him. Now as he wheels around, watch what this individual does. That was the end of it. Kyle turns around. He turns. That individual steps away from him. No more shots. Doesn't shoot randomly. Shots from behind him. Continues on his way, trying to turn himself into the police. People yelling to shoot him. He doesn't stop because it's not safe. Goes with his hands up to law enforcement.
Hey, he just shot them! Hey, dude right here just shot them! Dude right here just shot all of them down there! That dude just shot them right here! That dude right here!
continues on. Hands up. You hear the story about the pepper spray. Ladies and gentlemen, that's the case. There was no threatening behavior that started this. Mr. Rosenbaum was hell-bent on causing trouble that night. He did what he did, and he started this. There are tragic parts of it, but Kyle Rittenhouse's behavior was protected under the law of the state of Wisconsin, the law of self-defense. You've heard the instructions, and I'll end with this. You decide on count one. If you decide that his conduct was privileged under the use of self-defense, you don't go on to the lesser included. If it was privileged under self-defense, that affects count two. Both of the things that happened in scene one, as I read earlier, page 9 of the jury instructions. If his conduct was privileged as to Rosenbaum, it's privileged as to Mr. McGinnis. On to the next ones. At scene 2, ladies and gentlemen, there is no evidence whatsoever that he was an active shooter other than Mr. Binger calling him that. And there's no evidence that any of those other individuals who attacked him in the mob that night were attacking an active shooter. He wasn't shooting. And if they want to be the heroes and they want to beat somebody and do what they're going to do to them, they better be right. And they weren't. Kyle Rittenhouse shot Mr. Rosenbaum because he was attacking Kyle. Every person who was shot was attacking Kyle. One with a skateboard, one with his hands, one with his feet, one with a gun. Hands and feet can cause great bodily harm. I'm sure the state's going to get up and say, well, he didn't have great bodily harm, so it doesn't matter. That's not the standard. The standard is could cause great bodily harm. My client does not have to take a beating from the hands of this mob or the hands of Mr. Rosenbaum. And Mr. Rosenbaum might be little, but he was a pretty muscular guy. And some 30-some-year-old guy can take a 17-year-old kid 9 times till Tuesday. Ladies and gentlemen, it's a tough choice, but the evidence only leads to one conclusion. That is that Kyle Rittenhouse's conduct on August 25th was privileged based upon the actions of Mr. Rosenbaum and others. There are no winners in this case, but putting Kyle Rittenhouse down for something he was privileged to do will serve no legitimate purpose. I ask you to do this, do justice here under the law of the state of Wisconsin. Thank you very much.
Yay,
Thank you, Mr. Richards.
Now let's
Take about 10 minutes, and please don't talk about the case. Read, watch, or listen to any account.
Now they're going to give it back to the prosecutor. You know, he's going to talk for another hour or two. Especially now that the judge has said he can talk as long as he wants. That's going to suck. Here, let's see what the deals are. Want to go shopping? Shopping with Eddie for money we don't have. Well, I guess I do. I have it on my credit card. I don't know. What do you guys think? You guys think you made a good case? Pelican, $260. Wow. Look at the photography stuff. I can always use SD cards. I don't need a light meter. I could use a nice backpack. I got a lot of shit on sale. I don't know. Let's see what's going on in YouTube world. Let's see what else is on YouTube right now. Let's see if there's anything good. Let's see. 5 teen hospitalized after shooting near Colorado high school. Alex Jones loses last defamation lawsuit from. Wonder how much you got to pay for that. Oh, let's see this little.
It's not what they say sometimes. Sometimes it's what they don't say. In this case, what they don't want to say, but we all know is true,
What am I kidding
is,
right about?
oh, a patriotic song makes you conservative, makes you white supremacist.
Yeah.
So therefore, again,
What am I
okay,
kidding
the left
about?
hates America. It couldn't be clear. Like, well, it was played at Trump rallies. Barracuda was played at Sarah Palin rallies. Does that mean no one can listen to it? Do you think that it was created for Trump rallies? Or is it because it was a top #1 hit, perennial hit? I don't know for how long.
Yeah.
And it's a patriot song. And this guy, who is a judge who is serving his country, is probably a patriotic American. You want to say that any patriotic song is white supremacy? That's why the left wants a different flag. That's why the left wants a different anthem. They absolutely hate the United States of America, or they would not be mad that the guy's song is proud to be an American. This is something, I don't know if you've seen this yet, Dave. Gage ears. Guy who decided to invest in gauges in his ears. And this is why, I want to be really clear about this. This is why they want to try you in the court of public opinion. Because we saw Gage Grosskreutz when he was under oath. He had to answer, Kyle Rittenhouse only shot you once you came up on him, once you approached him, once you invaded his space and aimed your firearm at him. And he said, correct, to be clear.
Okay, what do you guys think?
Now he goes on CNN and he's gone on Good Morning America with that, I don't know, Michael Strand. I guess he's some kind of a football player. And what's hilarious, I recommend you go watch the entire interview because of the selective editing. Like, so what happened? I feared for my life. Dockers. You're like, what? What is that? Whoa. It's so clearly edited by his lawyer.
Hilarious.
But it's way better to try you in the court of public opinion. Why? Because you can just lie, unlike being under oath with the threat of perjury. So watch the difference. And the media's been trying to carry the water because they know that they're the losing end of Kyle Rittenhouse here. Watch Gage Grosskreutz, the difference between when he's been on the stand and his recent press tour. There you go.
So here you're allowed to say whatever you feel like you need to say. So you're saying that you actually you weren't pointing your gun at him. Is that what you're saying?
That's absolutely what I'm saying, yes.
It wasn't until you pointed your gun at him, advanced on him, with your gun, now your hands down, pointed at him, that he fired, right?
Correct. The only way that I could have sustained the injury that I have is if I had been shot with my arms up.
It wasn't until you pointed your gun at him, advanced on him, with your gun, now your hands down, pointed at him, that he fired, right?
Correct. Well, I think anytime you see your would-be murderer on the stand, it's emotional. And the defendant had, after murdering Anthony Huber.
The objection is sustained. That whether the death of Anthony Huber was caused by murder or not is for you jurors to decide and not for the witness.
Or Michael Strahan or Anderson Cooper, I guess, just as good.
Yeah, are you just going to go on their shows and retract everything you said?
Yeah, because I'd have a good mind to beat your ass and dip it in cheese.
Hey, it's something else, I tell you.
The cheese ass, it's a new thing.
You know, we talk about cheese head, but I think, young Gage, you might have your head in there is full of cheese inside there. I mean it as a pejorative, you know. Can we bring it? Let's just bring that up right now. The montage of how base this judge is. Whichever clip that's. I don't know which one it is.
Here, I got it.
I think.
Got it.
Clip 4. All right, bring this up. I've just loved this judge.
Chocolate syrup, cassava melon, and a Playboy model, Marley Renfro, were enlisted to create an iconic scene in this film.
It's trivia game.
What is Psycho? Heard of it? I was astonished when you began your examination by commenting on the defendant's post-arrest silence. That's basic law. It's been basic law in this country for 40 years, 50 years. I have no idea why you would do something like that. And it gives...
He's just smiling.
Well, I'll leave it at that.
The actions that I had talked about.
There it is.
Were done in bad faith.
My good faith feeling this morning after watching that testimony was you had left the door open a little bit, now we had something new, and I was going to probe it.
I don't believe you. There better not be another incident. I'll take the motion under advisement. To the extent that if there's no...
And again.
Pardon me?
That was before the
Don't
defense
get
testimony.
brazen with me. You knew very well. You know very well that an attorney can't go into these types of areas when the judge has already ruled without asking outside the presence of the jury to do so. So don't give me that. Anything else?
What time do you want to spend?
Let's hope for 1 o'clock. I don't know. Hope the Asian food isn't coming. Isn't on one of those boats in Long Beach Harbor. But let's aim for 1 o'clock.
And by the way, there was some anti-Asian defamation league representative like, this is deeply offensive.
Stop it.
There's nothing even remotely that could be. In other words, if that's offensive, let's just all start being incredibly racist again, I guess.
Right?
What's the point?
He basically said, I hope our food isn't on a container rotting away.
Yeah.
It's a Joe Biden joke.
It's a Joe Biden joke.
Yeah, it's like, come on, I don't understand why.
Are they mad that he said that or that he said Asian food?
I guess he said
Asian
Asian
food. It's
food.
racist to
What
eat
are we supposed to
Kung Pao
say?
chicken.
I mean, isn't it, if it's Asian?
Food from the Orient?
Yes.
I think it's
That's
the
a
combination.
rug, pal.
Yes.
Yeah.
I don't.
Can we go back to Gage's comment? He goes, the only way physiologically or whatever he said that I could receive that wound is if my hands were up. And I'm like, that would work, Gage, unless we didn't have like footage and pictures.
Yeah.
And you even commenting on the footage and pictures.
And I will say though, it was
Yeah,
just
your hand was up. The bullet moved it that way.
No, it blew my
And it just so happens to be happenstance that the part of the arm that Kyle shot made it so that he couldn't let go of the gun.
Yeah.
He's like, there are cameras. Like a turtle when it bites on your finger. Turns into a Jim Varney.
Yeah, just anus.
And Anderson Cooper just
Guns on his nose.
Anderson Cooper just is like, that's very interesting. I'm like, oh my, what world are we living in where this is this?
And
guy
by
can
the way,
say
they've
that?
been saying he's a white supremacist, the judge, just to be clear. It's like, oh, hey, thanks, leftists. This is it's not what they say sometimes. Sometimes it's what they don't say. In this case, what they don't want to say, but we all know is true, is, a patriotic song makes you conservative, makes you white supremacist.
Yeah.
So therefore, again, okay, the left hates America. It couldn't be clear, like, well, it was played at Trump rallies. Barracuda was played at Sarah Palin rallies. Does that mean no one can listen to it? Do you think that it was created for Trump rallies? Or is it because it was a top #1 hit, perennial hit, I don't know for how long, and it's a patriotic song, and this guy, who is a judge who is serving his country, is probably a patriotic American. You want to say that any patriotic song is white supremacy? That's why the left wants a different flag. That's why the left wants a different anthem. They absolutely hate the United States of America, or they would not be mad that the guy's song is proud to be an American. It would be a non-issue if they didn't revile people who are proud to be American. Are you getting the picture?
No offense, but it sounds like some fucking commie gobbledygook.
Offense taken.
That is perfectly said, though. I couldn't agree more.
Yeah, like if I see an American flag pin, I'm like, he's either president or he's a conservative.
Yeah. Oh, I always just think that's clearly a Nazi.
Yes.
That's what I go to.
Yeah.
He had a tie that was American flag tie. It had a bunch of little American flags. And I saw on Twitter people were like, "Oh, look at him. He's got an American flag. He's a white supremacist."
He seems like a guy just likes to have fun. He'd be like, hey, you like the tie? Hey, look, get on in there and see the flag. It's got all the, it squirts. See, I got you. I like to have a joke.
But don't grandpa energy. I love it.
Yeah, don't worry. It was just a gas bomb.
It was just a gas bomb.
I mean,
no, your upper lip in a few minutes, you might want to keep an eye on that because it's going to disappear. Sizzle, really.
Who's not gone down to the quick stop and lit a dumpster on fire? We've all been there.
Haven't we all done that?
Let he who has not throw the first Molotov cocktail.
Yeah.
Yes. Throw it back in the car like those, what do you call them? Guineas in a Bronx tale.
Yeah.
Yeah, I can say that. I'm part Dago.
I can't say that. I'm part WAP. Not to be confused with the gross vulgarities from that Megan horse.
Yeah.
Somebody call on the horse whisperer. Sure, get her to stop talking.
That'd be great if it was Megan Thee Stallion or whatever song on his phone. It's just booty music. It's like ass, titties, ass, and titties.
It's like, let me shut this off. Hold on.
Ass. He's like, I'm sorry. I apologize.
All right. Hey, by the way, do you remember, too, the reason Kyle Rittenhouse went down there? Keep in mind, Don Lemon was just saying, I don't know why, Kyle Rittenhouse went. What if Black Lives Matter went down and burned stuff? Do you remember when they covered all of those protests and the riots in Kenosha as mostly peaceful? Here's just a flashback.
What you are seeing, the common theme that ties all of this together, is an expression of anger and frustration over what people feel like has become an all too familiar story playing out in places from across the country, not just here in Kenosha, Wisconsin.
Those demonstrations in Kenosha have been mostly peaceful in recent days, and Jacob Blake's family is among those calling for nonviolence. Our Mola Lenghi is in Kenosha, and he spoke to people gearing up for the president's visit there.
Yes,
Mola,
let's go
good
now
morning
to
to you.
Walking
Very
Penis with
interested. What
Teeth.
are people saying?
Well, good morning, Tony. A lot of different views, as you can imagine, on the president's visit here to Kenosha today. You know, some folks we spoke with welcome the president and say that he can help heal and unify this community.
Last night was very peaceful. Tuesday night, not quite so peaceful, but it wasn't too bad. Monday night was our big night.
Big night.
And when I've talked about the deck being stacked against Kyle Rittenhouse, what are we talking about? The media? We're talking about big tech. We're talking about being booted from GoFundMe. We're talking about being booted, just my tweets in support of him on Facebook, let alone at the time being booted from just being able to post his side of the story, or anyone posting his side of the story. We have the president of the United States who compared him to a white supremacist, and we have the FBI who sat on footage and didn't allow it to be released until it really, really became an issue. Imagine being that kid. And also the DA is relatives with the mayor.
Yeah.
Well, imagine being that kid and still appearing innocent.
I know.
Yeah.
I know.
Even
That's
with all
a
of that
special-
stacked against you.
I mean,
Special
they
kind
just
of trial.
really must have nothing. You usually
No.
think, like, you know how they say you can indict a ham sandwich? You can try. Well, I guess Kyle is more Teflon than a ham sandwich. So here you go. The media labeled Kyle, just to be clear, when Don Lemon is talking about how this guy was being praised, the media and the president labeled Kyle Rittenhouse because they can never forget this when this kid is not guilty. They labeled him a white supremacist before they had any facts. Here you go.
I don't know enough to know whether that 17-year-old kid exactly what he did, but allegedly he's part of a militia coming out of the state of Illinois. Have you ever heard this president say one negative thing about white supremacists?
Yes.
A 17-year-old
Like three different things
Several times.
arguably a domestic terrorist, picked up a rifle, drove to a different state to shoot people.
You see a 17-year-old who was radicalized by Trumpism, took his AR-15 to Kenosha and became a killer.
He's sucking on a lemon head.
Not a hair on any of them.
17-year-old being held on suspicion of first-degree intentional homicide.
That is weird. I guess the sulfuric fires of hell singe everything off them.
Yeah, they do. It's strange. In advance.
Yeah, it's like Spawn.
He's like, I don't have all the information on this. I'm only the president.
Yeah, but I will put him in a campaign ad accusing him of being a white supremacist. I think that there obviously should be grounds for mistrial with prejudice. And what does that mean? Prejudice means they can't charge him again. Why? This jury is, every single attempt has been made to intimidate the jury, not only from the media, but you've seen it actually taking place directly right now. There is a conscious effort to try and intimidate them and make sure that they know, unless this kid fries, there will be riots in Kenosha. Not to mention the National Guard has been put on standby. That's a veiled message to be sent that look, it's in your hands if you want your city to burn, jurors. Protesters are outside the courthouse as well right now. Of course, almost like Don Lemon was saying, what if they were out there trying to take justice into their own hands? It's almost like that's happening from the people he supports outside of the Kenosha courthouse, which, by the way, they also tried to burn down back then. But they're doing it right now.
No justice! No peace! No justice! No peace! If we don't get it, shut it down! If we don't get it, shut it down! If we don't get it, shut it down!
Okay.
Huh. In
Shut
lockstep,
it down,
I guess. Huh, weird.
If we don't get it, shut it down.
Okay.
I like the OK sign poster. That
Yeah, it
a
was-
lot of work went into that.
It was pretty well done.
I think
I
it's pretty
appreciate
good.
that.
Here's also a man who claims to be George Floyd's nephew. I couldn't confirm nor deny, but seems like an asshole. So I don't know.
If I
bet he's the
Something about
nephew
shoes.
saying that they needed to take photos of the jury. This was out and publicly available. More intimidation.
I ain't even gonna name the people that I know that's up in the Kenosha trial. But there's cameras in there. There's definitely cameras up in there. And there's definitely people taking pictures of the juries and everything like that. We know what's going on. So we need the same results, man.
Tell me what you're gonna do when
Ain't
there's
nowhere
nowhere to
to
hide. It looks like Crazy Bone.
Does
It's
it?
not
Yeah,
even
it does.
racist.
Okay.
Yeah.
All right.
At all. It's not pull Crazy Bone.
Favorite band.
You're not a fan?
I'm out of touch with that.
See
culture.
you at the crossroads.
You won't be
Crossroads.
alone.
Is that where they play the fiddle?
No, it's not where he plays.
So
And
here's
I
another
miss
one.
my Uncle Charles, y'all.
Judge Schroeder actually said, too, this is well known, it was confirmed that people were, in fact, trying to film. So we have no justice, no peace. If we don't get it, shut it down. We have the National Guard right there on standby. We have allegedly George Floyd's nephew saying that we have people who are going to take pictures of the jurors. And then we actually have confirmed evidence that the jurors were being filmed where the judge had to shut it down. Here you go.
This morning at the pickup, there was someone there and was video recording the jury, which the officers approached the person and required him, her, I didn't even ask.
They.
To delete the video and return the phone to him. I've instructed that if it happens again, they're to take the phone.
Why aren't they arresting these people? I don't understand it.
Yeah.
If they are deliberately filming the jurors, it's a crime. Arrest them.
I'd like to say my point of this, where I thought, honestly, when this happened, because of all the media that was coming in, that he was a white supremacist who went there to shoot black people because that was the narrative. And I actually thought until the trial that the person who was shot was a black person. Now that I've watched the trial biasly, I do realize that I was completely misinformed.
Yeah.
And I would assume that he would be found innocent, and the only way he wouldn't would be through complete intimidation of the jury.
Well,
I think it takes a...
Or if you believe 2 pixels.
Rifle.
Yes.
Now, see, that takes a...
Powerful ammunition.
They're back.
And be chased by someone who is unarmed, who's smaller than him, who's shorter than him. And the first thing that you do to defend yourself is you plug 4 rounds into it. You shoot it from about 4 feet away, and not from 4 feet from Mr. Rittenhouse, 4 feet from the end of that gun. Your first shot immobilizes him. It shatters his hip. Then he's caused to go forward. And if you watch the videos, and we're going to watch a couple during this brief rebuttal, he crumples. He immediately crumples to the ground. No one is saying that Mr. Rosenbaum should have chased Mr. Rittenhouse. No one is saying that Mr. Rittenhouse did not have a right to defend himself. This case is about the right to use deadly force. And I want to talk about that standard because Attorney Richards, perhaps on accident, misstated it. He said that the standard is that it could cause death or great bodily harm to Mr. Rittenhouse, or that it is likely to cause death or great bodily harm to Mr. Rittenhouse. That is absolutely not what the standard is, and that is not what this trial is about. The standard is the defendant may intentionally use force which is intended or likely to cause death or great bodily harm, such as fire an AR-15, only if the defendant reasonably believed that the force used was necessary to prevent imminent death or great bodily harm to himself. Not, oh, if you repeatedly smash someone's face, it might lead to injury. Not, oh, this could have happened. Imminent death or great bodily harm. There's an old phrase that I could kill you with my bare hands. And there is literally no evidence that Mr. Rosenbaum was capable of that. Mr. Rittenhouse has size on him. We heard how he's a swimmer. We heard how he's a lifeguard. He's apparently in some kind of shape. Punch him in the face. Kick him in the testicles. Knee him in the face. Hit him with your gun. You don't just immediately get to shoot someone. And I don't care about provocation or any of that. Put that aside. It is not reasonable for any adult, for any person, for any 17-year-old male to not try and defend yourself first using other methods. Now you factor in provocation, the fact he had no right to retreat, or no ability to, or he had to retreat, and that he had to exhaust all methods. Clearly, if there is provocation, he's guilty. But even outside of provocation, why do you get to immediately just start shooting? As Mr. Binger said, he brought a gun to a fist fight. And he was too cowardly to use his own fist to fight his way out. He has to start shooting. And let's just say, theoretically, that we think, that the 12 of you think that it is reasonable to have used force, deadly force in that situation. Shoots once, takes out his hip. What does Mr. Rittenhouse have to do to avoid that? Well, maybe take one step back. And Mr. Rosenbaum is no threat. And Mr. Rittenhouse is responsible for every round of that gun. It did not have to happen as fast as Mr. Rittenhouse made it happen. He could have held back at one shot. He could have held back at two shots. The guy in the blue hoodie who came in to attempt to kick him didn't get 4 shots. Mr. Rosenbaum didn't get 4 shots. And Mr. Gross-Kreutz did not get 4 shots. The defendant has the ability to gauge what he is doing and to stop shooting. Mr. Richards talks about the threat being immobilized. What threat does someone 6 inches shorter than you that you've already shot in the hip and is already falling to the ground have? Why do you have to keep tracking him and shooting him and ending up with a kill shot in the back? Hit him, kick him, knee him, anything else. And Mr. Rosenbaum and Mr. Rittenhouse are alive. Because the defense talks about games that the prosecution has played. Let's talk about games. Let's talk about how Mr. Rittenhouse on that night did not tell Dominic Black, did not tell Joanne Fiedler, did not tell anyone about this grabbing of the gun. Didn't tell anyone about, oh, I was afraid they were use the gun against me. That is because once Mr. Rittenhouse and his team understood that an unarmed person chasing him and unarmed people chasing him later on would not be enough to meet this standard, to meet this privilege, they had to concoct a story. They had to concoct a story about how suddenly I was in great fear of this gun being used. And if that's the real reason, why didn't Jason Lukowski know that? Why didn't Dominic Black know that? Why didn't Joanne Fiedler know that? You darn well know if there was any evidence of the defendant saying that the night of, we would have heard about it. So yes, Mr. Rosenbaum is 4 feet or so from the barrel of the gun. He gets shot in the hip. He begins to crumple. Now remember, we did this demonstration when Dr. Kelly testified. This bullet entered here in the middle finger and came out here. This is how you grab something. I'm Mr. Rosenbaum trying to take this gun away. And this is how I'm going to do it, with my hand turned almost completely around and with apparently my fingers spread because these two don't get soot, which may mean they were on the gun or outside of the path, and the other ones do get soot. We're not talking about injuries to the palm here. We're not talking about injuries like this or any kind of grabbing injuries. We're talking about either something accidental or completely defensive to knock that gun away as he is being shot just before he is killed on the 3rd or 4th shot. Well, we're supposed to believe that Mr. Rosenbaum is Jason Bourne or John Wick or some other movie star hero who's capable of killing with his bare hands and deserved the treatment that he got from the defendant. Mr. Richards' closing was quite personal. If not taking shots personally, Mr. Binger, he was gloating and boasting about his client's kills. And he talked a lot about the Zeminskis. He knows darn well that the Zeminskis are charged by my office and they have a Fifth Amendment right. This is a criminal defense attorney.
Stop. Stop. Let me ask you to step out for a moment, would you?
Interesting. Come on. Let's hear some good stuff from the judge.